All right. Are we going to get started here? Are we streaming?
Yep, you're good.
All right. All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 2nd, 2023. We have 9 bills on the docket. We're going to start off with Senator Watson with Senate Bill 165. We'll then move to 164, Senate Bill 40, 22, 17, 51, 88, 37, and then we'll wrap up with Senator West at Senate Bill 27. Senator Watson, you're up. Senate Bill 165. Welcome back. You missed us. Before you start, can we get his mic lit up? Also, just for the committee and for the witnesses today, we have over 100 witnesses signed up. Each witness will get 2 minutes, so we're going to be strict on the time limitation. So if the witnesses could just please do your level best, and I'll do my level best. But with that, thank you. Senator Watson, you're up.
Thank you, Mr. Chairman. Good afternoon. Good afternoon, Judiciary Committee, JPR, and Senator Alonzo Washington. Welcome to the Dream Team here. No, you look good over there. I come here today requesting your support for Senate Bill 165, action to collect a private education loan. This bill was presented last session as well. But 165 bans the use of mass-produced documentation, also known as robo-signing, by requiring collectors to prove private student loan debts are valid when attempting to collect. This bill places the burden on creditors to certify that old debts are not barred by state statutes or limitations, preventing creditors from obtaining judgments against borrowers for time-barred debts. This protection will prevent creditors from obtaining court orders to garnish wages and seize assets to repay defaulted student loans that creditors cannot prove borrowers owe. Many across the state and this country struggle with student loan debt. Predatory lending serves as an anchor to people that seek to better their lives by way of education. For someone that is defaulted on their loan, having a creditor seize their assets or garnish their hard-earned wages when they're already struggling financially will only set them back further. In addition, being responsible for debt one is not actually obligated to pay back will only further hinder their ability. I wanted to bring the body's attention to the National Collegiate Student Loan Trust, NCSLT, was just one of these creditors owned more than 15,000 separate loans owned by Maryland borrowers, totaling more than $190 million. The federal government has ordered NCSLT to pay over $20 million for its deceptive acts in the past. So due to lack of documentation, companies lie to both borrowers and the courts about their ability to legally go after and get courts to garnish borrowers' wages. This bill puts the responsibility on the creditors simply to certify that the borrower actually owes the debt owed to them. This will ensure that private loan borrowers in Maryland do not fall victim to predatory or unsubstantiated lawsuits. With that, I urge a favorable report for Senate Bill 165.
All right, thank you, Senator Watson. Questions from the committee? All right, seeing none, we'll switch to the opposition panel. So is Mr. Peters here?
Yes, sir.
Come on up. Mr. Lagana?
Yes.
And is the next witness is virtual, so yes.
Good afternoon, Mr. Chair and members of the committee. My name is Scott Peters. I'm here on behalf of the Maryland D.C. Creditors Bar Association. I'm also an attorney that's practiced in and represented creditors for over 20 years. I have reviewed this bill, and at my first reading, at first blush, this bill sounded to me as if it was more of a roadblock legislation or a debt avoidance bill rather than simply regulation. As you know, the bill's 8 or 9 pages. It starts with the premise that all private student loan lending is bad, and I don't think that's the case. While I understand the need to provide proper documentation when pursuing a claim, I think we already have that legislation on our books, and that's Maryland Courts and Judicial Proceedings, Section 5-1203. This body has already codified minimum requirements. They've even created a signed consumer debt checklist complaint form that has been being used. I think the Rules Committee created it in 2012, and it was codified here in 2016. But this bill does a lot more. This bill actually has there's a list of 21 different items that a creditor must present as evidence in a trial before a court can enter judgment. This is changing the evidentiary standards for a contract action, which is basically what a student loan account would be. And it's adding, 21 different requirements. Included in that are 3 different affidavits, numerous statements, some of which are legal conclusions that may put an attorney in an uncomfortable situation. For all those reasons, I would oppose this bill and ask for an unfavorable report. And I'm open for any suggestions. I know 2 minutes was not enough, but I understand what you're up against today.
No, I appreciate it. It's never enough, but I appreciate it.
I could sit here for an hour, but I'll save you.
We'll hear from the entire panel first, and then we'll do questions.
Great.
That way
Great.
we can kind of field off each other.
Good afternoon, Chairman, committee members. Thank you for the opportunity to speak regarding Senate Bill 165. My name is Michael Lagana, and I'm here on behalf of the Receivables Management Association International, also known as RMAI. It's a nonprofit trade association representing over 600 businesses in the debt collection, debt purchasing, all in the secondary market. I've appeared before this committee 5 or 6 times over the last 10 years, most notably on the Purchase Debt Data and Documentations Bill, which was previously mentioned by Mr. Peters. Here was Senate Bill 771. Now it's Courts and Judicial Proceedings 5-1203. Required documentation for debt buyers, including the chain of title, if there was one, signed contracts, confirmation of the individual who the debt belonged to. Today, I'm here in opposition to Senate Bill 165, and while I believe the goal of the bill is laudable and bad actors should be removed from the space, we believe the data and documentation requirements in the aforementioned CJP 5-1203 are sufficient to prove the ownership of a student loan, the documentation that is required to prove the consumer signed an agreement, and a payment or transaction history that proves the debt. Mr. Peters has already talked about some of the onerous portions of this bill, and I won't add to that because of time. But this type of debt is remarkably similar to all the debt that was discussed in 5-1203. In 2016, all the stakeholders gathered together, and we discussed what had come out of the Rules Committee in 2012, and basically we codified what had come out of the Rules Committee. For these reasons, we stand opposed to this bill. Thank you.
All right, thank you very much. Questions from the committee? Senator West.
Thank you, Mr. Chair. As I'm reading through the bill, it goes on for many pages listing all the documents that need to be provided, or the information that needs to be provided. You all have said this is far too intrusive. Can you list specifically of the 21 different items, which ones, I guess by number, that you think fall or go beyond the pale?
Yes, and thank you for the question. Most of the 21, I'd say 15 of them are okay, and the others I refer to as head scratchers. I don't know why they're in there. And
What are those?
the head so number 1, Roman numeral 10. You must include a self-certification form, and again, this bill asks that you produce it as evidence in a trial, and it also asks that you provide these 21 items at first communication with the consumer. But it's asking for a self-certification form. From what I see, it's not in the definitions. I don't know what that form is. So right there, you're asking for something that's not defined. I don't know what it is. And if I fail to include that, I'm open to this, all these penalties for failing to comply. So that's number one.
Okay.
The second one is Roman numeral 12. So this is at first communication and to prove your case in court. They want you to provide, or this bill asks that you provide a record of all collection attempts in the previous 12 months. And I'm reading that and I'm saying, why? Why do I need to produce that to win a case in court or at the first communication with a particular consumer? I think it's Roman numeral 13, a statement as to whether or not the creditor is willing to negotiate the claim. I mean, as an attorney, I think that might even be an ethical problem. I'm suing for $5,000, but inside my complaint, I'm saying I'm suing for $5,000, but I'm not really looking for $5,000. So that's an issue. That's maybe an ethical problem. Next, we have, I think it's Roman numeral 14, and I will say I had to refresh my Roman numerals because this goes up to 21. Copy of all settlement communications in the last 12 months. Or a statement that the creditor has not tried to settle, I presumably in the last 12 months. And that's another, to me, a head scratcher. Why do I need to rehash prior settlement negotiations, especially when settlement negotiations are usually prohibited under the rules of evidence in your trial? So it's not relevant. It's not permissible in the trial. And then I think it's Roman numeral 19. They want an affidavit stating when the statute of limitations runs and that the suit is being filed within that time period. So, again, this is a legal conclusion. I mean, it seems simple, statute of limitations, but I'm not certain that that's always a statement I'm not comfortable saying in a lawsuit affirmatively, especially to someone whom I do not represent. There's a statement in there where the creditor has to state whether or not this claim is dischargeable in bankruptcy. Again, that's something that as an attorney, I'm not comfortable making that legal conclusion and stating it in a complaint or a first communication. I mean, dischargeability, I mean, there are very complicated cases in bankruptcy court over dischargeability. I don't think an attorney should be required to state that in a complaint. It could be adverse to your client's interest. I mean, those are the big ones.
Okay. Great. Thank you so much.
Thank you.
Thank you very much for being here. Just a couple of questions, and I have little knowledge in this area. I am aware of the predatory loans across the board and what those issues are. So a couple of minor questions and then one question that I'd like for you to answer. If we moved on with this bill, would you be okay with it? Most of what I see on here is information that you should already have, right? I mean, it's not like it will take you months to gather this. If you did all 21 of the items that you're against, most of it can be done in a day. Is that right?
In a day,
let's say a month.
Perhaps, and if I could follow up to that.
Yes.
So some of these debts are sold, they're assigned, and maybe they were assigned 6 months before it was sent to me as the attorney. Documentation issues are present because the individual that purchased it, or the entity, may not have all this 12 months, going back 12 months. So there could be, I know there would be issues. It would take a retooling.
Okay.
But
Got you.
yeah, that's what I say. I think this is more of a roadblock legislation because the basic requirements to prove your contract claim are already covered in courts and judicial proceedings 5-1203.
Thank you. Now, I'll get some advice on that, but my last question, because you've already answered the other two, if we were to amend out the 5 or 6 items, or at least come to some compromise with the bill's sponsor and others on the committee to amend out or find a compromise, some solution for the 5 or 6 items that you are opposed to, and we dealt with that, would you then be opposed to this bill?
As far as the items, I think when you take those 5 out, I think you're almost looking at a mirror image of what already exists. I guess that's our position is when you take out the things, and I think I call them head scratcher, things that don't make sense to me.
Okay.
I think you already have what exists. So why are we creating another level on top of what already exists.
Well, and I'm only answering because I know there are problems. The
Agreed.
problems are bigger than anything in this bill that seemingly you would have to do. The problems are bigger. We're trying to get a handle on it. Thank you for hearing me. Let me get some more information from both the opposition and the sponsor, hear the conversation of the committee, and see if I would submit some amendments to try and make it better without minimizing the reality of the problems that exist in this industry with this subject matter.
And
Thank
if I
you.
may respond quickly to that?
Yes.
I agree, there are bad actors. I mean, it's in the news. There are bad actors out there, and I think you should deal with bad actors. What this is doing, I think, is it's penalizing everyone who's not a bad actor. And I think, again, the requirements are already there, and the industry is already following the requirements to prove these cases. And it's worked. It's worked since 2012.
Thank you for hearing me out.
Thank you.
Thank you so
Thank you for
very
your
much.
question.
And thank you.
Thank you, Mr. Chair. I think I'll have two questions. One, you had mentioned earlier that you thought it might be an ethical issue with if someone was looking for, you said 5,000, or they asked for 5,000 and were looking for something. Could you talk about that?
Oh, it requires that, and again, remember, this requires these 21 items at first communication with the consumer, and these items are required to prove your case under the rules of evidence in court. So it requires a statement of whether or not my client would be willing to, I guess, renegotiate this debt. So the reason I say there's an ethical issue there is because I'm suing for $5,000. Just an example. I'm suing for $5,000, but within that complaint demanding $5,000, I'm also putting a complaint in there that says, well, it's really not $5,000. Maybe it's something less. And I just don't know that I feel comfortable making a claim in a lawsuit and then in the same lawsuit saying it's really not that. It's something different.
Okay.
And that's what leaves me a little uncomfortable.
Okay.
And I don't think we've ever had that requirement before in pleading, is plead a number and then say, well, it's not really that number. It's something less.
Okay, I think I got it. And secondly, you had said that you recognize that they're bad actors, but you don't want to punish good actors. But generally speaking, I think in lawmaking, when you have bad actors, you create a rule so that everybody acts accordingly. So how would you address the bad actors if it's not through this type of legislation?
I'm not certain that this legislation is going to stop the bad actors. And I guess that's where I'm coming from is.
So
is
how do we get those bad actors?
Well, I believe they're already being stopped. I mean, there's discussion about the state or the federal government coming down on private student loan lenders. So that machine's working. Like there's focus. So I think this is assuming that everyone's bad. And I don't know that complying with all of this makes the bad actors stop being bad, for lack of a better way to say that.
Thank you.
Thank you, Mr. Chairman. I apologize for going a second time, but I just was focusing on the last section of the bill, which would be codified at Section 5-1304 of the Courts and Judicial Proceedings article, and says that a person who suffers damage as a result of a failure to comply with the statute can get punitive damages, attorney's fees. First of all, how could a person suffer damage because documents aren't attached to a complaint filed in court? I don't understand that. Do you have any idea what kind of damage a person could suffer?
I don't. So when this is simply this is simply a bill based on what documentary evidence is to be required. Yeah, I struggle with that too. And as I indicated, I ran out of time before I even got to the penalty phase. Yeah, that's questionable. And then it's also giving the right to sue after a default judgment has been entered. And it says that they can have that default judgment vacated after the fact with no time frames. Like right now the courts have a 30-day completely discretionary period after a judgment's entered to decide whether or not they can vacate. After 30 days, Maryland case law establishes that it's only under cases of fraud, mistake, or irregularity, and the bar is much higher after 30 days. This penalty phase has no limit for what I can see. Like, it's saying someone could come back 10 years later and say, wait a minute, that default judgment from 10 years ago, we didn't have number Roman numeral 19 in there. So I want to file a lawsuit, say I'm damaged, I want this judgment vacated, I want all monies paid as a result of this judgment refunded, punitive damages, attorney's fees. I think that kind of flies into the sanctity of judgments. Like, Maryland has a sanctity of judgments. And at some point, judgments have to be final, and this opens the door forever. It seems like those judgments could be tacked forever.
Thank you for your answer.
Thank you.
All right, thank you very much. This has been helpful. Thank you.
Great. Thank you for your
all.
time.
All right, we have one more witness testifying virtually. Is Mr. Berkman-Breen. Are you ready to go?
Yes, I'm here, Chair. Can you hear me?
Yes, we can. Welcome. You're up.
Great. Thank you so much. So my name is Winston Berkman-Breen. I'm policy counsel with the Student Borrower Protection Center. We're a national policy organization focused on student loan debt. Prior to this role, I was the student loan ombudsperson for the state of New York and was the legal services attorney who regularly litigated student debt collection cases like the one addressed by SB 165. I've submitted written testimony, and attached to that written testimony is a report that a number of organizations issued about a year and a half ago about debt collection cases of this kind in Maryland, focused on one particular actor, the National Collegiate Student Loan Trusts, but it's representative of several other bad practices that emulate the sort of robo-signing that we saw a decade ago. I'm not going to give my prepared oral remarks just because I want to address some of what we've already heard. Namely, I do want to emphasize that there's a difference between bad actors and bad practices, and existing law clearly isn't sufficient because we still see rampant default judgments in communities of color across the state that are poorly documented, as the report discusses. On the last point that was just made about the right of action for folks who've been damaged, the fact that you have to show damage to benefit from the relief at the end of the bill is the gating mechanism, right? It's not a mere ministerial issue where you harmed because you have a judgment against you for a loan that you don't owe or that the creditor who got the judgment doesn't own. So there is an intentional gating mechanism there. I just generally, though, want to speak to the need for this law. As we've heard already, there are a lot of documents that are required to be filed. This is intentional, right? There is a bad practice of robo-signing and default judgment mills that take over state courts. And so this is not about getting one actor out. It's about making sure anyone who files and gets a judgment with the power of the state court behind it has documented their right to be there. These are sophisticated financial firms and debt collectors who can do this work relative to the individuals who might not even have an attorney. And again, I know my time is running up, so I'd be happy to talk more about the differences between existing law and the need for this bill. But I do want to emphasize the power difference between these companies who can do due diligence and the borrowers who get judgments against them.
Excellent. Thank you very much. We have a question from Senator Washington. Hold on, give it a second. Here you go.
Thank you, Mr. Chairman. I do have a quick question for you. Can you just speak to how this would eliminate any racial disparities that exist currently in predatory lending?
Thank you, Senator, for that question. So this is, I want to be clear, this is downstream from the lending, right? So we have to address with multi-pronged approach to the huge problem we have out here. But this will address mostly the disparity in enforcement of debts in courts that have been, again, documented robo-signing practices, bad practices, not necessarily bad actors. And one thing that it does that's really important and is different from the current law in Maryland, which has been shown to be insufficient for these communities, right, is that not only does it require the folks seeking a judgment to file these papers to show that they're the ones who should be in court anyway, it goes the further step of saying the court shouldn't even issue a default judgment unless all that documentation is there. The vast majority of folks don't make it to court because life is hard, and that's just the way that life works, and they get a default judgment. Folks who do make it most often don't have an attorney and can't represent themselves properly. So it's this buck stop of saying, file these papers, you should have them on hand if you're the right person to be here, and then the court will give you a judgment. And it shouldn't be that onerous because it's nothing beyond what might have to come out at trial. If there are technical fixes that need to be, discussed and debated, that's a whole other question. But I do think that part of the racial justice fix here is making sure that certain communities aren't disproportionately adversely affected by a system that's not working properly today. And thank you.
No, thank you. Is there another state that has this language and statute currently that uses this practice, that where you see it working, that dismantles any of the racial inequalities or racial disparities that exist?
Yes, thank you, Senator. So Colorado and Maine both enacted a nearly identical bill a couple of years ago in 2020, I believe, California in 2021, and then New Jersey and New York, to my knowledge, have pending legislation that would be very similar. Again, the theory just being file what you should have on hand anyway to show that you're the right person to be here, and then the court will issue a judgment. I should say from practice, a lot of these things on paper sound very simple or sound, well, why do you have to document it? It gets very messy, right? When you actually get in there and when someone says, wait, I've never heard of you. Like, you're not the one I took the loan out from. You're not the one I made payments to. How do I know if I settle with you here in court, someone else isn't going to come out of the woodwork and I have to sort of suddenly be accountable to two different people saying I owe them for the same thing? So that's really what this is trying to get down against. Let's make the system require that documentation so that individual borrowers don't have to pay a lawyer or have the sophistication themselves to ask all these questions.
Thank you.
All right, thank you, Senator Washington. Any additional questions from the committee? All right, thank you very much, Mr. Berkman-Breen. With that, that'll conclude the testimony in the hearing for Senate Bill 165. We'll now hear from Senator Watson again, with Senate Bill 164. Just for a little note, we are going to go a little bit out of order after Senator Watson. So after Senator Watson, we're going to have Senator Carter with Senate Bill 17. Just an FYI for the folks that are here. All right, Senator Watson, you're up.
Thank you, Mr. Chair, and good evening. Where are we at? Good afternoon again. Senator Watson, representing the 23rd District. Here to talk about Senate Bill 164, driver's license suspension for child support arrearages. I'm here urging the support of Senate Bill 164. This bill generally exempts an obligor whose income is at or below 300% of the federal poverty level from provisions requiring the Motor Vehicles Association to suspend the obligor's driver's license or privilege to drive in the state if the obligor is out of compliance with child support. You know, this bill is crucial because it prevents a person who has fallen behind on child support payments and they may not have the means for improving their situation, i.e. transportation to get to work, to remedy the situation from being hindered. If somebody is working and falls behind on child support, taking away the transportation is the last thing they need. It is completely counterproductive to helping them get back on track. Furthermore, this license suspension flag happens automatically with the Motor Vehicle Administration, giving the impacted person little chance to explain their situation. This is a bill I brought forth last session, and the thing that should be brought out is that the current law states that if an obligor is 60 days behind, they can have their driver's license lost. But if the obligor has a CDL, i.e. their commercial driver's license, they get 120 days. Now, what does that say? This bill has placed an importance on a person being able to go to work to remedy the situation if you have a CDL, but if you don't have a CDL, they take away that possibility. So this bill, by setting a baseline, 300% of the federal poverty level. The federal poverty level, 2023, is a little over $14,000. This means somebody has to be making over $41,000. Anyone making less than that, they would not have their driver's license taken away. So based on that, and I urge this committee to accept this recommendation to support. Thank you.
Members of the committee, my name is Christopher Dews, and I'm speaking on, can y'all hear me? Yes, right? Speaking on behalf of the Job Opportunities Task Force, I do want to highlight that this piece of legislation in its current form did pass out of this very committee and out of the floor, 46-0, a unanimous vote. So, you know, just got to get Senator Washington up to speed, and then I think we're going to be good to go this year as well. 50% of Marylanders drive to another county for employment. That was according to the U.S. Census Bureau. And only 9% of the jobs in the Baltimore region can be reached within 1 hour, one way, by public transit. So when you take away an individual's license, you are disproportionately crippling their ability to secure employment. And this is something that the committee knows very well, because in 2020, you guys also passed legislation to eliminate license suspensions entirely for the inability to pay traffic fines and fees. This is something that the Attorney General's office has worked on, and I believe the Attorney General's office is also working in support of this bill as well. So I just want to highlight that. I do also want to highlight that the Department of Human Services is favorable with amendments on this bill. Compared to last year, it was just information. So we're in conversations with them as well to ensure that this is a negotiation and proper passage. But I just wanted to highlight some numbers before I go ahead and take my seat here. And that is to say that 50% of non-custodial parents in the state child support program were employed last decade, and only 43% of those individuals earned minimum wages but owed over $10,000 in unpaid arrearages. This is a debt that they'll never be able to pay back. And I want to highlight that in a 2019 Able Foundation report, that 42% of individuals who had their licenses suspended for child support lost jobs as a result of the suspension, and 45% of those who lost jobs could not find another job, and 88% of those that were able to find another job reported a decrease in income. So I just say that to say you can still garnish the wages, you can still arrest for contempt of support, but all we are simply saying is don't take the license because it's detrimental to employment. Thank you for your time. We urge a favorable report. Mr. Thompson.
Thank you, Mr. Dews. Thank you, panel, for seeing us today. First of all, I also want to thank my guys here that have come out, young men that have been incarcerated, some for over 20 years. So my name is Aaron Thompson, Chief Executive of HTP Home, running a nonprofit. And what we do is train these young men to do work. A lot of them are carpentry skills, plumbing, things that they're able to get. The great thing about it is we actually guarantee them a job once they finish our course. We teach them life skills. We teach them all type of social skills. Something comes to mind just a couple of months ago. These young men learned to give back. They raised $1,000 within themselves, went to Frederick Douglass High School in Baltimore, which is, I think, the second oldest, I think, African-American school in the country, donated that $1,000 to that school. And the first thing I'm like, where's the media? These are the things that need to be said. These men are making a purpose to come out every day. They have changed their lives. They're doing everything they can to change their lives. And let me just be clear about this. I don't give a hand out. I just give a hand up. So supporting this act and helping them to expunge their records and things like that, it really helps us, people like the nonprofits that are trying to help them continue to grow. And I think that that's one of the most important things. Anything as far as the licenses as well, they need that also. And anything that you guys can do, I know they understand. I just want you guys to know that they are really trying to make a difference in their life. Thank you. Okay.
Okay. Hello, how y'all doing? My name is Brandon Riddick. Basically, what I'm here to talk about is I was recently incarcerated, and my daughter, she was with her mom, and she got taken away by DSS, and they actually took my license, and they had actually kept billing me for as child support while I was incarcerated, and I lost my job, like everything, just because they took my license. But I had got custody of my daughter back, and I was paying my arrears off, and my license still suspended, and and like I said, I have custody of my daughter, and her mom is still receiving all these benefits and stuff, but she had no reason. I mean, well, they have no reason to keep my license suspended. So I'm just speaking on behalf of everybody as far as that. That's really about it.
All right. All right, thank you all very much for your testimony. Questions from the, oh, yep, go ahead.
Oh, I'm sorry.
You're up.
Yes, okay. Expert witness, hold on. You got it, just kidding. Okay, should I start? All right. Good afternoon, Chair and members of the committee. My name is Stacy Bensky, and I'm an attorney at Maryland Legal Aid. So you might read Family Law Article 10-119 on its face and think, why another exception? You might also read that coupled with DHS's written testimony and think this law works perfectly well as is. So on paper, yes, the law already has enumerated exceptions to stop license suspension if it impedes employment. Or if the parent is disabled, or if the parent is paying on their arrearage balance per a payment agreement. For example, like Mr. Redding right here, who's being garnished, but his license is still suspended. What DHS's testimony does not tell you is that the Maryland Child Support Agency uses an automated license suspension system that operates as if those exceptions in the statute do not exist. So even when parents fit squarely into an enumerated exception in the current law, there's currently no mechanism in the automated system to remove them, to remove someone like Mr. Redding here, from that pool of people who can be selected for license suspension, and they can be selected each month over and over again. The only way to remove them from that pool of people is if their arrearage balance gets down to less than 2 months of arrears. Well, if you were incarcerated like Mr. Redding here and your arrears continued to accrue, it's going to take a very long time to get your arrearage balance down to less than 2 months of arrears. So my clients are often repeatedly their licenses are repeatedly suspended, so I'll have them reinstated, and then a few months later, I'll get a call, Ms. Bensky, my license is suspended again. And these are for people who fit into these exceptions, people who need their license for employment, and for people who are paying towards their arrears through an earnings withholding order, through a court order, which are exceptions already in the law. So, 10-119 also says the MVA may issue work-restricted licenses, but in practice, this never happens. Essentially, I know that I'm almost out of time here, but I just want to say that the automated system violates the current statute and disproportionately harms low-income families, punishes people for being poor, and criminalizes poverty. This could all be easily remedied by suspending driver's licenses only when appropriate, which is what the controlling federal law says. It says state agencies have the authority to suspend licenses in appropriate cases to increase the effectiveness of the program, but license suspensions are not appropriate or effective for families who are living in poverty. It also
Ms. Bensky, sorry, your time is up.
Okay, and last, I just want to urge a favorable report, and we hope that the agency would implement it correctly, because it would help break the cycle of poverty. And thank you so much.
Excellent, thank you very much. Questions from the committee for this panel? Senator Sidnor.
I had just wanted to get clarification from legal aid. You had noted DHS's testimony. Am I hearing you correctly? Because they have about 6 proposed amendments in their testimony. Are you saying that these amendments that they're suggesting are not necessary?
There. Oh, yeah, sure. So the amendments that they're proposing, basically, they kill the bill, is what they do. So Amendment 2, what they propose is to make this exception, which accepts parents who are below 300% below the poverty level. it puts them in the exact same category that I was explaining before, and that their testimony says that there already are exceptions in the current law, in the Maryland Code Family Law Article 10-119, for if you need your license for employment, if you're disabled, or if you're paying on your arrears through an earnings withholding order. But the issue is implementing it. And so what we would hope is that this law would actually be implemented differently. Those exceptions were added into the law, I believe, in 2004. The agency never implemented it. All of my clients who come to legal aid, which is every single week, we have intake, we have walk-in intake, we have a hotline, we have a lawyer in the library. I'm all over the state, and we have people that come in every single week with their licenses suspended, that if the statute was being followed, they never should have been suspended in the first place. So what they're trying to do with that amendment number 2,
So
is.
I take it with the ones that are suspended, then you win those cases and. they get
Well,
thrown
we
out.
get them reinstated. What happens is basically we'll get their license reinstated, but it's only temporary because they're still in that, if they still owe more than 2 months worth of, or not even more than, but 2 months or more of arrears, they're in that pool of people. They have an automated system. So every month they suspend licenses. So it's over and over and over again. So that's why I say I have the same clients that come back to me. I've had their license reinstated. It's suspended again. I mean, I have guys that are, that they need their license to work. They get sent home because they don't even know their license is suspended. A lot of my
Let me
clients.
ask you this, we have a new administration, and I know what the governor's his policy is, and I believe his agencies are going to work in accordance with his policies. Have you considered also sending a letter about the implementation, if that's what the issue is, rather than the law?
You said, have we considered doing that?
Right.
I mean, certainly we've tried working with the agency. Maryland Legal Aid has, but
Right, no, but this is a new day.
certainly that is something that I hope so. We
Okay.
also have a new executive at Legal Aid. So, I mean, there's lots of things, hopefully, but essentially with that amendment number 2, it makes it pointless,
Thank you.
essentially, unfortunately,
Appreciate it.
at least for my low-income clients.
Thank you.
Thank you.
Additional questions from the committee? All right, thank you very much. Thank you to the panel. We'll now hear from Ms. Hilliard. You're here. Ms. Hanson. Ms. Burton. And then that's it. And the rest are virtual. So come on up.
Good afternoon, Chair, Vice Chair, members of the committee. I'm mostly up here to just say the Office of the Public Defender and Maryland Legal Aid frequently have the same clients with the same interaction between cycles of poverty and cycles of interactions with the criminal legal system. So we know how important it is, and we thank Senator Watson for introducing the bill, and we appreciate the Maryland Legal Aid testimony that's been submitted. We urge a favorable report, and we want to just re-emphasize the impact that unnecessary suspension or creating hardship to accesses to licenses can really cause, especially for people who already may have interactions with the criminal legal system. Thank you.
All right, so before we switch to our virtual panelist, Ms. Angel, come on up.
Thank you, Mr. Chairman, committee members. Great to see you all. I was notified about this bill at about midnight last night from a mother group. So I'm speaking to you from the point of what we like to call the custodial parents. I don't want to just say moms because fathers are also custodial parents. There's a deep concern about this bill in the sense that while I never want to encourage or create interactions with the carceral system for anyone. But the question becomes, for the custodial parents, regardless of their income, this is the only enforcement mechanism that they have to help ensure that child support comes in. There is a provision, and so I do support with amendments. The way the law is currently written, it says may provide a restricted license. I do believe that it should be shall provide a restricted license. That way that no one's license is outright suspended, but we do automatically give them the work restriction, which is inherently what they are saying they need to go to work. But for child support enforcement agencies, this in many cases is the only way they are able to get a response from certain non-custodial parents or to have for them to reply, because otherwise there actually is no incentive for them to respond to agency outreach, for them to submit paperwork, or for them to have, honestly, any response on their obligations. I understand there is the 300% income limitation, but that is actually, I think at last calculation, is about $41,000. That's actually the average income for all of the state of Maryland. So essentially, this would opt out at 300% almost everyone. And we could get into kind of what in other non-custodial or custodial parents were not able to attend because, like I said, we were just made aware of this. But, you know, there are a lot of cases where all that is reported to child support is W-2s. There's many instances where there's income that's unreported. So thank you for hearing me. I do believe that there is a pathway forward, but wanted to make you aware of those issues. Thank you.
And good to see you, Delegate Angel.
Good to see you.
Quick question. It was mentioned earlier, though, that you would have the option of garnishment. Is there something wrong with that particular option, that you would have to go and take someone's license so that they couldn't possibly get to work?
Well, as I said, I don't I only support restriction of licenses, not striking the provision. Garnishment only works, one, if you're able to find out that they're working. And the restriction of license, once it happens, oftentimes that produces a court date where you finally get a respondent to come into court, and then that's the only time where you're able to actually get their income. The way that the garnishment system works, and someone from Office of Child Support may also be able to clarify, is that honestly they have a computer system that just sends out to see if a Social Security number is reporting income. As you and I well know, there are many ways to counteract that system. And so garnishment, and even garnishment, it can happen, I'll say personally, I don't like speaking on my personal, but where if you constantly change jobs, the garnishment never catches up. The sweep happens, they check for a Social Security number, they get a hit, they then have to issue the garnishment. That usually takes, then they have 30 days to respond to the garnishment. And it's honestly about a 90-day process, and many people can switch jobs within that time frame. So garnishment alone has often not been able to produce the results and to have people respond. Thank you, sir.
All right, thank you very much. Always good to see you. Yeah, all right, with that, we'll switch over to our virtual panelist, and we'll hear from sir. What is your name, sir?
Hi, I'm DeAndre Wiggins.
Were you signed up for this bill?
Yes.
DeAndre Wiggins. I don't have. Do you have? I'm sorry. Hold on. Let's go to our virtual panelist real quick, and then we'll come right back. Mr. Hennigan, you're up. Welcome. Mr. Hennigan, you have to.
Yes.
There you go.
I did. Yeah, I got it. My name's John Hennigan. I'm a senior judge assigned to the oversee contempts for failure to pay child support in Baltimore County. In addition, I run a family employment support program, which is a program that I transfer potential individuals who are in contempt to have them go through the process of checking their resumes, getting barriers removed, and getting them employed. And one of the barriers that is hindered is license revocation or suspension. I support this bill because, one, the people I deal with are all impoverished because they're all unemployed. They have no income, they have no assets, and they don't have two nickels to rub together. They live in areas where bus access can't get them to the jobs. For instance, somebody living in West Baltimore, to where I might have them go to Amazon in Sparrows Point, get employed. Can't really get over there, although Amazon has done some nice things and is setting up some shuttle buses in certain areas. I had a lady in court the other day who lived in Baltimore City and had a job at McDonald's, York Road in Towson, and just couldn't get there. If they have their license, then I don't have to look for jobs for them within walking distance of their home. The other issue is that before they get to me, and I might sign an order to reinstate their license, they go through a magistrate, and you have months and months and months of a person whose employment is difficult because they have no license.
All right.
I assume, yeah, that's my time.
Excellent. Yeah. Well, it's not your time for everything, but for this it is.
Yeah, thank you for that.
Yeah.
Although since I'm a senior judge, it seems like my time is coming quicker than I anticipated.
Oh, no, well, we hope not. We hope not. God bless you. Thank you very much for your testimony. And thank you. Seeing no questions from the committee, thank you very much. Thank you.
Well, okay, and thank you, Senator Watson, for presenting this bill, because I think it will assist me greatly in achieving what I'm trying to do, which is in the best interest of the children and not punish people.
Excellent. Thank you.
Okay.
All right. So we'll come back to Mr. Wiggins, and then we'll wrap up with our virtual panelists. So, sir.
Thank you. Thank you. I'll be very brief. Interestingly, the judge actually spoke some of my sentiments. I am DeAndre Wiggins. I'm here to obviously support this bill. And I work with folks and have worked with folks from all over the state who are job seekers, currently through Job Opportunities Task Force. And one of the top reasons that we see, that I've seen over the past 2 decades, in terms of arrearage accrual for those who have child support cases, is a lack of employment.
So we're getting some feedback from our folks in the Zoom room, so we'll give you your time back, but
Okay,
please go ahead.
Yep.
Thank you very
So
much.
the top reason, I should say, for not being able to pay is unemployment, right? Obviously. And so because we are in the business of barrier removal, or at least mitigation of barriers, we certainly would not want to add an often insurmountable barrier to an unemployed, low to moderate income individual who is clearly seeking employment. Again, the reason for the arrearage accrual is unemployment. It's not. It really has absolutely nothing to do with driver's license and so. And so to say that driver's license suspension is the reason that arrears are now being paid or will be paid in the future is completely fallacious. There can't be a correlation drawn between those two factors. We like to encourage everyone to support and not penalize to this extent folks who are simply impoverished and need support around finding employment going forward. That's what it's really all about. And as the judge just said a moment ago, in the best interest of children, obviously, in order to get a child support case going, there has to be children involved. And in the best interest of children, we want folks employed, right? Not having to dig out from under yet another huge barrier. Thank you.
See no questions from the committee. We'll go back to our virtual panelists. And so is Mr. Williams in the queue? Mr. Williams, if you could turn your video on, we are ready for your testimony. All right, let's move on to Mr. Quarles.
He's
Not in here? Okay. All right. So, Mr. Williams, we're going to give you one more shot here. Okay. All right, with that, that'll conclude the testimony and the hearing for Senate Bill 164. Thank you, Senator Watson. We'll now move on to Senator Carter with Senate Bill 17. Senator Carter, you're up.
Good afternoon, Chairman Smith, Vice Chair Waldstoker, and all the members of our wonderful JPR committee. I'd like to bring up my panel, which is already present, is State's Attorney Aisha Braveboy. I've also got Judge Phil Karim from the Maryland Alliance for Justice, if he's here, Mary Denise Davis from the Office of the Public Defender, and Christopher Deuce from the Job Opportunities Task Force. Formally, or representing, representing the Job Opportunities Task Force. Members of the committee, and I want to take a moment of personal privilege. I'm going to basically read some data that solidifies the purpose of this bill and why it's a good bill. But I think it's important to talk about why this bill matters so much to me and why I think it's the absolute right policy moving forward for Maryland. When I was much younger woman, 20 years ago in 2003, I was first elected to the House of Delegates. And at that time, I had spent some years initially as an assistant public defender, and then I was doing private practice criminal defense. And I felt we should do two things when it came to the laws of expungement. I thought we should expunge non-convictions, and I thought we should expunge non-convictions when they are part of what's called a unit of charges, and I thought that we should expunge non-convictions when they were eligible for expungement, but a person later obtained a conviction and then was barred from doing it. I thought these were very common sense things, and I went about the business of putting them in for a few years in 2003, 4, 5, 6, 7. They never went anywhere, and finally in 2016, the subsequent conviction one was passed, that we passed that law. We are still struggling. We are still struggling with allowing people to fully expunge non-convictions when they're part of a unit of charges. And from that time, when expungement was not as readily embraced in this body as it is today, and we've come so far, we've passed so many laws, we now allow for the expungement of certain convictions. We allow for, after a waiting period, certain things that are even felonies. It's pretty amazing. We've come an amazing way in 20 years. But I believe at this point, 20 years in to this journey of trying to help people restore their lives and overcome a taint of criminality, that the right policy is to stop setting up these rather arbitrary timeframes and conditions on when and when not a person should be able to be eligible for an expungement. It makes common sense. You know, I don't believe that we're doing it in the smartest way, because we're only looking at a circumstance. We're looking at, has it been 3 years since this crime? Has it been 7 years since this conviction? Has it been 15 years since that conviction? What we ought to be doing is looking at the human being. Is this person a person who is worthy of expungement of whatever this was on their record? And is this expungement going to help this person overcome this obstacle, the taint of criminality, and live a better and flourishing life and contribute to society? And so this bill, in my opinion, is probably 20, 30, 40 years overdue, because it's the common sense bill that we should have been looking at in the beginning. An expungement for good cause. So under this bill, we wouldn't look at conviction, non-conviction. We wouldn't look at how many years it's been. We would simply allow a person to file a petition to a court for an expungement, and the court would consider all of the facts and circumstances as to why this expungement, this person is deserving of an expungement, and why it would help, why it would be necessary, and for good cause, a court could grant an expungement. There is an error in the drafting of the bill, and the bill, as you have before you now, and I noticed it only this morning, says that person would be able to file this petition any circumstance, anytime. So that's not correct. A person that has a conviction, and I've already requested this amendment, would be able to file a petition for an expungement upon the full completion of their sentence, any period of incarceration, parole, or probation. That's what the bill should read, and that's what the bill that I would support. And so with that, I won't be too much longer, because I have an illustrious panel of experts here, and I know you want to hear from them. But I do have some background data I want to share. And what I really want to emphasize, though, is we already know the domino effect of conviction, no employment, no housing, no loans, no money, and the evil cycle that happens to people that they can never get back on their feet. But what we don't talk about enough is the stain on a person's dignity when all of that happens. The fact that they lose their confidence to even navigate the world because they're told you're not worthy of a job. You're not worthy of housing. You're not worthy of any money, any loans from a bank. You're not worthy of a license. And that sends a message to the person that they ought to just give up. And that's why many of them do. And that's also why we have a great amount of recidivism. And so with that, this brief data I want to share. Approximately 25% of working age Marylanders have a criminal record. In addition, each year, approximately 15,000 are released from state prisons and struggle to secure employment or a place to live. Demographically, 71% of Maryland's prison population is black, the highest in the nation, and 1 out of 3 Marylanders returning from incarceration resides in Baltimore City. The Department of Justice has documented high recidivism rates among citizens returning to society, with half of all returning citizens reoffending within 3 years and 60% reoffending within 5 years. One of the primary drivers of this high recidivism is the inability to secure employment. More than 60% of formerly incarcerated persons remain unemployed 1 year after release. This is mainly because more than 85% of employers perform criminal record background checks on job applicants. This leaves many citizens who completely paid their debt to society with a criminal record and unable to obtain gainful employment. A 2015 Manhattan Institute study revealed that employment, especially within the first 6 months of release, drastically lowers the likelihood of recidivism for nonviolent offenders. Maryland has a variety of laws in combination prevent Marylanders from accessing expungement services needed to reintegrate into society. First, Maryland has much longer waiting periods for expungement than several other states. I know that Vice Chair Waldstreicher has a bill that would address that later, but I think that this catch-all is needed as well. Under Maryland Criminal Procedure Act, an individual must wait 10 years before becoming eligible to expunge most nonviolent misdemeanor convictions and 15 years for common law battery, second-degree assault, nonviolent felonies. The eligibility periods does not begin until after completion of the entire sentence, parole, probation, drug treatment, and/or any other mandatory requirements or supervision. In most instances, the waiting period is longer than the actual sentence, thereby creating major barriers to education, employment, housing, public assistance, occupational licensing, and much more. According to a recent poll from the Collateral Consequences Resource Center, 42 states have shorter waiting periods for misdemeanor expungement, including Texas, Alabama, Mississippi, and Utah. Additionally, under the Criminal Procedure Act article, charges that arise from the same incident, transaction, or set of facts are considered to be a unit of charges. That all famous unit of charges that this body has been unable to grapple with effectively to help our Marylanders out. If a person is not entitled to an expungement of one charge in a conviction or a conviction within a unit, the person is not entitled to expungement of any other charges within that unit. This prevents charges that would be eligible for expungement from being actually expunged. And this is what I referenced when I started, that in 2003, you can check the record, I came into the General Assembly saying, we got to fix this problem. And it's still not fixed, unfortunately, and many, many Marylanders are negatively impacted by it. Lastly, if an individual violates parole or probation or manages to have a subsequent conviction during the waiting period, it is virtually impossible to expunge the original charge. Many criminal law attorneys, some judges decree that their inability to dispense justice is due to the complex web of laws blocking the expungement process. A study by the National Institute of Justice examined more than 80,000 criminal records and found that there is a point in time when an individual with a criminal record is at no greater risk of committing another crime than individuals of the same age that have never committed any crime. Without an expungement, reintegration into society is extremely difficult, and so I believe it's our obligation to honestly consider this as a viable option moving forward. Thank you.
All right, yep.
Thank you. Thank you so much, Mr. Chair, Mr. Vice Chair, and esteemed members of the Judicial Proceedings Committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, and I'm here today to express strong support and urge a favorable report for Senate Bill 17. You know, as State's Attorney, so much of what we do is hold people accountable for their wrongdoings, but because of the work of this committee and your counterpart in the House, we've been able to expand expungement opportunities to thousands of Marylanders. And so my office engages in hosting expungement fairs, and it is a real opportunity for my prosecutors to really get to meet and see the people oftentimes behind the convictions that we have. And so when we're able to help someone get an expungement, it's an exciting feeling. The bad part is when we tell someone, well, you have to wait another year, or you've got 2 or 3 more years. And we know that they're good people, they have families, they're just trying to support themselves. But there's nothing that we can do because we are bound by the law. So I think this bill gives courts the discretion like they have when they are sentencing an individual. When a court sentences an individual, they look at the pre-sentencing report and they make a decision weighing the factors involved in that case, the seriousness of the offense, of course, but also the human being behind it, the age of that individual, their criminal history, and various other factors, whether there was trauma, just so many other factors that the court gets to consider, because I think we understand in our justice system there has to be humanity. And I think this bill gives courts the same type of discretion in determining whether or not someone should be eligible early for expungement that we give courts when determining what the appropriate sentence for that individual is. And for those reasons, we urge, or I urge, certainly a favorable report of this bill. I don't believe that this will be something that will be negative to our communities, because again, a judicial officer will be making a determination based on all of the factors at play. And so I thank you so much for your time and look forward to any questions you might have.
Thank you, Mr. Chairman. I did want to welcome our esteemed State's Attorney from Prince George's County, the county from whence I hail, and now Senator Alonzo Washington. You have represented us well, and we've worked together down through the years from our days in the House until now on this exact issue, expungement and giving people a second chance. I want to welcome you again to our committee, and thank you for allowing me to do that, Mr. Chairman. Thank you.
Excellent. Prince George is strong. All right. All right. There you go. Welcome.
Hello. My name is Mary Denise Davis. I'm with the Office of the Public Defender, and we're here today to show our support of Senate Bill 17. I will say I absolutely love this bill, love it. The reason why is being a practitioner that has filed expungements for individuals, I can't tell you how many times I've heard a judge say, I would love to help your client, but my hands are tied. And this bill makes sense, as Senator Carter said, because it says good cause can be found once the person completes their sentence. I also want to point out that there was a recent appellate case, the expungement petition in Vincent S. that basically said the good cause that is listed in 10-105 section of the expungement is not extended to 10-110. So that's why I think it's vital that we put that language in there, because it's not there now, and the appellate court said they could not grant an expungement on good cause under 110. The other thing I will say is, just because there's good cause doesn't mean the expungement's going to be granted. The petition has to be filed. The state's attorney can file the objection. The judge is the one that's going to make the final decision. And that judge in the expungement statute has to consider in the interests of justice. So I think it's important to let these cases go in front of a judge to determine what should be done instead of just relying on 3 years, 5 years, 15 years. There should be an exception for good cause once the person finishes their sentence. The other thing I will say is there's also another appellate court that came out, and I do apologize because I'm not sure how to pronounce the individual's last name, but it's In Re Abishka, which basically the appellate court there said, because there's this language in the expungement statute that says satisfactory completion of probation, the person had violated his probation, got 4 days, and he wasn't able to get that expunged, even though 15 years had gone by. So to me, what the good cause will allow, it will allow that judge to say, this is a period, this is an individual. I'm going to judge them today. I'm going to see what they've done in the period of these waiting periods, if there's not good cause, but I'm going, like, if they didn't follow right away. But anyway, the good cause, because it seems kind of illogical to say, and kind of defeats the purpose of the expungement statute, to say you violated your probation 10 years ago, and even though you're doing everything you need to do now, I need to finish. So, I think you know where I'm going with that one. But anyway, I will say,
conclusion of the testimony.
I will say, I hope you support this bill, and thank you.
I appreciate it. Thank you very much.
I guess I'll slide up to Judge Kuro.
Judge.
Yeah, let's let the judge go.
Chairman Smith, Senators, I'm speaking today for Maryland Alliance for Justice Reform, not officially for the Maryland Judiciary, and I'm going to be very brief. I will have more to say to you about SB 37, but as to SB 17, I just want to assure you that judges looking at expungement petitions can use their discretion carefully in the interest of the public and of public safety. But there are times where that discretion is taken away simply by the lengthy waiting periods required by the statute. There are situations where a petitioner may come with an opportunity for employment, an opportunity for an educational program, an opportunity for a professional license, which would help him or her to be a more responsible, self-supporting, law-abiding citizen. The statute prevents the court from saying yes currently. The state's attorney would be present in these cases, would have the opportunity to present any countervailing considerations. But typically, if one is the state's attorney, one wants to see a defendant get a better job, get a better employment opportunity, have the ability to rehabilitate himself, and SB 17 would permit this. So I encourage you to give a favorable support to favorable vote in support of SB 17, and be happy to respond to any questions.
Thank you to the panelists. Questions from the committee? Oh, sorry. Oh, Mr. Dews, my apologies.
Still love you.
Welcome.
Yep. Well, actually, I'm going to be relatively brief because the wonderful Senator Carter laid out the case very strongly, as well as State's Attorney Braveboy. So I'm just going to say we think it's a great bill. And I thank you all for your time. No, seriously though. No, but I just wanted to highlight one of the things that Senator Carter did mention, as well as State's Attorney Braveboy, the actual barriers that do come from this. You've probably heard this said on multiple occasions, but housing, financial aid, access to education, public assistance, licensing, and employment. You've heard about the employment aspect, but just to highlight some numbers from the Criminalization of Poverty report that was released in 2018, a past criminal conviction of any sort reduces job offers by 50%. 4 out of 5 landlords perform routine background checks on every single individual that's going to come applying for housing with them. Subsidized housing can be denied, of course, due to prior convictions. 3 out of 5 colleges use a background check to screen applicants, and aid can be denied based on prior drug offenses. Depending on the felony conviction, one becomes ineligible for SNAP and TANF, and over 10 million Americans were unable to receive benefits based on a criminal record. And lastly, because we talked about employment already, I just want to highlight that 55 licensed occupations as of right now will prohibit a license renewal or employment for a prior conviction. So this has real implications. All we're simply saying with this piece of legislation is that we want to give courts the opportunity, since they are the ones who are leverage these convictions against an individual. We just want to give them the chance to unleverage them based off of their own convictions, based off of their own discretion. So we think it's a phenomenal bill. I want to thank the State's Attorney, Judge Karoum, and the rest of the members that are going to testify on this, and we urge a favorable report. Thank you.
Thank you. Questions for this panel? Seeing no questions, thank you all so much for being here. Let's move to our next witnesses, Blake Donahue, Christopher Sweeney, DeAndre Wiggins, Charlotte Ahern.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Blake Donahue, and I'm the legislative extern for the Human Trafficking Prevention Project. I also attend the University of Baltimore School of Law as a 2L. Senate Bill 17 would allow a court to grant a petition for expungement of convictions listed in Maryland Criminal Procedure Article 10-110 at any time for good cause shown. The Human Trafficking Prevention Project supports this bill because it would allow criminalized survivors of human trafficking to petition for expedited criminal record relief, allowing them greater access to the opportunities they need to better their lives. Criminal records are both a predictor and a result of human trafficking. Data from a national survey of trafficking survivors shows that 91% of them have been arrested, and over 40% were arrested 9 times or more. As a result, the expungement laws have become a crucial part of survivors' ability to heal. After escaping their traffickers, survivors overwhelmingly want to leave those traumatic experiences behind them and be able to provide better lives for themselves. This often involves finding a job that gives them economic stability. According to the Sentencing Project, 87% of employers conduct criminal record checks, and in the many professions that require licensures, employers are allowed by law to discriminate against or altogether ban job candidates based on their criminal record, all of which makes securing a job especially burdensome. Given the fundamental injustice that so many survivors are already forced to endure due to the consequences of a criminal record that so often stems from crimes they are compelled to commit, it is essential that any state-based remedy allow for the broadest relief possible, rather than impose additional hurdles like excessive waiting periods that prevent them from moving forward with their lives. With the expanded access to the good cause expungement provision provided by SB 17, criminalized survivors of trafficking can petition the court to expedite the start of their new lives. For these reasons, the Human Trafficking Prevention Project supports Senate Bill 17 and respectfully urges a favorable report. Thank you.
Good afternoon, Mr. Vice Chair and the rest of the members of the committee. I appreciate the opportunity to be here. My name is Christopher Sweeney. I'm a staff attorney with Maryland Volunteer Lawyer Service, and there I manage the Workforce Development Project, which means, in short, that I assist people in job training programs to remove barriers to employment. And needless to say, I have assisted several hundred people with filing for criminal record expungement. A lot of what I had planned to say has already been stated very well by Senator Carter and the great panelists we've already had. So I'll just briefly say, first of all, I have seen far too many people turned away from getting criminal record relief. As Senator Carter stated, there are There is language in the statute that imposes long waiting periods and actually omits a number of minor offenses from eligibility. So let's just imagine that someone went through a period of addiction and that resulted in a lot of convictions for theft, drug possession, minor nonviolent things. As it stands right now, if that person did everything they're supposed to do, they could still be turned away from the expungement process. They could turn their life completely around in a few years, complete a treatment program, graduate from a job training program. They could even have a conditional employment offer, just with the requirement of a clean criminal record, and they would be turned away at the clerk's desk. And that's the real issue that this bill solves. That person in that situation, they can't even make the ask of the court to even consider their petition. They would be turned away by the clerk for not meeting the statutory requirements as written. So this bill just gives the court, as everyone has said, discretion to consider those types of cases. Let the judicial officers make that decision rather than going by the strict language of the statute and allow for exceptions. I really appreciate the opportunity to be here. I hope you will return a favorable report.
Hello, good afternoon, everyone. My name is Charlotte Ahern. I am a staff attorney with Maryland Legal Aid. Thank you for this opportunity to provide testimony today. As Chris mentioned, everyone has basically said all of the great things, and thank you for Senator Carter for proposing this bill. The majority of my work focuses on workforce development and criminal record expungement. This bill is reasonable, it's straightforward, it's simple, it makes sense. The good cause provision does already exist in section 10105. However, it does not exist in section 10110, which the Public Defender's Office mentioned that there was a case recently that in Vincent that decided that because that was not included in the specific language, that judicial discretion did not exist, which is exactly what this bill would do. It would create judicial discretion to allow individuals to file a petition early for expungement. I want to just make sure I clarify that this is not related to, or this does not create additional types of convictions that are eligible for expungement. It's not adding new convictions. It's not expanding the number of convictions that are eligible. It is simply convictions that this legislative body has already decided will be eligible for expungement at some point, and this is a time for filing bill. The judicial discretion exists in all aspects of the law, and it should exist in expungement as well. As Senator Carter said, every person is different, everyone in this room is different, every case is different, and that is why Maryland Legal Aid believes that there should be a judicial discretion to look at the person, look at the case and the facts, and make a decision whether that person is deserving of expungement prior to this very long waiting period to file for a conviction. So we urge a favorable report. Thank you.
Hi, DeAndre Wiggins, Job Opportunities Task Force. We obviously urge a favorable report. As we do the work that we do in workforce development, one of the things that we have noticed over the years is a lack of character development in some of the individuals that we work with. And so what we've seen is that if you address that as well as certain skill sets, then you have a more robust individual who's ready to go into the workforce. In other words, obtain employment and also retain employment. One of the premises that from which we operate is that which my past should not dictate my future. We cannot continue to forward folks or move folks along this continuum, if you will, if we continue to hold on to the past too greatly. None of us would want that to happen for us. If you've done something wrong and you have served your time or been punished in some other way, then you should be allowed to move on, as we all have. So we believe that a favorable report for this bill is definitely in order. Good cause, good faith, and good character go hand in hand. And I think that in days to come, you will see a trend especially with regards to workforce development, which is my wheelhouse, of those issues being addressed as well as or alongside certain skill sets that are being imparted to the individuals that we serve. The absence of which certainly creates or at least perpetuates a sub-working class group, that which we certainly do not need to expound upon anymore. So again, we urge a favorable report and expect you to respond accordingly. Thank you.
Thank you so much, everyone, for your testimony today. Seeing no questions from the senators, we'll move on to our next panel. In favor of the bill, Nicole Hansen, Harold Coleman, Norman Richardson, please. Are any of those witnesses with us today? One more time, Nicole Hansen, Harold Coleman, Norman Richardson. All right, we'll move on to the unfavorable in person, John Cox, Lauren Lipscomb.
I don't see Ms. Lipscomb, so it looks like I'm on my own. I'm John Cox. I'm Deputy State's Attorney for Baltimore County. Speaking here on behalf of the Maryland State's Attorneys Association and ask for an unfavorable report on Senate Bill 17. In 2016, this committee, in what could be described as a Herculean effort, passed the Justice Reinvestment Act. A major part of that, or a significant part of that, was expungement. Prior to 2016, the only thing that could be expunged was what was referred to by Senator Carter previously as non-conviction, either a stead or a null pros, or a probation before judgment. This addressed, in 2016, the committee addressed and passed through the legislature the piece that dealt with a significant number of guilty findings, convictions, and then went through the deliberative process, and I think the correct process, in determining that there ought to be a time frame for which somebody ought to be held responsible or accountable for their actions before they can be granted the opportunity for expungement. And they set those time periods. In effect, what this bill does is remove those time periods. To say that, and Senator Carter did note one thing I pointed out in my written testimony, and is corrected, I assume, or will be corrected, in the way that this was drafted. Theoretically, the way it's drafted, you could expunge something the day after you were convicted. And it appears, I mean, I accept that Senator Carter is going to amend that part to fix that and to put it to the point where it can't be done until the conviction is over or the sentence is over and served. But that still leaves the need for accountability. A retailer ought to be able to know that somebody just finished a sentence for stealing from their employer when they're applying for a job. The justice system ought to be able to know that an individual just finished a sentence for a theft if they've committed another theft. There ought to be a rational time period for which somebody has to be held accountable, and the justice system will know of your actions for that time period if you choose to commit another offense. We'd ask for an unfavorable report.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of Sheriff Troy Berry and the Maryland Chiefs and Sheriffs Association.
Mr. Spencer?
Sir.
Are you signed up to testify on behalf of this bill?
I believe so. Yes, sir.
What's that? Okay, please go ahead.
I went online, hit save, and signed up and hit save. So it should
Got
be
it.
there.
Go for it.
So I'm here on behalf of the Maryland Chiefs and Sheriffs Association in opposition to this bill. There's essentially four major reasons why we're opposed to this bill. You heard about the need for transparency in the judicial process and the need for why access to convictions is important in society. But number two, unlike 10-105, there is no waiver provision for a lawsuit. Under this bill, a criminal conviction can be expunged within less than 3 years, and the person can turn around and file a suit against the officer who arrested him and charged him, against witnesses who complained against that person. In 10-105, there is at least a waiver that requires a waiver suit if you're found within 3 years. This bill does not have that. Number three, there are background checks do play an important role in various hiring positions. You heard there are 55 licenses that require background checks, including police. So if you allow good cause at any time, that means when police agencies go to hire somebody, they can't access the expunged charge of prior second-degree assault, the prior fourth-degree burglary. Finally, there are other offenses where a conviction prohibits you from doing certain things. For example, firearm possession. Many of the offenses listed in the current statute are things that prevent you from possessing a firearm, such as second-degree assault, fourth-degree burglary, felony theft. If that charge is expunged, an officer encountering somebody with a gun on the street is not going to be able to tell that person's prohibited from possessing a firearm. That person gets away, gets charged with carrying a handgun or transporting a handgun instead of the public safety article charges because that person's prohibited. It denies access to that critical information. For those reasons, we ask for an unfavorable report on this bill.
Thank you. Questions for this panel? All right, seeing no questions, we will then move online. Okay. All right, Mr. Quarles is not here with us. Mr. McAvoy, please go ahead.
Thank you so much, committee. I appreciate your time today. I want to discuss something sort of bouncing off Senator Watson's bill on child support. There was a mention about the clicking off of the this toggle inside of CSES, the child support system, that holds on to those records and how it comes back every couple of months.
Mr. McAvoy?
And I want to point out that I know this because I've actually hand-walked these cases to that director and asked them to remove it, and it's been removed permanently. And I want to submit that for expungement, there are probably certain other tricks and hacks for this. Senator Carter brought up the issue. I hope that you can all hear me okay. Check.
Mr. McAvoy, we can hear you. Are you testifying on the expungement
Yeah.
bill or the earlier bill related to child support?
Senator Carter said that about 2 decades ago, she had brought this issue. And I want to say that maybe 2 decades ago, Senator Carter was successful because in city, anyhow, every single job service has, for about 2 decades now, included expungement services. There's 2 Matthews. I can't recall their last names, but one has a service who does low and pro bono work, and the other one was working with OPD. And I would also say and submit that I don't see why, for some of these who were just starting their expungement, maybe it's their first charge, we did hear a lot about recidivism, which would make some of these expungements ineligible and likely should. Why they can't just go to Maryland courts and fill out that form and submit a heartfelt or sort of ad hoc submission, because the discussion was made that judges do have some type of leniency in these expungements for the betterment of society. And I think I just want to wrap this up saying that we have a convicted crime. Now, they vary in degree, but there was a conviction, or there'd be no expungement or need for expungement. Let's not forget that a wrong was done to society and to people, and I can tell you in city, victims aren't paid. They don't get anything.
Thank you,
get
Mr.
hit on the
McAvoy.
head, you get carjacked, you get nothing.
Mr. McAvoy.
So let's not forget that part.
Thank you for your
the victim.
testimony
Thank
today.
you all for your time today.
Really appreciate it. That concludes the hearing on Senate Bill 117. We'll now go back into order with Senator Sidnor and Senate Bill 40. Senator.
All right. How you doing? Good afternoon, committee. For the record, Senator Charles Sidnor, here to testify on Senate Bill 40. For many of you, I think for most of the members here on this committee, this bill is very familiar to you all. We've passed it, at least a bill very similar to this a number of times. When I was over in the House, I had supported this bill. I was able to get it passed in the House, but it would die over in the Senate. When I came over here to the Senate, I've always been able to get it out of the Senate, but it would die over in the House. We all hear about that quote about insanity, doing the same thing over and over. Well, I was trying not to be insane this time, so there was one provision within the bill that tended to cause some consternation over in the House, and it was that portion of the bill that I took out. Unfortunately, I think when we filed the bill was published removing the section that's tended to be problematic, but really, when this bill was first introduced, was a big portion of the bill. That portion has been removed, and it accidentally removed one section that I did intend to keep in the bill, which was about the depiction of the death of a law enforcement officer that occurs in the performance of the officer's duty. Now, in setting that stage, what is this bill about? This bill is essentially, for me, about ensuring that one's dignity and privacy is protected in certain circumstances when law enforcement's body cameras capture certain images. So in the past, we've had like 5 different categories. As I said, in the bill as amended and before you all, those 5 categories are now down to 4 categories, with the section that was most problematic being removed, and a section that was inadvertently removed, the death of the law enforcement officer, being placed back in. So with the bill, for the most part, what the bill covers are people who have been victims of domestic violence, and ensuring that when they're captured on body camera, that those images, that they have some control over the images and how those images may come out. So I'm going to be quiet. I do ask for a favorable, and I'll leave it to the panel to talk.
Thank you, Senator Sidnor. And whoever would like to come up next, as the advocates come up, I just remind the panel, there's no opposition to this bill today.
Noted, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, here in strong support of Senate Bill 40. Thank you, Senator Sidnor, for sticking with this bill. It really is very important to survivors of sexual assault and child abuse, as well as to survivors of domestic violence. Since the senator has done such an excellent job explaining the bill, I just will mention what the bill does not do. The bill does not change access in civil discovery. It does not change the rules permitting access to footage that is introduced in evidence in court. It does not limit the ability of a victim to see footage for any reason, including holding law enforcement accountable. And it does not prohibit alleged assailants from viewing the footage. It does prevent them from copying it, and it does require that the victim be notified if an alleged assailant is looking at the footage, so she or he can take safety precautions. So it's a very carefully balanced bill. You've passed it before. We ask for a favorable report again. Thank you so much.
Good afternoon, Mr. Vice Chair, members of the committee. I am Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence, Maryland State Domestic Violence Coalition. I, too, will not reiterate all of the things that have already been said. What I will let you know is that over half of all domestic violence incidents go unreported. And it's for a variety of reasons, including a desire for privacy, fear of reprisal, shame, as well as an overwhelming mistrust of law enforcement and fear of not being believed by the police. Policies such as this will help improve that relationship, instill that trust, and allow victims to seek assistance of law enforcement when they need it. Ms. Jordan already covered what the bill does and does not do. I would just reiterate this bill is about victim safety and victim privacy. It's trauma-informed and it's victim-centered, and it carefully balances the needs of victims of domestic violence, those of confidentiality and privacy and safety, with the need to develop trust and confidence in the police and the constitutional rights for those in civil and criminal justice proceedings. This incorporates recommendations from the 2015 Commission regarding the implementation and use of body cameras by law enforcement officers in Maryland, and it's also consistent with recommendations from the International Association of Chiefs of Police 2017 National Forum on Body-Worn Cameras and Violence Against Women. And we are asking for a favorable report on SB 40.
Good afternoon, Mr. Vice Chair and members of the committee. My name is John Fitzgerald. I am here representing the Maryland Chiefs and Sheriffs. I serve currently as the Chief of Police for Chevy Chase Village, a small municipality in Montgomery County. I'm in my 40th year in this work and my 32nd year as a Maryland attorney. This bill does some really good things, and I recognize there's no opposition here for it. But I didn't learn until last night, and I don't want to cross swords with my friend Senator Sidnor. We've worked on this bill
at least on 5 go-rounds here, at least twice when he was a delegate, and this is the 3rd time since he's been in the Senate. I didn't realize he had submitted an amendment that would remove what I think is very important language. So we are here supporting this bill with that language in, as well as with the language that he's asking to add. So his amendment asks for a deletion of something and an addition of something else. We support the addition. We don't want the language removed. The language that is proposed to be removed, that passed 10-0 in this committee last year and 44-0 on the floor of the full Senate, and similarly the prior year, would provide Marylanders generally with privacy protections from voyeuristic neighbors that want to just see these things that have nothing to do with police searches and seizures and so on, while at the same time providing for real access to people for things that they want to complain about if the police act badly, and all of the things that the public is concerned about, searches, seizures, uses of force, and things like that. The language of that particular provision should stay in. Thank you.
Thank you, Mr. Chair. Senator Sidnor, thank you for the bill. Often we know that when there's a bill that makes it through, has this much difficulty, there's a good reason. And what I mean is that even though the intent is good, usually the more work we do on it, the better product we have. While there may not be any physical opposition here, there is a written opposition, and it basically, and I don't know, you've done a lot of work on the bill, so maybe the concern is addressed, or maybe it isn't, I don't know. The surge
Right, so
opposition?
surge. So surge is talking about the provision that I removed, that they've
Okay.
been against, that the ACLU has been against. And as I've mentioned to everyone here on the panel, it's that particular provision that I think has caused the stoppage on the other side. And so, again, in my intent not to be insane and bang my head up against the wall and continue not to move things forward, I gave in. I said we're going to present it this manner and see how it goes.
Okay, thank you.
All right, seeing no further questions from the committee, thank you all very much. We'll now move on to the next panel, and we'll hear from Mr. George, Ms. Sample, and the next one is virtual. William.
Good afternoon, Mr. Chair and members of the committee. My name is Bill George. I'm here with the Maryland Municipal League today in support of Senate Bill 40. I'd like to just talk briefly about this bill and how it will help our records custodians. You've heard me and our organization before your committee several times in the past talking about the difficulty of the Public Information Act, both from the records custodian perspective and also from the requester perspective. We understand there's frustration on both sides and believe that the provisions in this bill will help provide a clear, bright line for denials of certain incidents that have no public interest should they be released. Our records custodians are really looking for some help to release some of their burden, take some discretion off of their plate, and give them a clear-cut reason for denials of these certain egregious crimes. So with that being said, we ask for a favorable report. I'm happy to answer any questions.
Good afternoon, everyone. Thank you for having me today. Thank you to the chair and members of the committee. My name is Sarah Sample, and I am here on behalf of the Maryland Association of Counties, and we are here in support of this bill. I know a lot of people have already mentioned the history that this bill has, particularly in this committee, and so I would point to that history. This is, thank you, Senator Sidner, for really sticking with this and keeping the conversation open with us. But again, it's something that did pass unanimously in this chamber. I want to say it was last year and also in 2021. So I wouldn't belabor the point too much in terms of getting down into the details on it. But from MACO's standpoint, this is a good bill. This is a bill that I think reinforces the integrity of the police reforms, and I think it also does well to try to clean up some of those inadvertent consequences that come with body-worn camera footage and those records being open if they contain victim footage in them. So we would, just consistent with this committee's report in the past, say that we would urge a favorable report. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all. Thank you both. All right, we'll now turn to our virtual panel, and we have Ms. Levy.
Hi, Judge, sorry, Judge.
Hey.
Hi,
Wrong
Senator,
branch.
I'm sorry, I'm in a jury
Yeah.
trial, and we did have
Oh,
a
no.
verdict, so I'm going to be very, very quick. What I wanted to say, and we've signed up to testify informationally, can you, okay. Deborah Levy from the Office of the Public Defender. As you know, I run the Special Litigation Unit where we subpoena law enforcement misconduct records from every law enforcement agency in the state. And since the enactment of Anton's Law, we have subpoenaed over 125 law enforcement agencies. We've gotten 0 full files back because of the redaction provisions for the media in Montgomery County. As you know, we have over $1 million fee request for redactions. In other counties, we have over $200,000 fee requests for redactions. And my understanding of Senator Sidnor's bill is that this would remove this redaction requirement for cases related to a complaint of misconduct. And we would think that that would actually start to move these records, and the legislature's intention with Anton's Law would come to fruition, which it is currently not. So that is the message that I wanted to give Your Honor, to give you, Senator. And if anybody else had any questions, otherwise I would hop back into court.
All right, thank you, Ms. Levy. Good to see you.
Thank you.
No questions from the committee. Thank you.
Thank you.
All right. I believe that is the last witness, so with that, that'll end the testimony and the hearing for Senate Bill 40. We'll now move on to Senate Bill 22. Senator Sidnor, you're up.
All right. Now, that was an easy bill, and this one should be easy as well, depending on what side out you look at it. So, for the record, Senator Charles Sidnor here to testify in support of Senate Bill 22. So, Joshua Hoffman, who is sitting to my left, he and I had spoken sometime this past fall, and he had raised some concerns regarding the Supreme Court's chipping away at what many of us know and believe to be our rights, our Miranda rights, the right to be kind of read your rights when you were brought in to some sort of custodial type relationship with law enforcement. Anyhow, over the years, because Miranda is common law, not statutory law, what the court gives it, depending upon the balance of the court, it taketh away. And many of the things that, again, how we thought Miranda was, no longer is. So what we attempted to do with Senate Bill 22 is to codify what was Miranda and to define what a custodial interrogation is. So rather than moving away from it being a judicially determined, meaning we kind of listed some factors as to what we would like it or what we believe it to be. So with that, I'm going to move and turn this over to some folk who are more expert than me.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. I'm Josh Hoffman. It's been 11 years since I first came out of law school and worked for a member, now retired, of this House. And since then, I've been practicing mostly criminal law at the state and federal level. And I've had two big conclusions from that time. One, the courts are somewhat results-oriented. And number two, as they always say, it is actually the body, the legislative body, that should be making policy. We hear courts say this all the time. Usually it's in the dissenting portions. And and usually they do it when they're making policy. They're not able to conduct research. They're not able to craft policies on a widespread basis. They have to deal with what's right in front of them, and they can't do very much more. It's hard to predict what they're going to do and when they're going to do it. We've already gotten started quite a bit on Miranda, and I'll just take the committee through some of the biggest stuff. Justice Rehnquist is the one, I think, who originally coined the term prophylactic rules. They refer to the Miranda rights not as something that's actually part of the Fifth Amendment or, for that matter, Maryland Article 24 of the Declaration of Rights. In fact, the Miranda rights aren't in there. They're just something that the Warren Court saw as necessary, because with modern policing, urban policing, if a police officer is able to just get a confession and bring it seamlessly into the courtroom, after all, what was the purpose of that right in the first place? This committee has responded, and I think the people who elect our legislatures has shown from the midterm elections that they prefer a response to this Supreme Court. And I agree with the Supreme Court that some of this stuff is not actually in the Constitution. It is the work of this committee and the General Assembly to do this. This is police procedure kind of stuff we're talking about here. In the Dobbs opinion, this committee and this General Assembly responded forcefully, and the dissent warned that they were not done. In Vega v. Tico, they found that Miranda was actually not a constitutional right for purposes of a 1983 tort. It's very clear which direction they're going, and it would be better if we dealt with this now rather than wait for a period of chaos and uncertainty to decide then. The Supreme Court, and I'll conclude on this, I know I'm out of time, is elected or appointed by a president who is mostly determined by the voters of Georgia, Arizona, Pennsylvania, much more than it is Marylanders. That and that alone is what is determining our current Fifth Amendment Miranda jurisprudence. Therefore, this committee should act. I urge a favorable report. Thank you.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Tia Holmes. I am here on behalf of the Office of the Public Defender. Now, I come before you today to urge you to vote in favor of this bill. Not as a warning that Miranda is going to go away, but just to reinforce those rights in case that Miranda goes away. What we have right now in our custodial interrogation definition is that it refers to a judicially determined meaning. Well, a judicially determined meaning is constantly a moving target, and the custody analysis part of that custodial interrogation meaning is constantly being interpreted through a fact-based scenario. And so what it does is it evolves every time the court enters a new factual situation. So the most important thing that this bill does is establishes 3 distinct scenarios where custody would already be established, and that is when a person is detained, when a person is arrested, or when a person feels that they are not free to leave the encounter. Now, why should we codify Miranda? We need to codify Miranda because right now the tortured meaning of custodial interrogation is producing mixed results. Consider, for example, Gupta versus State, which the Court of Appeals decided back in 2017. The person was actually arrested. He was in a holding cell, and he demanded to see an attorney from his cell 3 to 4 times. But the court held that he was not in the context of custodial interrogation. There's another case where custody was established. The state conceded it. The trial court found it. However, the appellate court reversed it. And so what we are asking this committee and this body to do is to demonstrate your legislative intent that custody should be established in 3 distinct scenarios. And with that, we ask you issue a favorable report on Senate Bill 22.
Thank you, Mr. Chairman. I don't know whoever wants to answer on it, but when I look at Miranda and I'm looking at what you have here, you know, one of the things you have in here is that when that they had a reasonable belief, or they feel, I think you said they feel like they're in custody, or that they're not free to leave. Are we now saying that we're going to subject officers who are already under immense amount of scrutiny to now determine how one feels during a given situation of questioning that may be immediately following a crime, and they may not know that the person they're even talking to is actually the suspect, but that's why you have different levels of interrogation, custody, and that's why custody and interrogation are specifically mentioned in Miranda as those measures. The feeling or belief is irrelevant because people might feel very intimidated and feel like they can't leave just by a police officer being there. But the reality is that it's very clear that custody means the formal arrest or deprivation of freedom to an extent associated with the formal arrest. So those two things are pretty clear to me. So can someone answer as to how this bill is doing anything except, I mean, this is a federal issue. If you're trying to, in my opinion, this is something that you need to go to the Supreme Court or go to your congressperson to change the federal law, because Miranda is a federal decision, is it not?
Miranda is very much a federal decision, and you said a lot of valid points. Your first about whether the officer believes that or changes his perception about what the stop is for, and the person's belief. Right now, that is not a relevant inquiry to the custody analysis, so I don't think that this law would change that. What it would do is establish the scenarios. And so right now, what courts do is they engage in a fact-by-fact based totality of the circumstances analysis from a reasonable person's standpoint. And so what this bill would do is just make those decisions for the court instead of leaving it to a shifting analysis. And so in your scenario, would that person be detained or arrested or what? Detained? Is this a detention in your hypothetical?
You have an you have a part of the investigative process. You could have an investigative inquiry. You could have an investigative detention or whatever you want to call it. The reality is that custody and interrogation are the clues, are the words that are associated with Miranda. An investigative detention, immediately following a crime or something of the like. Are we allowing video cameras in the room now? Where's that? Right there. The senator from videoing. That's not appropriate. Not appropriate at all.
I apologize. This is my friend, and I was trying to.
Okay, it's not appropriate.
We're all being recorded, right?
I get it. Not to be used on your Snap account. So Miranda's very clear. It deals with custody and interrogation. Investigative detention is not either of those, but it is a required element by law enforcement to be able to investigate the facts or fact gathering of a commission of a crime, correct?
Yes, and this bill does not change that.
It does change it. Because you're going to say that a person that would be in a investigative detention may have reasonable belief that they can't leave, or as you said, feels like they can't leave. And that would change that. Because now you're asking the officer to say, hey, I got to put you on notice that you're free to leave, but I want to talk to you.
Well, respectfully, Senator, right now, even if a person is Mirandized, there are studies. That person may waive a Miranda right, and an officer still can get an incriminating statement.
Correct.
Right? And in 65% of those cases, you can still get an incriminating statement. Maybe not the one you were looking for, but you can still take that person to court and prosecute them once that
Correct.
converts.
Correct.
So this will not necessarily weaken or change anything that officers are doing or any investigative techniques.
Actually, it would. It would make officers more liable for potentially violating the perception of someone's right by their feeling. That's my point. Officers cannot be charged with challenging to accept the feeling of another person on how they feel about their investigative detention. Miranda is clear. It's custody or interrogation, not an investigative detention. These are required elements within the framework of the law that are utilized by law enforcement and necessary elements to investigate crimes appropriately. And anything short of that is watering down the process and doing things to just allow people to be like, oh, you know what, I felt like that officer, I felt afraid, I didn't know I could leave. and now I don't want to, I'm afraid.
Well, respectfully, in a suppression court, those facts would come out, and the suppression court would be able to make a determination. What happens at the appellate level, which is what this bill would address, is they would then apply the facts of the case to the bill and discern this body's legislative intent.
So once again, we're adding another layer that someone then, off their feelings, could then appeal and then turn around and try to sue law enforcement by saying, oh, he violated my rights, when
Well-
he's following within the exact guide of what Miranda allows.
Well, the same results would yield if an objective person in that same person's circumstances right now under the law.
I agree with that.
Yeah.
Because I like that standard. That's a great standard. I'm going to use, because that's the exact standard on what has been lost for some of the MPAA stuff that came out, because the standard for Leobar, what it used to be was that would a like officer in a like situation have responded the same way, and now we're being reviewed by people that are not even police officers. So I appreciate you bringing that up, because it's an excellent point.
That is.
Thank you. I appreciate you coming out.
All right, further questions from the committee? Senator Washington, thank you.
Thank you, Mr. Chairman. Just point of personal privilege, I just want to apologize to Senator Folden. It wasn't meant to be any heinous way or anything like that, so I do want to apologize to you. Yep, absolutely. Just want to ask a quick question. If the Supreme Court does rule that Miranda rights are removed and it's no longer, no longer a law in this country, this bill codifies it for Maryland. Is that right?
That is exactly the intention, Senator. The law exists in Maryland and federal, also goes to the previous question from the esteemed senator. It is Maryland law and it's federal law, but Maryland interprets it in pari materia, meaning identical to federal law. In theory, it would disappear from Maryland law, where it absolutely does exist, because it disappeared from the federal law too. In other words, Maryland's Article 24 is interpreted identically for purposes of this with the Fifth Amendment. The purpose of this is to no longer leave that up to the Supreme Court, and then possibly, you could argue, you could think, then hope that maybe the Maryland Supreme Court would keep it around and say that it is a state thing, and we're keeping it, but we don't know that. And as I've said before, it's a matter of police procedures. Why do that? So yes is the answer to your, with a long answer to your question. Yes, thank you.
Go ahead, follow up.
And just to follow up, this wouldn't be the first time we've done something like this, that went before the actual ruling before a Supreme Court. We've put these things into law based on case studies before. Is that right?
Certainly, certainly, Senator. And I would add on top of that that so many of the big reforms and important reforms that have come from the General Assembly in recent years, looking to curtail bad conduct of all sorts, was not identifying bad conduct that was newly being made illegal. Already, they were illegal. Anton's Law was mentioned a little while ago. Now, in certain contexts, for example, the famous Brady versus Maryland case, whether a police officer had maybe perjured themselves or was likely a perjurer or had broken various procedures, that was the kind of thing that a lot of people thought probably had to be disclosed to the defense in a criminal case, and possibly in certain civil cases, although that did change some laws. So a lot of the times what this committee is doing is not only preempting the courts, as it should, because this is the lawmaking body, but is also identifying things that were already illegal, every bit as much so, and something needed to be done to enforce it more strongly or more to the liking of this body and the people it represents. Thank you, Senator.
Thank you. Senator James, did you have a question? No. Okay, Senator West.
Thank you, Mr. Chair. And I have to apologize. I was out in another committee presenting a bill when the senator presented this bill. But I do have a question for the senator, if I could ask you a question. So last year, we passed a significant amendment to the juvenile system of justice. We're rapidly moving away from incarcerating juveniles, instead giving them the services they need to solve their problems, mental health services and other services, wraparound services. The whole idea of what we passed last year is premised on the knowledge that premised on the idea that we would know who the juveniles are who need the treatment. So under this bill, Senate Bill 22, the requirement is that every juvenile be provided with a lawyer before any interrogation occurs. And all the lawyers that I know always advise their clients to be quiet, not to talk to the police, not to say anything, for fear that they might say something which would incriminate them. And I can just understand that when we're talking about adults who could go to jail. But with juveniles, increasingly, as I indicated, we're not trying to put them in jail. We're trying to get them help. So don't you think that this bill is inconsistent with how we're trying to treat juveniles these days? In order to treat them, we need to know who they are, who did what at what time, and who the other people were who assisted in the crime. So don't you think that your bill is inconsistent with the way we're moving with respect to juvenile justice?
No.
No. Okay. Can you explain why?
My bill is attempting to be consistent with our constitutional rights under the Fifth Amendment. We don't want people self-incriminating themselves. The idea of the bill is really, as Senator Washington was alluding to, is attempting to codify what we've all thought was our rights for all these years, and to ensure that there's no further, and this is, in my perception, erosion of those rights.
But wouldn't you agree that if those people who were present at the scene of an incident all see lawyers and are all told, don't talk to the police, and the police therefore aren't able to figure out who did it, we're not going to be offering services to the person who did it to try to turn their life around. Instead, the person who did it would just go on to do more things because the person has not been identified and hasn't been received treatment.
I think at that point, again, you have the tribunal and they'll figure those facts out. So
I'm sorry, what's the
I said at that point you have your juvenile hearing or whatever, and those facts and things will be sorted out. You're assuming, or you're talking in your hypothetical, you already have an attorney, or you've gotten to an attorney and they said don't say anything. But the fact of the matter is, on the street you don't have an attorney, and most juveniles, they don't understand what the rights are, what people's rights are. And again, this is more of a way to make certain that we're codifying something and ensuring that it doesn't get further eroded.
All right. Thank you very much.
Thank you, sir.
All right, thank you, Senator. Seeing no further questions for this panel, we'll move on to the opposition to the bill. Jerome Spencer, John Cox, Stephen Kroll, Scott Schellenberger, please.
Mr. Vice Chair, members of the committee, Scott Schellenberger, State's Attorney for Baltimore County. And to take Senator Folden's example a little bit further, everybody's going to consent on the night that they are questioned. But boy, when they get to court on now, 3 months from now, suddenly it's, I didn't feel the same way. And so what we're doing here is we've had Miranda versus Arizona around for nearly 60 years. And you could fill 20 shelves like that behind Senator Waldstreicher with all the case law that developed around Miranda rights and how police have to behave. And it's very nuanced and it's very different and it's very specific, and we teach it to the police officers every day and make sure they understand it. We know the rules, we know what they are. What we're doing is we're taking Supreme Court case law, Court of Appeals case law, Court of Special Appeals case law, and put it on one piece of paper. That just doesn't really make any sense. The other thing that I think is important is that this is very different than the 14th Amendment. This is the Fifth Amendment that says, nor shall be compelled in any criminal case to be a witness against themselves. That is not interpreting due process like some of the cases folks are talking about. We are talking about a very specific right that is in the Bill of Rights, our Fifth Amendment, and I don't think it's going to disappear because some new Supreme Court comes around or some new Court of Appeals comes around. This is codified in law, and it's not going to change, but it's case law that we need because every circumstance is different, and they are always changing. The other thing that's fascinating is to require the waiver has to be signed or the advice must be recorded is a little unrealistic also. I know I'm very much in favor of body cameras. We love them. But there are some times where individuals are going to be questioned without having a body camera. And Senator Sidnar brought up, well, you can take that juvenile to the tribunal. Well, you don't get to the tribunal because you don't have enough evidence to arrest anybody until people have done the discussions. I just feel like this is a pretty standard area of law that everyone understands, and I would oppose the bill as it's. I would oppose the bill in any fashion. Thank you.
Members of the committee, I'm John Cox, Deputy State's Attorney for Baltimore County. Far be it for me to say that the last speaker wasn't brilliant and addressed what we need to address, but I do want to point out just a couple other things. Number one, this is not a codification of Miranda. If you look at the advisements, those aren't the current advisements that are required under Miranda. The most telling part of this is the definition of custodial interrogation. As Mr. Schellenberger said, there's 56 years, actually, of litigation or clarification by the Supreme Court as to what custodial interrogation is. This has gone so far beyond that. I'll give you two examples. An officer pulls a vehicle over because it's weaving and then walks up to the vehicle. That person reasonably would conclude that they're not free to leave. I'll give you that. They're detained. So that officer has to, according to this, then pull out a written form before he even asks the person's name, because that's questioning. So therefore, you've got to have your written form with you and go through that advisement and have them sign it and or record the fact that they refuse to sign it. And then maybe you can ask questions if they choose to answer any questions that you're going to pose to them. You can't say, have you been drinking, without going through this process. A school shooting happens, an elementary school, report comes out to a police officer, there have been shots fired on a playground. The officer goes flying to the scene. And as he's getting to the scene, there's somebody running away. That officer, understandably, stops that person. And the first thing they're going to say is, what just happened? And this says the officer has to have some pieces of paper on him and stop the person and say, wait a minute, let me advise you of all of these things, and please sign this before I can ask you anything like what happened. And if the officer doesn't do it and the person says, I just shot 4 kids on the playground and I hid the gun under the mulch in the jungle gym, that can't be used against them. That is clearly not what Miranda dictated. That is clearly not custodial interrogation.
Good afternoon. Once again, I'm Jerome Spencer. I'm the General Counsel for the Charles County Sheriff's Office here on behalf of Sheriff Troy Berry and the Maryland Chiefs and Sheriffs Association. The advantage of going third is that Mr. Cox said it very well, but I'll say it again. This is not Miranda. You heard the proponent saying we're codifying Miranda. This is not Miranda. Mr. Cox gave you a couple examples of where this bill would require a piece of paper to be handed to a person. Give another one. Routine traffic stop, you're pulled over. Before the officer can say to you, hey, do you know how fast you're going? He's got to give you this piece of paper and go through the Miranda rights. Let's talk about why we have Miranda real quick. Miranda involved a station house interrogation where the Supreme Court was concerned we don't know what goes on behind closed doors. So in order to ensure that a voluntary statement is given, we advise people of their rights. That's not what a routine stop is. It's not that level of coercion. This is why time and time again, the Supreme Court, the Maryland Supreme Court, the Fourth Circuit have said that it has to be an arrest or the functional equivalent thereof. That's what Miranda is designed to protect. This bill goes way beyond that. And if we're worried about the voluntary statements, keep in mind, we already have protections in law. We already have the 14th Amendment and 5th Amendment, which talked about. The 5th Amendment says you can't be compelled to incriminate yourself. We also have other statute provisions in place, including body-worn cameras, recording custodial interrogations. We have the Juvenile Interrogation Act. We have the commencement of traffic stop or any other stop. I'm Officer so-and-so. Here's who I am. Here's why I'm stopping you. These protections already exist to ensure we have voluntary statements. This bill, I'm not really clear what the purpose of it is. If it's to prevent people from saying anything at all, it might work at that. But it's to ensure we have voluntary statements. It goes way beyond what is necessary to ensure that any statements given are voluntary. So we ask for an unfavorable report.
Vice Chair, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since October 1984. And I'm here on behalf of the Maryland State's Attorneys Association to say we're asking for an unfavorable report as to Senate Bill 22 and ask that you incorporated Mr. Schellenberger, Mr. Cox, and Mr. Spencer's arguments. And again, we ask for an unfavorable report as to Senate Bill 22. Thank you.
Absolutely, Senator Muse.
I'm sorry, I missed that. You represent,
Maryland State's Attorneys Association.
so all of the Maryland State attorneys are,
Yes.
they get together and they, okay, got you. You know what Prince George's County or Baltimore City would be on this? Did they also?
Every person, every state's attorney can put in a representative on the legislative committee. So there is somebody from Prince George's County
That's
on
what
that legislative committee.
That's what I need to know. Thank you very much, okay?
Great. Any further questions from senators to the opposition panel? All right, seeing no questions, I think we have one more in-person witness, which is David Daggett. Mr. Daggett, please come up.
Mr. Vice Chair, members of the committee, my name is David Daggett. I'm also a prosecutor. I have been for about 32 years here in Maryland. What's not been mentioned today by any of the other speakers was that, and to me, the reason why I find Senate Bill 22 so frightening is that officer safety has not been brought up. Nobody has mentioned Terry versus Ohio. I submitted an 8-page paper that I wrote about Terry versus Ohio. What Terry requires is, in order to detain somebody, before police can even stop somebody, they have to have reasonable, articulable suspicion to believe that that person either just committed a crime, is currently committing a crime, or is about to commit a crime. If somebody comes out, the police officer gets a report that somebody in a red shirt and blue jeans just committed armed robbery of a bank, and a police officer sees a person running down the street with a red shirt and blue jeans, before the officer, they can detain them because under Terry, they have reasonable articulable suspicion that that person committed that crime. Before they can ask them any questions, the officer would have to stop, get out his card or get out his piece of paper, and then advise the person of their rights, even though the person maybe just had committed an armed robbery. It's an officer safety issue. We also have the Supreme Court in Berkmer versus McCarty and Maryland's highest court in McAvoy versus State said that roadside questioning of a suspect or a detainee, if it's somebody who's stopped for driving, speeding, whatever it might be, Miranda is not required for that. This particular bill would require that. As I think Mr. Cox pointed out, you pull over a vehicle for weaving within the lane, crossing the center line, before you can even ask them their name or if they've been drinking alcohol, you have to advise them of their rights. That would overturn everything that the Supreme Court and Maryland appellate courts have said. And finally, I would point out my colleagues from across the country, I reached out and I had 22 people or actually I have to take that back, 21 people from across the country. I asked them if there is such a law in their states, if there's codification of Miranda and...
Mr. Daggett, if you could
yes,
conclude, please.
And none of the 21 said, in fact, that they had that statute. This would be the first of its kind, as far as I can tell. We recommend, the Maryland State's Attorney Association does recommend an unfavorable report.
Thank you. Questions for Mr. Daggett? Senator Sidnor.
No questions. All right, thank you.
And it's a quick question, because I think you and the other panel had kind of touched on this. As a legislature, we have the ability to essentially codify things, whatever that thing is. Do you believe that the judiciaries, when they make laws, that it's best to remain as court law, or I guess common law, versus something being made statutorily?
Well, I think the courts would have to follow what the legislature says. I mean,
But they don't always do that.
Well,
sometimes they interpret things as they want to interpret them.
well, that's a different issue. I can't address that. But by law, they are required. They are required to follow the statutes, and just like they are required to follow the Supreme Court precedent and upper court precedent, they have to do that.
Right. So last year, we experienced a court that got rid of something in Roe that we thought was our rights.
I hear
So
you.
there are times when you try to do some things to make certain where you see a court going in a certain direction where it would make sense to codify something rather than rely on case law, correct?
When you're talking about Roe v. Wade, I'll stand up here right here, and I agree with you 100%. I'm sorry about that decision. I don't have any problem
Right,
saying
so-
that. I understand perfectly what you're saying there. But no, I think what you're attempting to do is short-circuiting other types of, and there's so many other issues involved here. As I said earlier, officer safety is one of them. I think what you're trying to, at least what this bill tries to do, would prevent people from being held responsible for crimes that they commit. I mean, if you can't detain somebody and can't ask them questions, it would stop people from getting caught for the crimes that they commit.
So let's say that, let's set this, we were to set this bill aside and we whatever law currently is Supreme Court jurisprudence, we codify that. Would that be a problem?
Codify.
Whatever they say Miranda is right as of today.
Well, I think you have to, I think it takes a lot more, I think it takes a lot goes into that. And like I said, there's not a state in the union that I can tell that has come close to doing anything like what this bill would do. Plus and I understand, I think I understand where you're trying to go with this, but it's so open. And there's so many things that are open to interpretation. And like I said earlier, you couldn't even, as Mr. Cox said, there's a shooting in a school and somebody comes running out, maybe matching the description. You couldn't even stop them and ask them questions because unless you advise them first.
All right, like I said, let's set this aside.
I guess I can't. I mean, I'm having a hard time doing that.
So we codify whatever it is, whatever Miranda is now. Put it in the statutes. Would that be problematic? Or shall we just continue to have it be common law?
Well, I think we have a lot of areas, and I think you said it earlier, when you asked questions about the juvenile system, there's a lot of places in which individual citizens have rights protected, and whether that's before a juvenile court magistrate or whether it's before a district or circuit court judge or a court of appeals, you have so many steps in which you have your rights protected. I don't think it needs to be. I don't think it should be codified in this sense.
In this particular instance?
Certainly.
Thank you.
Okay, thank you.
All right, thank you so much, Mr. Daggett. That concludes the hearing for Senate Bill 22. The next bill we'll be hearing is Senate Bill 51. Senator Carter, please join us up front and bring your panel as you see fit.
Okay, we're still early, so we shouldn't grow too weary yet. Thank you, members of the committee that are here for listening to this really important bill, I'd say critical. I'm State Senator Jill Carter, District 41, and my panel, who has so assertive, waited to come up before I called. I want to introduce them, though. I believe the people here, I have Michelle Hoffman, the Office of the Public Defender. I have Malcolm Ruff, esteemed attorney and constituent of District 41. Yanette Emanuel from the ACLU of Maryland. My other constituent, this is why people call me the People's Champion. Deborah Reynolds, who you heard from yesterday. And is there anyone that I forgot? Okay. Roberto Martinez. So I had you down, but then I didn't see you. Okay, well, he's part of the panel, too. You can get a chair. Just hold. Mr. Chair and members of the committee, when it comes to the issue of legalizing marijuana, this issue is one of the most important issues that we're going to have to grapple with. How we choose to move on this issue is really speaking about who we are as a state, how we respect the Constitution, how we respect and want to see better outcomes for Marylanders than what we've had up until now. Senate Bill 51 will prohibit law enforcement from using the odor of cannabis as a basis for the warrantless search of a person or vehicle. In 2022, Marylanders endorsed overwhelmingly the legalization of marijuana for recreational use. However, so doing does not solve the ongoing problem of disparate enforcement of the law, especially in our Black and brown communities. The Fourth Amendment grants individuals a right to be free from unreasonable searches and seizures. However, the Supreme Court has long carved out exceptions for car searches when an officer has probable cause to believe that the vehicle contains contraband. Courts have held that the odor of cannabis does not provide probable cause to search a person or vehicle. For example, the Supreme Court of Pennsylvania in Commonwealth v. Barr, April 18, 2022, recently held that the odor of cannabis is insufficient to conduct a search of the vehicle. The plain smell without more is not enough to conduct a vehicle search, according to that court. Courts have been mixed about this issue, and decisions are ever evolving, but I believe it's our responsibility in Maryland to give guidance to our courts. This is a matter of public policy. Allowing the odor of cannabis to be the basis for a search creates a loophole in probable cause determination as it is being applied after the stop, notwithstanding the fact that cannabis is not the reason for the stop, and the citizen is stopped under the influence of cannabis. Research demonstrates that police are twice as likely to search Black people and other people of color during traffic stops than white drivers, even though the data shows that Black people and other people of color are less likely to possess illicit drugs and/or contraband. In traffic stops involving Black drivers, probable cause was used to justify 67% of searches in Maryland. In traffic stops involving white drivers, probable cause was used to justify a search of 46% of the time. Senate Bill 51 would eliminate opportunities for officers to abuse the discretion afforded them in these situations and reduce opportunities for racial profiling. In this post-criminalization period, Maryland court decisions on this issue have been confusing and inconsistent. In 2020, the Court of Appeals, now the Supreme Court of Maryland, ruled that the odor of marijuana alone does not provide probable cause for an arrest or warrantless search of an individual. The court reasoned that the odor of cannabis alone does not provide probable cause because cannabis possession has been decriminalized, and because an officer cannot determine the quantity of marijuana in someone's possession based solely upon odor. However, the same court, Supreme Court of Maryland, also ruled that while the odor of marijuana does not provide probable cause for a warrantless search or arrest, it does provide reasonable suspicion that the person possessed 10 grams or more, and therefore justifies an investigatory stop that could lead to a search. The Maryland legislature, we the Maryland legislature, must clarify for the courts that the odor of cannabis alone is not a basis for the search of an individual or a vehicle. And so for those reasons, I urge a favorable report. I had a chance to read through the bill and to glance at some of the opposition, and I think there is just one other point that I want to make clear regarding the concern or misunderstanding possibly about the issue of consent. So consent under Fourth Amendment has long been an exception, and this does nothing to alter that. And the intention of it is to do nothing to alter the exception of consent. When consent is given, that basically takes precedent over the Fourth Amendment, other issues, because the person has consented to a search. But what this does do, or tends to do, is to make it clear that a later consent can't be used basically to justify or make good an initial bad search. And so, with that, I'd love for you to hear from my esteemed panel, and I'm going to take my seat and listen for some, what I think will be riveting testimony. Thank you.
Whomever would like to go next.
Good afternoon, Chair Waldstreicher, or Temporary Chair Waldstreicher, and members of the committee. My name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland. This last November, Marylanders affirmed with their vote what legislators acknowledged with the decriminalization of marijuana in 2014. The criminalization of marijuana is a misuse of police resources and is rooted in racism. However, legalization alone does not mean an end to the disparate enforcement of marijuana laws or unnecessary interactions with the police. Marijuana odor stops and searches not only pose serious risks to people's Fourth Amendment rights, they enable racial profiling and dangerous unnecessary police interactions. In Maryland, the current legal standards, as Senator Carter pointed out, were made under decriminalization, and the court's interpretation of this matter has been inconsistent. That's why it's critical that the legislator must step in to ensure that the state's stance on this issue is consistent and, most importantly, rooted in the will of the people. Opponents will say that banning odor searches and odor stops and searches will impede law enforcement's ability to investigate incidents of impaired driving. That's simply not true. In the marijuana DUI context, just as with alcohol, an officer will need to have some evidence of impairment first before conducting a search or arrest. That is why odor of marijuana alone is insufficient to support that type of search. Public safety is the utmost importance for all of our communities, but diligent law enforcement can and should solve a crime using honest and evidence-based techniques without relying on pretextual bases like the odor of marijuana for stopping and searching people. Marylanders should not fear police interactions because of a lingering odor of a now legal substance, and legalization must do more than just allow for recreational use of marijuana or the state to profit. To be equitable, legalization must disincentivize the pretextual police searches and seizures and unnecessary police interactions. And lastly, I'll say Virginia has already done this, and I think Maryland can get it right too. For the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 51. Thank you.
Good afternoon. My name is Deborah Ramsey. I am a former Baltimore City Police Detective, Uniform Patrol, Criminal Investigation Division, Drug Enforcement Section, Internal Investigation, Community Policing Officer, and a former private investigator for the state of Maryland. I'm here to represent myself and also as a member of the Law Enforcement Action Partnership. It is a nonprofit organization that mission is to improve the relationships between police officers, law enforcement officers, and the community. And I cannot think of a better way of ensuring that we can have a more healthier and mutual relationship between police officer and the community. I am in support of this bill. I have also submitted my written testimony, but I would like to just say this. As a former police officer that had did many stops and searches and warrants and all that, the chain of custody, not unless you were born with an acute sense of smell, how can you use that as a possible probable cause in a situation where you cannot bag that, submit that, it's inaccurate, it's unreliable, and to use that as a measure. So I would just like to say that I'm in support of this bill, and I think this is one of the many ways in reforming police tactics to help relationships between the community and law enforcement officers to show good faith efforts that we do want to have that relationship again. Thank you.
Good afternoon. My name is Malcolm Ruff. I'm a trial lawyer with the Murphy firm in Baltimore, and I'm very honored to be before you guys today in support of Senate Bill 51. Our firm supports it because it calls for social equity and pushes our state to strive to achieve restorative justice for the most negatively affected by the unfair history of cannabis prohibition in this country. But we also support it because at its core, it works to properly and practically safeguard the sanctity of the fundamental right to the reasonable expectation of privacy under the Fourth Amendment. This bill would relieve the courts from having to split hairs in this counterintuitive and perilous legal vacuum that was painfully highlighted in the OAG's report that came out in December, and get rid of the guesswork. The critical question is how really practically should the legalization, or some would say the partial legalization of cannabis for adults, affect the Carroll Doctrine and the plain smell doctrine. The high courts have ruled under certain circumstances pursuant to these theories. All of their rulings that have said that these types of searches are viable have hinged on the fact that partial decriminalization did not render the odor of cannabis free from all criminal suspicion. But once we make marijuana legal for millions of adults in Maryland, the smell will no longer be indicative that criminal activity is probably afoot, or even that it's reasonably, that there's reasonable suspicion that criminal activity is occurring. So the legislature should proactively remove this contraband classification from marijuana altogether, because of doing otherwise would convert probable cause and reasonable articulable suspicion to essentially include a mere hunch or guesswork. So we would ask that this body favorably report back on this bill, and we are strongly in support of the bill.
Good afternoon. My name is Michelle Hall. I am an assistant public defender with the Office of the Public Defender. I've submitted quite lengthy written testimony in support of Senate Bill 51, and so I'll use my time orally to address just a few points. First and foremost, without this bill, the odor of marijuana will continue to be a pretextual basis for stops and searches. And quite frankly, without this bill, walking, driving, and existing while smelling like weed while black will become the new driving while black. This undermines not only legalization, but invites abuse of discretion for when and how police seek to investigate the odor of marijuana. Quite frankly, in my time as a public defender in Prince George's County, I had no cases arising based on the odor of marijuana on University of Maryland's campus, but quite a few cases arising in black neighborhoods and apartments in Prince George's County. Second, the failure to address this now will lead to another decade of litigation over what the odor of cannabis means in the Fourth Amendment context, just as what happened with decriminalization, and more importantly, based on the court's body of case law on this issue, so long as possession of any amount of cannabis remains crime or civil violation, the odor of marijuana alone may continue to support a stop of a person or a search of a vehicle. And I think that is unfair to Marylanders seeking to legally enjoy and use cannabis. Third, I'm sure that everyone in this room read or watched the video of the Memphis police officers beating Tyree Nichols to death in the street. And I think the question we all need to ask is, when should the police have the authority to forcibly stop, search, and detain someone and use escalating force against them? And I submit to you that in legalizing cannabis last fall, Marylanders did not envision a world where the odor of a now legal product to lead to those types of escalating circumstances. Legalization means nothing if its odor alone allows for the indiscriminate stopping and searching of our citizens. This is the most important bill related to cannabis that this General Assembly can pass this session, and we urge you to adopt a favorable report. Thank you.
So let's actually pause there and do 4, and then you can join the next panel if that's okay. I don't want to get too far before we allow questions. So Senator Folden, please go ahead.
Thank you, Mr. Chair. So I just wanted I was going to ask Senator Carter where the research, you gave a statistic about, I think 1 in 2 arrests were Marylanders. I'm just wondering where you pulled that research from when you.
I'm sorry.
You early on stated about some research data that research suggests that.
The 2 times more likely?
Yes.
That was from it's in here. I think it's the a report that NYU did.
Okay.
And the second one is from so that wasn't, the second one was globally, it was nationally, like twice as more likely, it wasn't in Maryland.
Yeah, I just wondering where those numbers came from.
I can find you the report, I don't
Okay.
have it here, but.
All right.
The
Thank
second one, the 67% was Maryland numbers, which is available on the GoCap website.
Okay, I appreciate that. And then, so I just want to know, like, I agree that there is problems with this, the passage and the legalization of recreational use of marijuana. It's created a lot of issues. And my concern is that what your bill does is it's, again, limiting certain investigative tools. For example, and I'm just going to take this as the simplest example I can. This doesn't have anything to do with, if a police officer's in behind a vehicle going down the road, there's a single occupant, can't tell, you can't tell who's in the vehicle, the windows are tinted, the only thing you can smell is right behind that vehicle you're driving, or you can see the number of occupants, but that's it. There's one occupant, and you smell the odor of marijuana coming from that car. Is that not probable cause to initiate a stop for driving while impaired?
No, it shouldn't be, and I'll tell you why. Because the citizens decided that we should legalize it, and so it should no longer be used as a reason for a stop. Now, if that were coupled with something else, if that were coupled with reckless driving, if that were coupled with weaving in and out of lanes, then that wouldn't be a problem. But the issue for this bill is that odor alone should not give reason probable cause.
So the strong odor coming from a car in front of a police officer, and it's one car in front of them, should not be used as reasonable articulable suspicion to initiate a stop on a product, much like alcohol would be used, for the potential concern that there's an impaired driver behind there, which by your statement is you don't think that should be the case. So I'll take it a step further, and then I'll say, we've passed this legislation, or this legislative the state has passed this, the recreational use. We're not talking about trunkfuls of marijuana. I'm talking about recreational use, marijuana, and that there is a recognized known that it does have, and it affects the behavior. It affects your perception reaction time. It affects you similar ways that alcohol does, right?
If there were reason to believe that there was someone that were driving impaired and there were symptoms or signs that were happening, this wouldn't affect it. This is simply saying, if you don't have any other reason to stop somebody just because you smell the odor, it's not enough.
Well, and this will be probably for a discussion for another day, but my point I was getting at is we've passed something and we have no measurable standard in the state, in the system, to be able to determine if someone's impaired by marijuana, if they're driving a 3,500, 3,800-pound projectile and impact somebody else. What's the measurable standard? Maryland doesn't have one. So we have to go to a catch-all charge. That's a problem. Like these people, there should be accountability. It's been passed. It's going to be recreational use is legalized. I get it. But we're putting the cart before the horse here. We're not allowing the proper things in place to be able to properly monitor and keep the roads safe. And we're trying to take away, this would take away another tool that, by your statement, of RAS for a stop, would it not?
Well, I want to take away using the odor of marijuana as a tool, as a pretext for other reasons to search vehicles and individuals, which the court has already said searching the individual because of the odor alone is already against the law in Maryland. So I want to use it as the pretext to go further in search a vehicle. This doesn't, I think that Ms. Emanuel testified about how this doesn't have anything to do with if there's some kind of reason to believe that the driver is driving impaired or some other thing. This is saying this alone. So if there's another reason to think something else is going on, I don't think there's any problem.
No, I appreciate it.
In fact, I think that there is an amendment that would clarify that because I want to make it clear that we're saying this isn't saying that there's no circumstance in the world where odor can't be a factor, but we're saying it can't be a standalone reason.
We can all agree that, maybe not, but I would like to think that there's times you can walk by a car and it's a pretty strong odor and it's probably more than the amount that's for recreational use because it's that strong.
But I think the issue, and I think former Officer Reynolds talked about this, is that it's unquantifiable. You can't determine based on the odor what the quantity is. That's not something you can determine.
Okay, I appreciate it. Thank you.
Senator Muse.
Thank you. If I can, Senator, just ask you a question, just for clarification. When you can, if you can find fine for me in writing the legal definition of the word solely. And I say that because this bill is based on or centered around, in my opinion, help me where I am wrong, solely. And if I am correct, and I know what it means by alone, by itself, just I know that, but I want to see if there's room to expand that based on the legal definition as it is used in this bill. And it does refer to where it is. And if I'm correct, then would it apply this way? Solely would apply this way if we all just left what do we all have there? Well, we have receptions down here. And we all had a drink. We all drank the same thing. And we all only had one drink.
Well, that's not here, but.
Well, yeah, I'm going to get to the other one, right? Let's say someone else had 3 or 4, but we're going to come out and we're going to smell the same, right? And solely would mean unless we're falling down the steps, unless we hit someone, unless we're speeding, and they can couple it with something else. But if they said we smell alcohol on your breath, then everybody in that reception would legally be able to be pulled over and by a police officer for anything. We all smell the same, so we would all. So obviously that's not it. But if you and I have had the same thing to drink, and you just drive home, and I'm all over the road at 100 miles an hour, absolutely, I expect someone to stop, find out how much I had to drink. I can't tell by smelling if you've had 5 drinks or 3 drinks because it all smells the same.
Correct.
I'm not an expert in drinking, but I know a lot about it. But anyway, my point is, my point is, how does solely apply here? And my friend just made an excellent point when he said, hey, if you're driving all over the place, or if you've just done something that we can we stop you? And I agree with him. We ought to be able to. So I'm struggling with solely.
So that's exactly it. You've already explained it. You've already hit the nail on the head. It's just, standalone reason. In order, if should we pass this law, and I would urge us to do so, because I think it's critically important. If the purpose of legalization was legalization and legalization for everyone, then we have to take into account our painful, troubling history of racial disparity in the way laws are enforced. And we have to take into account the fact that if we allow odor alone, it's still going to continue to be the same thing that we've had, which is more often than not people of color being pulled over, being searched, having their cars searched for no reason other than odor, and we haven't accomplished the goal of legalization. And so no one is suggesting that we should have a free-for-all of driving impaired all over the road. No, I'm saying if someone's driving impaired, you can stop them. If someone's, bobbing and weaving, you can stop them. There's a reason other than odor to do that. Thank you.
Cheers. Thank you.
Thank you. Any more questions for this panel? All right, seeing no questions, let's bring up our next panel, please. So please, sir, come on up. In addition, Martin Mitchell, Roberto Martinez, Charlotte Ahern, please.
Good afternoon, Vice Chair and members of the committee. The Maryland Office of the Public Defender respectfully requests that this committee issue a favorable report on SB 51 because this bill will not prevent DUI investigations. My name is Roberto Martinez, and I proudly serve as a co-supervisor for District Court in Montgomery County. In my capacity, I represent Maryland residents accused of misdemeanors and felonies. Through my representation, I have never encountered an impaired driving case attributed solely to the odor of marijuana. Most, if not all, impaired driving cases in Montgomery County follow the same investigative pattern. The National Highway Traffic Safety Administration, NHTSA, trains officers to observe the vehicle in motion, make personal contact, perform standard field sobriety tests, and further investigate the impaired driving at the station. This bill will not obstruct this practice. I have handled hundreds of DUIs, both alcohol-related and drug-related, and tried dozens of cases. Again, I have never tried an impaired driving case solely on the odor of marijuana, and that is not for want of investigation by Montgomery County law enforcement. To begin, officers look for traffic violations as signs of impairment: speeding, straddling lanes, turning too fast, turning too slow, stopping on a crosswalk, etc. They look for expired registrations, swerving, accidents. There is no reference to the odor alone. Once they find a reason to pull the car over, the officer observes the individual. They look for indicia of impairment: slurred speech, bloodshot watery eyes, slow reactions, and poor coordinations. Again, this bill does not limit that practice. I can discuss a little bit further, but I know that my time is running short. But in conclusion, this bill will not prevent investigations of DUI. And for those reasons, we strongly urge a favorable report on SB 51. Thank you.
Thank you, Mr. Martinez. Whomever would like to go next?
Hello. Thank you for this opportunity to testify on this bill, and thank you to members of the committee and for Senator Carter for this important legislation. My name is Charlotte Ahern. I'm a staff attorney with Maryland Legal Aid. The majority of my work focuses on workforce development and criminal record expungement. We have a unique viewpoint on this issue because although we don't deal with the criminal trial and aspect of prosecuting certain charges, we deal with the aftermath. So often, many of our clients tell us stories of being stopped and essentially harassed by certain police officers in relation to a traffic stop. Typically, when our clients come to us with marijuana charges or cannabis charges, there are varying issues that take place during that stop, that they feel like it's their first time ever being able to actually tell someone their story and what happened. And oftentimes, it seems as though the only reason that the person is being stopped is because of some discriminatory practice. As many people have mentioned, obviously, Marylanders have voted for cannabis, to legalize cannabis, and for this bill to be in existence, and if they were, in law, it completely contradicts the votes of your constituents. Your constituents voted for marijuana and cannabis to be legal. It would continue to criminalize Marylanders. It doesn't necessarily. I see that my time is up. Thank you very much. We urge a favorable report. Thank you.
Greetings, Chair and distinguished members of the committee. My name is Councilmember Martin Mitchell. I'm the at-large council member for the City of Laurel. Some coined me the cannabis councilman because I'm a medical patient and an advocate. But today I'm here testifying on behalf of the NAACP Maryland State Conference as a political action chair. I would like to offer strong support for the passage of SB 51 because it will take away the fishing tool from law enforcement in furthering the war on drugs, especially given that we overwhelmingly voted to legalize cannabis. I've heard assumptions. How about if I'm carrying CBD? Are they going to search my car then? CBD has been legal for several years. CBD, just like THC, has industrial medical benefits. I will share one story. I was a student at UMBC. I came home. I live in Laurel, very, very familiar with getting pulled over from the Laurel police. I would say probably 100 times before I was 25. But the thought is I came home, I went to the gas station on my way home to grab a Gatorade after wrestling practice, and, I was in the parking lot texting. The police officer came over, I think, after 5 minutes, and, then asked me a few questions, and, then said he smelled cannabis. Asked me, what I was doing. I was coming from wrestling practice, still wearing the wrestling gear and everything, coming from wrestling practice. So then I had to wait 45 minutes, for the dogs to come up. several more officers to come, right? Just one person in the gas station. And of course, they found no cannabis, they found no drugs, they found no guns, and they sent me on my way with the, hey, I apologize, sorry for wasting your time. But that's many people's stories, right? So I urge this deliberative body to pass SB 51 to ensure that Marylanders, don't have their rights violated because of an ambiguous smell of cannabis. Thank you.
Thank you. Seeing no questions for this panel, we'll move to the next panel. Professor Warnken, Rusty Carr, Karen Kaplan, Joanna Silver. This is the final in-person panel on behalf of the bill.
Good afternoon, members of the committee. I am Heather Warnken, the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in support of Senate Bill 51. Despite the belief that people should be able to move freely throughout society, the privacy rights enshrined in the Constitution and the Maryland Declaration of Rights are only as strong as the doctrines and laws that have developed around them. In the case of the Fourth Amendment, a long list of judicially crafted exceptions combine to allow the government to stop and search both people and their automobiles, even when they are engaged in lawful activities. The evidence is clear. For many well-documented reasons, this leads to the over-criminalization and invasion of the dignity and privacy rights of Black Marylanders and other persons of color at greatly disproportionate rates. While the statistics are staggering, the case law further demonstrates why weak privacy protections hurt poor communities of color the most. Specific cases included in our written testimony demonstrate why it is imperative for the legislature to act and not wait for the courts, which have been inconsistent and insufficient in addressing these issues alone. We also believe this bill to be in furtherance of, rather than a hindrance to public safety. This discretion that too often invites officers to manufacture justifications or include lies in testimony, a disturbingly pervasive phenomenon. Over-reliance on searches based on odor of a now legal substance can distract police from more effective and evidence-based policing strategies and true investigative work, also a hindrance to public safety. This is especially problematic given the abysmally low clearance rates in many jurisdictions throughout the state. For these reasons and more included in our written testimony, we urge a favorable report on Senate Bill 51. Thank you.
Thank you, members of the committee, and thank you, Senator Carter, for introducing this legislation. My name's Karen Kaplan, and I am a resident of District 18 in Silver Spring. On behalf of Jews United for Justice, I am speaking in support of SB 51. JUFJ organizes 6,000 Jewish Marylanders and allies from across the state in support of social, racial, and economic justice campaigns. We always like to begin with Jewish tradition, which makes it clear that we are obligated to respond when our core values are threatened, including the concept of Tselem Elohim, the idea that all people are created in the divine image and therefore are equally precious and worthy. We see the law as it currently stands, in which police officers may stop and search individuals without a search warrant merely because they claim to detect the odor of cannabis as a threat to that value. Maryland voters, as we've said many times today, have now chosen partial cannabis legalization. Surely it makes no sense for the odor associated with the use of a legal substance to be a gateway to entanglement with police and entanglement with the legal system. This is a problem of equity, because we know that Black and brown people are disproportionately stopped by police both nationwide and in our state. Crucially, there's no way for an officer to prove a smell, and of course no way to disprove it either, leaving the door to discriminatory pretextual stops wide open and leaving people of color significantly more likely to be harmed by police, something that happens far too often, especially during traffic stops. As has been said many times today, driving while under the influence of cannabis remains illegal, and this bill allows police officers to continue to investigate that. With this assured, there should be no reason not to protect Black and brown Marylanders from violence, from unnecessary police interactions, and from legal entanglement in a system that data makes clear is weighted against them. On behalf of Jews United for Justice, thanks so much for the opportunity to share our position, and we respectfully urge the committee to return a favorable report on SB 51. Thank you.
Thank you. My name is Joanna Silver, and I also live in District 18 in Silver Spring. I am testifying today on behalf of the Silver Spring Justice Coalition in support of Senate Bill 51. The odor of cannabis has long served as a pretext for officers to conduct stops, to prolong stops, and to search in the hopes that they will find evidence of some other criminal activity. We know, as many people have said today, that the weight of these invasive and often dehumanizing stops and searches falls most heavily on our Black and brown community members because they are the ones most frequently targeted. Where I live in Montgomery County, from 2018 to 2022, Black drivers were the targets of 31% of all traffic stops, despite being only 18% of our population. And Black drivers constituted 43% of all searches conducted during traffic stops. These racially biased stops and searches come at a great cost. In 2021, Black people were the targets of 54% of all use of force incidents by Montgomery County Police. I want to address two of the issues that opponents of this bill raise related to cannabis and traffic stops. First, pretext traffic stops are not a necessary crime-fighting tool. A report by the Montgomery County Policing Advisory Commission revealed that of all firearms seized in our county in a recent 3-year period, less than 5% were seized during traffic stops. And again, as everyone else has said earlier today, this law will not prevent officers from investigating drivers who are under the influence of cannabis. I want to add that in my day job, I've worked for the last 20 years as a public defender, primarily in the federal system. And I cannot remember a single case in which cannabis was the substance that caused my clients impaired driving. It is almost exclusively alcohol and PCP that we see in DUI cases. There is simply no excuse to continue the racist practice of odor-based stops and searches in Maryland. For these reasons, I respectfully urge you to issue a favorable report. Thank you.
Thank you so much. Questions for this panel?
We have one more.
Oh, I'm sorry. Go ahead.
Thank you, Vice Chair Waldstreicher. Thank you, members of the committee. My name is Rusty Carr. I live in Mount Airy and District 4. And I rise in support of this bill with amendments. And I'm going to start by reading you a little passage from this book written by Dr. Patricia Fry, who's from Tacoma Park. It is referring to a Harper's Magazine interview in 1994 with Nixon's domestic policy advisor, John Ehrlichman. And he says, "You want to know what this was really all about? The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and Black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or Black. But by getting the public to associate the hippies with marijuana and the Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. Ladies and gentlemen, I hold in front of you hemp. It's also called cannabis, but this is legal and it's non-impairing. I invite you to smell it. It smells no different than marijuana because marijuana, hemp, and cannabis are all the same thing. You can smoke this and not get impaired, and therefore I urge you to amend the bill to remove the allowance of allowing the police to search within the reach of the driver, which will still allow the racial enforcement and pretextual stops. Thank you very much. If you have questions, I will allow you to smell if you'd like, and I have samples to compare if you like. Thank you.
All right. Any questions for this panel? All right. Seeing no questions from the senators, thank you all for being here. We'll now move to the opponents of the bill. Steve Kroll, Scott Schellenberger, David Daggett, Mike Lewis.
Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. Just need to make sure nobody left anything up here for me to accidentally pick up. Again, here we are, and I'm in opposition to Senate Bill 51 because once again we are trying to codify what is been interpreted by the courts as probable cause to investigate a crime. Maryland has for decades allowed the courts to set the standards of what constitutes probable cause for a search. And once again, we're talking about a very specific amendment, now the Fourth Amendment, against unreasonable searches and seizures. And that's why this is very important that it be left to the courts, because we're talking about interpreting the Constitution. And, you know, it may have been said that I misinterpreted what was being dealt with in consent, but I would take a look at page 2, letter C. It says, evidence discovered or obtained in violation of this section, including evidence discovered or obtained with consent, is not admissible in a trial, a hearing, or other proceedings. So that means we are now taking away an entire area of the law where even if you consented to the search, this law is saying, no, can't use it. No, you can't. Now, the question keeps coming back, you know, this is all changed because now suddenly marijuana or cannabis is going to be legal. Have we ever developed Fourth Amendment rules of arrest and search and probable cause around a legal substance before? Oh, that's right, alcohol. We have tons of cases about how we interpret and allow police to proceed in cases for a very legal substance, and that substance is alcohol. I suggest that we allow the courts to do the same thing with marijuana once it officially becomes legal. The courts have already worked on this. 2017, Robinson versus State, odor of marijuana is enough to establish probable cause to search a vehicle, even in light of decriminalization. We'll see what happens now. Paccio versus State, 2019, odor of marijuana and observation of marijuana joint in the vehicle is probable cause to search the vehicle, but not search the person. Lewis versus State, need more than just the odor for probable cause to make an arrest of a person and conduct a search. So the courts have already been making rules surrounding these type of searches. All that's going to happen in July is one more change, and that is the legalization. And I believe it's the courts that should decide because they are interpreting the Constitution rather than a statute. Thank you very much.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is David Daggett. I'm here as I've been a prosecutor for over 30 years, currently with the Maryland State's Attorney Association, but I'm also here as a parent and a citizen. Every state across the country, and I think there's 21 or 22 that have legalized cannabis, have seen a marked uptick in fatalities, in vehicular fatalities related to alcohol and or cannabis impaired driving. Usually it's a combination of the two. There's a statute right now that that Maryland has. I know there's language to go in that says a person, an occupant of a vehicle, may not smoke cannabis in a vehicle. The penalty for that is $25. If this crime, if this bill passes, that's an unenforceable statute because you'd never be able, unless you actually saw the joint or the cannabis that was being smoked actually in the ashtray or something like that, you wouldn't be able to search the vehicle to find it. Therefore, you'd never be able to prove that particular violation. You couldn't do it. It's, again, as I speak, it has to do with traffic safety, and I'm just so terribly concerned about the number of fatalities that'll go up. We have enough fatal crashes across the country and in Maryland related to alcohol. If you start legalizing and allow people to smoke cannabis in the vehicle, it's only going to make it worse. One of the things I see, Michigan, for instance, and while I'm not advocating or not supporting this bill in any way, I would say Michigan differentiates and distinguishes between the smell of burnt cannabis and the smell of raw cannabis. The smell of raw cannabis in Michigan, you cannot search a vehicle. The smell of burnt cannabis, you can, because they do not want people smoking in a vehicle because of the safety concerns. And I see I have no time left, and so with that, I would urge an unfavorable report. Thank you.
Mr. Chair, Mr. Vice Chair, distinguished members of the committee. My name is Mike Lewis. I'm a sheriff of Wycomico County, Maryland. I'm here to represent the Maryland Sheriff's Association and the Maryland Chiefs of Police Association in our opposition to Senate Bill 51. This bill would certainly prohibit the odor of cannabis alone from providing either reasonable, articulable suspicion or probable cause to search a motor vehicle. Currently, possession of cannabis in any amount is illegal in Maryland, subject to rare exceptions, such as being a lawful holder of a medical cannabis card. Beginning on July 1st of 2023, this year, individuals will be able to lawfully possess up to 1.5 ounces of cannabis. Possession of any amount of cannabis beyond that will continue to be illegal in the state of Maryland, with criminal penalties assessed to more than 2.5 ounces. Possession of cannabis by individuals under the age of 21 will also continue to be illegal in the state of Maryland, regardless of the amount. Recognizing that cannabis remains presumptively contraband, Maryland's Court of Appeals, now the Supreme Court of the state of Maryland, has held that the odor of cannabis alone provides a law enforcement officer with probable cause to search a vehicle for contraband and reasonable articulable suspicion to briefly detain to investigate if a criminal offense is occurring. As a 38-year veteran of law enforcement, 22 years as a Maryland State Trooper, now in my 5th term as Sheriff of Wycomico County, I can tell you firsthand that I cannot distinguish based on the odor of marijuana coming from a car, whether there's an ounce in that car, an 8-ball in that car, or 100 pounds in that car. I can tell you we frequently have stopped automobiles with several hundred pounds of marijuana in the car based on a probable cause search based on the overwhelming odor of marijuana coming from the vehicle. I've also conducted a probable cause search many times, in fact, hundreds of times, based on the odor of marijuana coming out of the car, and found considerably smaller amounts of marijuana. Based on that roadside investigation, depending on how much we found, we would send the motorists on their way in many cases if we felt they had not been driving under the influence of drugs. But sadly, as my colleague to the right just testified, Mr. Daggett, fatalities across this country have skyrocketed, including in the state of Maryland. Last year, the state of Delaware experienced a 42 high record of fatalities in my neighboring county of Sussex County, Delaware. We have to be able to conduct a roadside investigation based on that odor to determine if, in fact, they are driving under the influence of drugs or evidence of a much larger crime exists. Thank you all very much. I hope you issue an unfavorable report on this legislation. Thank you.
Mr. Chairman, Mr. Vice Chairman, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984 in opposition to an unfavorable report asking in Senate Bill 51. I will incorporate Mr. Daggett's testimony, Mr. Schellenberger's testimony, and Sheriff's testimony, and ask for an unfavorable report. Just to say one thing, they are exactly right about the statistics about the increase in deaths when it comes to cars and marijuana. And that should be on each one of yours mind when you take a look at this bill. We don't want that to happen. We'd ask for an unfavorable report as to Senate Bill 51. Thank you.
Thank you. Mr. Chairman, my questions are for Mr. Daggett. Mr. Daggett, the proponents of the bill appeared to testify here today that the nature of the suspicion, whether it was legal or illegal, was determinative. I want to call back to the previous bill where you referenced someone in a red shirt and blue jeans. Is the nature of the suspicion being legal or illegal determinative when it comes to the reasonableness of a Terry stop?
In order to conduct a Terry stop, you have to have reasonable suspicion that a crime has either just been committed, is currently being committed, or is about to be committed. So that's why you have to have a reasonable suspicion. So when it comes to this, the offense would be smoking in a vehicle. Now, it's only a misdemeanor, and it's only a citation. It's a $25 fine. It still is an offense. Unfortunately, you cannot search in the way the statute, the way the law in Maryland is. You cannot search a person for a citation because you can't arrest them. So in this particular, we'd be unable to enforce that law against smoking in a vehicle because you wouldn't be able to search it. I guess unless you saw it, unless you actually saw it, and anybody that's smoking in a vehicle, all they have to do is just put it out, put it underneath the seat, swallow it, throw it out the window, whatever it might be. You would be unable to search the vehicle. You could never prove that offense. So therefore, it's a wasted statute, quite frankly.
Alcohol is a legal substance, but could be used as the basis for reasonable suspicion that a crime had occurred.
It could be. It could be used for, in the sense of again, it depends on whether you're talking about the driver or passenger.
In reasonable suspicion, well, yes, but just outside of a car context, a knife is a legal thing to have, but a knife in certain circumstances could be reasonable suspicion that a crime had occurred.
Absolutely, depending on what the circumstances were, certainly. I mean,
That's right. And in your previous example, you said there was a suspect wearing a red shirt and jeans. There's nothing criminal about wearing a red shirt and jeans, but under certain factual circumstances, red shirt and jeans could be reasonable suspicious to continue an investigation.
If that's what the report came, and that's the information that you had, it certainly could be.
So just going back to vehicles, if there is an odor in the vehicle, the odor could be evidence that the amount is below the personal amount. Is that correct?
That's correct.
But the odor could also be indicative that the amount was enough to suffice for possession with the intent to distribute.
That's correct.
And in fact, the odor could be indicative, as the officer indicated, that it could be sufficient amount to be in our kingpin statute.
Absolutely could be.
Okay, I think I understand. Thank you.
Thank you, Mr. Chair. To the gentleman, either Wycomico or, sir, that you just were up, you both quoted fatalities that, and I think that you linked them to post-cannabis legalization. Where'd you get the data? Can you elaborate on that?
I can provide you all that data if I could have it done to you by early next week. It's NHTSA data. It's from started in Colorado, obviously.
But is it, so it's post-legalization of cannabis, you're attributing it to that and not to NHTSA is I know, I'm familiar with it with DUI.
No, but I mean, obviously, we've had DUI fatalities going back since cars were invented.
Right.
There's no question about that. But every state, and I think there are 21 or 22, every state that has legalized cannabis, personally used cannabis, has experienced an uptake in fatalities based upon drug impaired, and it's usually, and it's a combination of cannabis by itself or cannabis in relation with alcohol. But every state that's done it has increased, so there's certainly a correlation between people's, I mean, I think we all understand if you smoke enough cannabis, you could get impaired, and that's not safe to be driving like that. So, but every state that's legalized it has experienced the uptake. And if you'd like those numbers, I can certainly get them to you. I mean, that's not a.
Well, I can check them because I'm familiar with that. I look at it a lot for other stuff. So, thank you.
Okay, sure.
In response to, I'm sorry, I keep turning on, I shouldn't be doing. Do you, sir, thank you. The question that you just answered, and I probably no doubt it's gone up. Is there a way to relate that directly back to cannabis being found in someone's system? And so we have found of the fatal accidents and or bad accidents, the number's gone up by 10%, and we have been able to attribute that to cannabis in 8%. I'm just throwing out numbers, so that I just want to be able to say, yes, they're right. It's definitely as a result. It's not anecdotal. It is definitely a scientific way of determining and if they've done it, who, as a driver of those accidents that caused the numbers to go up, how do we absolutely say it was attributed to cannabis and the change in the law?
So, Senator, that's another problem with cannabis.
That's what I thought. You cannot determine it.
It's because there is no test like
Correct.
a breathalyzer
Correct.
that can quantify how it's affecting your system because it stays in your system for so long. And so I do know that there are some companies around the country who are trying to develop a test to see if they can equate it to a breathalyzer, but so far they've all been unsuccessful, and it's mainly because it stays in your system so long. So that is an additional problem with cannabis, which is why the bill that you all put through that said smoking in a car is a crime, or is illegal, not allowed, because that was very important to add. But that is another additional problem. But what you can say when you look at the statistics that Mr. Davitt was referring to is that there was an increase in each of the states that, that legalized cannabis, and nothing else in the law had changed. They didn't change their DUI laws. They didn't lower the numbers. So logically, you can attribute it. There's just no scientific way to attribute it.
Thank you very much. And again, good seeing you again, and welcome back.
It's been a long time.
To you. Yes.
Nice to see you over here.
Good to see you.
You used to
And
be
all
on
of
that
my
side,
friends.
right?
Yes, and all of you. Thank you. And as you know, I want to get to the truth. I want to know, because everything we do down here is going to determine whether life is lost, maybe, or someone's life is saved. And this is an important issue for me, and also are the civil rights of everyone. And with all the stats that I'm seeing, it shows that the one definite here that we know about with scientific evidence to prove it is that, as sorry as I am to have to say it, and I've heard it all the time, and it's true, black and brown people are the ones whose lives are changed by this in many ways, all the way around. And I'm just trying to find a balance for that, and I think you've helped me to do that. Yes.
Well, my response would be that when a police officer pulls someone over for speeding and smells an odor of marijuana, they aren't making different decisions based upon the color of someone's skin. And
then how do we get to these statistics that are proven and are true? I don't either. That's why.
I do not question the statistics.
Okay, thank you. Thank you, Senator Carter, for letting me in. Thank you, Mr. Chair.
I wanted to follow up on the Senator Musin and the Vice Chair's line of questioning, because this is where we get kind of, as we evolve and we're moving toward, the legalization of cannabis, recreational cannabis. So July 1st is an important date, but you get up to 2.5 ounces, which is just a citation. And so where I struggle with this, like obviously I want to err on the side of public safety always. Where I struggle is that if we are legalizing a certain amount, you're searching based on something that's legal. And so it's a weird kind of place to be. It's a weird space because there's no fruit of the poisonous tree at this point, because you find a gun or something else, and, I talked to our state's attorneys, my state's attorney, and we've had 66% increase in recovery of guns last month than the same time last year. And a lot of them are as a result of stops based on smell. So and I'm going to ask for the data to back this up. But where I run into trouble is because it's a weird legal space, because it's based on the search is based on something that I'm legally, allowed to have.
And that's why I gave you the example of alcohol. You're legally allowed to have alcohol. You're legally allowed to have alcohol in your system up to a point. And so that's why, as we heard from our law enforcement friends, it has to be coupled with other observations. So, your classic DUI, I pulled him over for speeding, I smelled alcohol, he was disheveled,
But is that true in all cases? Because, look, of course in alcohol you could smell it on my breath, but if I was carrying alcohol, you could never smell it if it was in a sealed container. Whereas if I'm carrying cannabis and whatever, you're going to smell that.
More likely than not, you are.
And that's the space where I'm operating, where I'm, struggling with this. So. if you wish to opine, that'd be great. If not,
No,
yeah.
I understand.
Okay. All right, Senator West.
Thank you, Mr. Chair. Mr. Schellenberger, do you know what percentage of illegal gun seizures come from routine traffic stops?
I do not know the specific number, but I know that there are quite a few. I think Senator Smith is absolutely correct. You do get a lot of guns based upon traffic stops. A lot of guns.
Thank you.
Guns are confiscated through stops, but 83% are confiscated in other ways, but very few stops for marijuana or alcohol will lead to a gun arrest, and the stats that I saw were 5%.
Okay. So we'll follow up on that. But again, I mean, we'll continue the discussion, but it's.
Thank you.
I'm still, yes, sir.
If I could, sir, you had mentioned how many guns were found. As the sheriff of Wycomico County, like any law enforcement executive, I'm the recipient of a daily shooting report that comes out from Maryland's Coordinated Analysis Center. And what it does, it captures every shooting that occurs from Ocean City, Maryland, all the way to Deep Creek Lake. And 95% of the time, the bulk of the shootings are in the Baltimore metro area and PG County. And I can tell you that the overwhelming majority of those victims that are being shot and the suspects that are being arrested are found in possession of weapons that are commingled with marijuana, almost always. And oftentimes there are felonious amounts of marijuana recovered from the underwear or the pockets of the victims at the University of Maryland Shock Trauma. And on a weekly basis, the Baltimore City Police Department has to go into shock trauma to recover these weapons that are found when they start cutting the clothing off these individuals in the hospital. And I can tell you the overwhelming majority of the handguns that are found in Wycomico County are found on traffic stops. And we had a traffic stop just the other night of a pickup truck right on U.S. Route 13 in the city of Salisbury. And based on the strong odor of marijuana coming out of the pickup truck, a probable cause search was conducted and 3.5 kilograms of cocaine were found inside that vehicle. But that harkens back to an April 1999 traffic stop I made on I-70 out in Frederick County, where I conducted a probable cause search of 2 Southern California blonde-haired, blue-eyed men coming to Washington, D.C. from California. Based on the odor of marijuana, searched their vehicle, and I found a fabricated compartment constructed in the floor with 87 pounds of cocaine. So I can tell you, oftentimes, there are very significant felony arrests that come out of a probable cause search based on the odor of marijuana. And as a 38-year veteran, I feel we have a duty and a responsibility as the eyes and ears of everybody in this room to investigate, to conduct a roadside investigation to either confirm or dispel our suspicion based on that odor of marijuana.
This too, and thank you for what you do.
Yes, sir.
Thank you. I'm not a professional statistical analyst, but let me ask this. You say 95% of those in automobiles that you stop. Now,
No, 95% of the guns that we recover do come from traffic stops.
they come from traffic.
Yes, sir.
Now, the other sources from which you can confiscate guns may come from a number of other areas.
Yes, sir.
It may come from homes that you go into. It may come from those who are actually manufacturing illegal guns or bringing illegal guns in. When you take that 95%, and you compare that to other ways that, to all the other ways that you confiscate guns, I think that is what the statistics were saying, 5% of all of the other ways that you can confiscate guns, and they were saying that that was a very, not insignificant. Nothing is that we're talking about is insignificant, but not enough to kind of change my mind about the bill based on the numbers that I'm hearing. So, do you know if that 95% is a part of the whole? Is that the only place? And I know this is just a example. Can't be true, but if that's not the only way that you confiscate guns, when you put in all the other ways, most of them through homes, most of them through people that you stop.
Yes, sir.
Who are committing crimes in the street. not marijuana related at all?
Uh-uh.
Not cannabis related?
No, sir.
At all? That's not 95% of where you confiscate guns from?
No, sir. A prime example, on a Sunday night several months ago, we received a call at the Wycombe County Sheriff's Office that there was an armed individual at an apartment complex down in Pittsfield, Maryland, on the east side of the county towards Ocean City. We sent 2 deputies down there. They rode through the parking lot. Didn't see anyone matching the description. The description was a blonde-haired guy, had tattoos on his face, little skinny kid. They didn't see him at all. One of my deputies decided to go back in the area about 2 minutes later and spotted him. He had a knapsack on his back. Our information was he was armed, but we have a duty to investigate. And as the deputy pulled up in his tow, the suspect took off running. The deputy gave foot pursuit, gave several commands for him to stop. The deputy was considerably faster than the kid. When I say kid, he was 19 years old. And the deputy ordered him to stop multiple times, and the suspect turned and shot my deputy in the head, killed him instantaneously, dropped him in his tracks. Deputy Glenn Hillier left behind a wife and 3 kids. This kid had an extensive record, not just for other crimes, but including marijuana distribution. And in Baltimore City had been convicted of an armed robbery of a McDonald's with a semi-automatic handgun that he pointed at the clerk in McDonald's, and when arrested by detectives and interviewed, they said, "Why did you have to point the gun at this girl?" It was very traumatizing. His response was, "Because I can. Because I can." But this kid had an extensive criminal record, 29 previous contacts with law enforcement. He was only 19 years old. Several of those were marijuana related. None were cocaine related. None were heroin related, but they were marijuana related, and he was armed with a semi-automatic handgun with a laser sight and took the life of my deputy instantaneously.
Thank you.
Yes, sir.
Thank you.
Thank you.
And the reason we are all struggling so much is why we shouldn't have a statute and let the courts decide.
We've had a little bit of tension going on with the judiciary the last couple of days here. No, I'm kidding. But
I take that back then.
Yeah. Could we have, there's a difference between correlation and causation, and so it would be really helpful if we could get some of that information from you all. And I'll do the same with my county as well, because, that would really help us in our decision making. So,
yes,
thanks. Thank you.
Thank you, Mr. Chair.
Thank you very much. Thank you all. All right, we'll now switch to our virtual panel, and we'll start off with Ms. Abdul Malik. Sorry about the delay there. Welcome. If you can unmute yourself, we're ready to hear your testimony.
Yes, thank you for having me on. I really appreciate the happy accident of going last, because I have some testimony that directly address the opposing panel that was just up. So my experience comes from, I'm a Maryland resident. I am on the board of Maryland Normal. I serve as the event coordinator and liaison. I also have served 4 years in the Maryland market as a cannabis regimen specialist. So I help people hammer out their cannabis routines, making changes when necessary. I've gotten several of them off of completely their medications. So I definitely am a proponent and advocate of its medicinal value. I would like to tap into my experience and share that with my experience working with patients, many of them do not have the privilege of smoking in their homes due to residential restrictions, lease agreements, children within the home, family members that don't like the smell are affected by the smell because of their own personal health issues. And so it's just not always possible to smoke somewhere else. So a lot of people, including myself, retreat to their cars, because currently I'm in a living situation where I cannot have cannabis in the house. A mason jar, which is supposedly airtight, is not enough to keep the smell from permeating throughout the house. So addressing the issue of the smell of marijuana leading to how much you have in the car, like that's just all because if I have 7 grams, that 7 grams is going to smell just as loud as the 1.5 pounds or the 2.5, 1.5 ounces or 2.5 ounces that, is going to be legal to have once the bill goes live on the 1st. So I would just like to share that it's really asinine to go based off of odor alone to have that be the reason as a probable cause, because it's not. Many people retreat to their cars for privacy, for protection from the elements, for warmth. nosy neighbors. They don't want everybody all up in their stuff like a car. Like I said, you walk into my car right now, I will tell you happily and gladly, it smells like a whole pound in there. There isn't, but that's what it smells like. And that's not indicative of the amount that I have, or if I have other drugs, or if I have a weapon and any of that thing, or any of those other things. This also runs into the issue of cannabis medical card holders being able to have a gun. Like, these things are not, they do not correlate the way it's being portrayed. While I forget the exact phrase, but he said correlation is not causation. So we have to really get into, the specifics on this and not just go off of odor alone to say, oh, I smell odor, so the person must have cocaine or weapons in the car. It's
Excellent. Thank you very much for your
Thank
testimony.
you.
Thank you, and thank you for your patience. All right.
Thank you.
All right. We will now hear from Ms. Wilkes. You're up. Welcome.
Yes, hello. Thank you for having me. First, I want to say I'm glad that I got to go last, because I definitely was going to lead with a different kind of testimony. But I just want to say that if the police need what should be an illegal tactic to use something that is legal in order for them to catch people doing other things that are illegal, then maybe they should be trained in different ways to do their job better. Because in the fall, overwhelmingly majority of Maryland residents voted to legalize marijuana, right? And I've heard a lot of testimony and a lot of questions about correlating this with like alcohol and driving under the influence of alcohol. The difference between alcohol being legalized and weed being legalized is that you can have weed legally in your car in an open container or a sealed container. Alcohol, you cannot have it in your car if it's in an open container, which makes the two different. I also want to say that smell is subjective and it cannot be proven in court. I have been on the opposite end of that, where I was pulled over by a police officer and told that my car smelled like marijuana, even though I had just came from taking a drug test and provided a negative marijuana drug test to the police officer. I was searched on the side of the road. The most intimate parts of my body were touched by a stranger in public. A canine dog was dispatched out. And you know what they told me? Oh, we mistook the smell of marijuana for a banana peel. I think that moving on with this with an unfavorable report would be anti-Black, racist, and irresponsible based off of the racial disparities of those who are deeply impacted and directly impacted by being stopped and searched based off of solely the odor of marijuana. And I think that this needs to be taken in consideration. And as I said before, if we have to use a tactic that should be obsolete and illegal to find out what other illegal activities are going on, then the problem isn't the odor of marijuana. The problem is the effectiveness of the police. Thank you.
All right. Thank you, Ms. Wilkes. We'll now hear from Mr. Green. You're up. Welcome. Hold on. Let's go ahead and unmute you. Can you unmute? I'm sorry. There we go.
Thank you, everyone. My name is Rondez Green, and I am appearing in support of SB 51. I am a student at Bowie State University, HBCU in Prince George's County, and I'm happy to have access virtually here. This is a wonderful point of accessibility, and I just wanted to highlight that as we're in class. I recognize that Marylanders voted overwhelmingly to decriminalize cannabis last year, and so to me, it is important that the legislature is consistent in their promises to their constituents. So when I think about these practices that are invasive and dehumanizing, or some words that I heard used to describe these stops, unnecessary, a fishing tool, and a remnant of the war on drugs, I align with that completely. And I think that it should be abolished. There's no reason for us to continue this practice. I don't want to make it about myself, because we heard of a bunch of other wonderful stories, not wonderful stories, horrible stories of other people and their experiences in this racist system, this racist practice. I want to highlight specifically Councilman Mitchell being stopped, not having anything. It's a complete waste of your time. On the 4th of July in 2021, I went to Havre de Grace, Maryland, like I've done every year for my entire life, to celebrate Independence Day with my family and friends. I showed up, stopped at my mom's house. Nobody was home. I walked the dogs, and I walked down to Tidings Park like I always do every single year. It's the middle of the day. I have a book in my hand, this one actually. I walk up to the bench at Tidings Park and I sit down, and moments later, by the way, the park's filled with people. Moments later, 2 officers walk up on either side of me, stop right in front of me. The only guess that I have at this point is maybe they smelled something, but I don't have anything on me. They proceed to question me, they proceed to get really aggressive, and they try to instigate a reaction out of me that I'm not going to give them. I was poised, I responded appropriately, but I also have this audience of everybody at Tidings Park watching me be questioned by the police on a bench as I'm reading a book by myself. So if I were a different person, if I were in a different situation, maybe I would have ran. Maybe I would have responded a bit more negatively to this hostile interaction, this unnecessary, this invasive and dehumanizing interaction that I also experience on the road, when I'm going into grocery stores, when I'm going into gas stations. The smell of marijuana is unquantifiable. You cannot quantify how much we may or may not have.
Mr. Green.
If we just smoked, if we're about to smoke, there's no way to know. And I think that this is unnecessary and needs to end. Thank you.
Excellent. Thank you very much. All right, we'll now hear from Ms. Tyree.
Good afternoon, Chairman Smith and JPR. I'm Nikki Tyree, Executive Director for the League of Women Voters of Maryland. We thank Senator Carter for this bill. The League believes in having the most robust and people-centric democracy possible, but that is hard to achieve when certain communities are continuously and disproportionately targeted and affected by out-of-control policing. We believe this bill is the right step on a still very long path to equity, and we cannot have a true democracy when we still have mechanisms in place that allow further marginalization of Maryland's minority communities. You have our written testimony, and we urge a favorable report. Thank you.
Excellent. Seeing no questions from the committee, we will now switch to the opposition panel, the opposition virtual panel. Mr. McAvoy, you're up.
Thank you so much, committee. I appreciate you hearing my testimony. No, it's been a long day. I want to start by saying that the focus on presuming that all police are horrible is what's at the core of this bill. And as I've debated this in the city, where I hear flawed statements that every time a stop happens, it's because of skin color, or because I shouldn't even be able to be pulled over for weed. Folks, this isn't weed. This THC product that is being used now is 80 to 95% pure. Arguing for drug driving or inhibiting road safety, like this bill would do, SB 151, is irresponsible and immature. And I highlight for the person who brought up the Constitution earlier, much earlier, this bill ignores the Constitution, supremacy clause. Presuming that all police are horrible or doing their jobs wrong in Baltimore City is a tired trope. And it's noteworthy because not one example, not one case was given this entire long hearing about a case where this has actually happened, other than gaslighting tropes and nebulous, unnamed statistics. So regardless of what the MoCo OPD says, SB 51 will cause less checks for impaired driving and additional deaths. And in fact, House Judiciary, when they're reviewing HB 1 and 837 last year, their delegates acknowledged this will bring more deaths. They offered zero solutions. Officers are trained by weed. Montgomery County should know this. They do. This bill is rushing things. It's putting the cart before the horse when we don't have any way of actually checking the potency. It's a tool in the toolbox. I'm glad that all those people brought up the cases where serious drugs and guns were brought. You can look on any state police, Maryland State Police website, and see significant cases with drugs and guns and cash. There was one on I-95 last year that was very large. So to Senator Muse's point, I don't know where AAA is getting their data, but they rank marijuana deaths as number 2 cause now in Maryland. That's why they testified against HB 1 and 837 2 years in a row, I believe it is. And we are seeing significant increased deaths. This is not a time.
Mr. McAvoy.
Okay, I'll wrap it up. I thank you so much for listening. Thank you.
Excellent. Thank you very much. All right, seeing no questions from the committee, that'll conclude the testimony and the hearing for Senate Bill 51. Thank you, Senator Carter. We'll now move on to Senate Bill 88. Senator Wallstreicher.
Thank you, Mr. Chairman, members of the committee, and my panel, if I might be outside, and they are welcome to come in and join for Senate Bill 88. This past year, Mr. Chairman, there were two big developments in cannabis policy. First, President Biden announced a federal pardon for everyone who has been convicted of simple possession of marijuana. Second, as you've heard throughout today, Maryland voters approved a ballot measure to legalize small amounts of adult use cannabis. Maryland joined several states across the country in doing so. No doubt passage of this ballot measure was a great step forward, but there is still more work to be done. President Biden's historic pardon applies only to those who have federal convictions. The overwhelming majority of simple possession convictions are at the state level. As you may know, this administration here in Maryland has indicated that it may follow President Biden's lead and pardon all Marylanders who have simple possession of marijuana convictions. That got me curious about a question that is the core of this legislation, Senate Bill 88. And the question is this: does a pardoned offense automatically get expunged? If the answer is no, this could result in an untenable policy result. Imagine having a simple possession of marijuana conviction from 2 decades ago. You then receive a full pardon from the governor of the state of Maryland. Later, you apply for a job believing your record to be clear. But the employer brings up the conviction in an interview, and suddenly your job prospects are dramatically dimmed. In my research, that's exactly what I found. In other words, Maryland pardons don't automatically trigger expungements. They are separate concepts and don't travel together. And that will cause unnecessary pain and confusion when it comes to those applying for employment, credit, or housing. Senate Bill 88 would resolve this issue by automatically expunging the records of all Marylanders who are pardoned by the governor for simple possession of marijuana convictions, and only such convictions. Under this bill, individuals would be granted automatic relief. They would not have to wait years to see if they are eligible, and they wouldn't need to petition a court for that expungement. In sum, members of this committee, Mr. Chairman, the Pardons for Simple Possession of Cannabis Act of 2023 is a narrow, restorative bill that rationalizes our pardon policy with our expungement policy. For these reasons, I respectfully urge a favorable report on Senate Bill 88.
Good afternoon. Good afternoon, members of the committee. Good afternoon, Chairman Smith. Thank you for the opportunity to appear in favor of SB 88, proposing the automatic expungement of certain pardoned convictions for marijuana possession after a full and unconditional pardon by the governor. I'm Deborah Carr, the CEO for Job Opportunities Task Force. We're a nonprofit organization conducting job training, job placement, advocacy, and public education to better the employment prospects of low-income and low-wage workers here in the state of Maryland. Our work paves the way to financial stability and improves the lives of individuals and strengthens communities and families. We've trained nearly 2,000 Baltimore City residents, and we know the impact of a criminal record on people's employment prospects. The impact of a criminal record prevents individuals from participating in the state's economy. I want to highlight the potential scope and the impact of a criminal record on someone seeking a job. In Maryland, an estimated 1.5 million residents have a criminal record. Of working age Marylanders, 25% of them have a criminal record. 70% of the employers in this state will conduct a background check on all of their job applicants and make decisions about employment based on what they find. I will highlight that marijuana arrests in particular account for about a quarter of all drug arrests in the state. That's based on 2019 data. And of those arrests, half are of people of color, specifically African Americans or blacks. One national report found that there were 1,100 collateral consequences to having a criminal record. Not only does it affect employment, it affects housing, education, access to public assistance, and the ability to obtain certain occupational licenses. JOTF supports measures that move people from unemployment into the workforce. We support measures that move people from low wage, low skill into higher paying jobs. Therefore, we support SB 88. We thank you for considering this, and we hope you issue a favorable report.
Thank you, Ms. Carr. All right, we'll have Ms. Hilliard. And is Ms. Hanson here? Welcome.
Good afternoon, Chair, remaining members of the committee. You've already heard extensively about the import of expungement from community members, advocates, and other attorneys from the Office of the Public Defender. I'm really just up here to say we are very grateful for Senator Waldstreicher to introduce this bill. We are very excited about any opportunity to increase the availability of automatic expungement, especially in light of our progress moving forward with legalizing marijuana. Thank you for your time. I'll see you later.
Good to see you again. Thanks a lot. All right. With that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we should have someone on Zoom. Is it Vince McAvoy? He's not in the room. Oh, he finally skipped one. All right. Oh, sure. Do you have questions? I'm sorry. Yeah, I'm sorry. Pardon. Senator West has a question for the proponents.
Thanks. And this question's for the sponsor. Of course, this is the same bill we've seen for a couple of years, and the judiciary always has come in and said it's going to be impossible for them to comply. They have submitted a memorandum in this case, which appears to be very similar to the memos that they submitted previously, saying that it's so hard, it would be so hard to separate a charge from marijuana out of a bill, a case with multiple charges, that the compliance would be, they frankly say it would be impossible. So how do you respond to that?
So two quick things, Senator. This is the first year that this bill is in, and is directly tied to the president's mass pardon of people with simple possession of marijuana convictions. I believe we should do the same in Maryland. I imagine over the course of the next 4 years, we will do the same here in Maryland. And so the underlying point of the bill is the disconnect. As lawyers, we all, or as many of us are lawyers, and we know the difference, but that pardon and expungements are different. But most people who are receiving this pardon won't know about that difference and will walk around believing their records have been cleared by the governor, and then unfortunately, that illusion will be rudely destroyed when they go to apply for housing credit or any other thing where a criminal records check is done. With regards to the administrative office of the courts, I have read their memo, and I've spoken to them by phone. And so I want to bifurcate between two concepts. Something that is technically impossible because of the computer system that the courts run, and something that is laborious and difficult. So the courts have indicated to me that this is technically feasible, that within their current computer system, they are able to do this. They've also indicated, in part because of the 60-day requirement included in the bill, that this would be administratively difficult and expensive. And so I think the path forward on this bill because I do think it's an important policy to rationalize pardons and expungement, maybe to relook at that 60-day requirement inherent in the bill and provide the other branch of government with more time to accomplish the policy goals behind the bill.
Okay. In the memo they submitted, they literally said it would be impossible to accomplish this in 60 days. So you're willing to consider a longer period of time?
Absolutely.
Also, they indicate that it's going to be very expensive, and I haven't had a chance to find the fiscal note in this case.
And that's related to the 60 days as well. In other words, if they have to do it in 60 days, they have to hire more people in order to accomplish that. But if we amend this to provide the judiciary with a longer time period, they wouldn't have to hire as many people. The fiscal note would be much less. So I'm excited to work with you to get the fiscal note down and come up with a reasonable time period with which the judiciary can accomplish this policy goal.
Okay. Thank you for your answers.
All right, thank you, Senator West. Thank you, Vice Chair Waldstreicher. Did we have the gentleman come back up for the opposite? There you go.
Good afternoon again, Mr. Chairman. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of Sheriff Troy Berry and the Maryland Chiefs and Sheriffs Association. As you'd expect, we're opposed to pretty much every expungement bill there is. This particular bill, though, I want to focus on one absence, and I know we've had a conversation with the Senator about making an amendment to address our major concern with this bill. Don't know how quickly the government's going to act on any pardon, or how quickly the expungement thing will occur, but pardon could occur less than 3 years after an incident occurs, well within the statute of limitations for any likely lawsuit against anybody involved in the underlying prosecution. As was discussed in the earlier bill, 10-105 allows for good cause expungements if there's a waiver signed waiving a right to sue somebody. There's no similar provision in this bill. And second, a more minor concern with this bill is it does require law enforcement, upon getting the court order, to do the expungement, which is fine, and then send a notice to the person, hey, by the way, we expunged this case, we're not allowed to talk to you about it anymore. It creates an awkward burden, and also creates some minor fiscal burden on us and our employees to engage with that, what appears to be perhaps a huge number of expungements that come our way. So for those reasons, we asked for an in-favor report of the bill as written, but happy to continue work with the Senator about amending the bill and making it more workable for us. Thank you.
Excellent, thank you very much. So with that, that'll conclude the testimony for Senate Bill 88, and we'll now end the hearing for Senate Bill 88. And we'll now move on to Senate Bill 37 with Senator Waldstreicher. Mr. Vice Chair, you're up.
Thank you, Mr. Chairman. And I believe we have a graphic that I will pull up if Ms. Pop can assist. Thank you, Mr. Chairman, members of the committee. As we've talked about so much today, criminal records follow an offender long after their debt to society has been paid. These records often act as impediments to gainful employment, education, housing, public assistance, occupational licensing, and much, much more. The majority of the 15,000 Marylanders released from state prisons every year struggle to secure a job, find a place to live, and reenter society. The REDEEM Act in front of you now would remedy this inequity by modernizing Maryland's expungement waiting periods for certain misdemeanors and nonviolent felonies. Maryland's current expungement structure, including its waiting periods, were part of a historic bipartisan compromise known as the Justice Reinvestment Act. The bill was shepherded by the chairman, with strong support from Senator Huff, Senator West, and Governor Hogan, who enthusiastically signed the bill. Now 7 years old, the passage of time allows us to evaluate how our expungement waiting periods compare to the waiting periods in every other state. And what we find, unfortunately, and this chart is in front of you, is that Maryland has longer expungement waiting periods than most other states. Indeed, 42 states have shorter waiting periods for misdemeanor expungement, including notoriously blue states like Texas, Alabama, Mississippi, and Utah. That's a joke, they're very red. And unlike other states, the waiting period kicks in after offenders have completed their entire sentence, parole or probation, drug treatment, and any other mandatory supervision. There's nothing wrong with that as policy, but in practice, unfortunately, it can create unintentionally absurd results, because in most instances, the waiting periods are far longer than the actual sentence at issue. So what you see in front of you is all the states. And I don't know if you can see the mouse moving. Here you can. On the left side of the screen are the waiting periods for misdemeanors. So you can see Mississippi, no waiting period at all. West Virginia, 1 or 2 years. And then as I go down here with the mouse, Maryland is 10 or 15 years at the bottom of the chart, depending on the crime. On the right side of your screen, these are felonies, and you can see states like Colorado and New Jersey, 3 to 5 years, 4 to 5 years, even fewer in these 3 states above, California, Ohio, and Illinois. And here Maryland is at the way bottom, 15 years. So what the REDEEM Act in front of you does is that it makes the following changes to our expungement waiting period. Eligible misdemeanors go from 10 to 3 years. Contact misdemeanors go from 15 to 5 years. And eligible nonviolent felonies go from 15 to 5 years. Let me make one thing clear before I conclude. Here's what the bill does not do. It does not expand or change in any way the misdemeanors or felonies already eligible for expungement. The eligibility of an offense is defined in the Justice Reinvestment Act, and that eligibility is unaltered here. This legislation simply rationalizes the waiting period for offenses that are already eligible. In sum, Maryland law should not be the reason that returning citizens are locked out of employment over a decade after they have repaid their debts to society. This legislation will improve offender reentry, reduce recidivism, and is a logical and necessary addendum to the bipartisan work of the Justice Reinvestment Act. For those reasons, I respectfully urge a favorable report for Senate Bill 37.
Thank you, Senator Waldstreicher, and members of the committee. Once again, Christopher Dews, speaking on behalf of the Job Opportunities Task Force. You know, Senator Waldstreicher pretty much said everything. I just want to highlight that in your packets or in your testimony packet, we did list of all of the offenses that will be eligible for a waiting period reduction. Just to, you know, there's thousands and thousands and thousands and thousands of actual offenses. And after many conversations that we've had with advocates and even with members of the state's attorney's office, we specifically chose to use the charges that are already eligible for expungement on the logic that we've already kind of agreed to the fact that these should be something that we should be considering expunging. We're just shortening the waiting periods to match, as the great senator already said, what is already being done in other states. It doesn't necessarily make any sense that we are so far behind and rigid in our expungement. And it wouldn't even really matter, to be completely honest, if it wasn't a massive barrier to employment. When I was running workforce development programs, we had this massive issue where you get a person a job and they're doing the job and doing it well, and then they get a message back after a charge that was 7.5 years ago. They get a message back saying that, hey man, you can't actually take the position, leading them into a cycle of poverty that continues on and on to this day. So I respect the work that was done with the Justice Reinvestment Act. I just think this is a logical next step to bring ourselves in line with what other states are doing, and I urge a favorable report. Thank you.
Hello. Hi. Thank you. I hope you're not sick of me yet today. My name is Charlotte Ahern. I'm a staff attorney with Maryland Legal Aid. I represent individuals for criminal record expungement, and I focus a lot of my work on workforce development. So as previously mentioned, Maryland is far behind the times in terms of the expungement laws. Not only that, Maryland has, I believe it's 70% longer incarceration rates compared to surrounding states. So add the incarceration time that you have to serve plus this very long time that you can request an expungement, we need to catch up. I routinely have clients, one specifically that I'm thinking of right now, this individual is in Garrett County. He received a conviction for CDS possession with intent to distribute on August 25th, 1986. To give you some perspective as to that, I was 2 days old when he received this conviction, okay? So he was, did not get in any trouble until 3 months shy of the 15-year time frame that this person had to wait to request for this expungement. 3 months shy of 15 years. He was picked up and received it on driving on a suspended and prepaid the fine, which that is considered a subsequent conviction. Those are the only two things on this person's record. And I hear these stories day in and day out. If one of your goals as a legislator is to reduce recidivism and to get people working again and to get people a job again, which will then bring money back to the state, you should support this bill because it will drastically improve the lives of all of the individuals in the state of Maryland, but particularly low-income people who have had interactions with the criminal justice system. Thank you.
Good afternoon again, Mr. Chairman and members of the committee, and thank you very much, Senator Wallstreicher, for sponsoring what I think is a really important bill. Again, my name is Christopher Sweeney. I'm with Maryland Volunteer Lawyer Service. I'm a staff attorney there who manages our workforce development project, which means that I support people in job training programs to remove barriers to employment. In the several hundred people who I have helped to expunge their records or even just simply counsel them on the possibility, expungement has become an issue that I'm extremely passionate about, not only because I've seen the immense impact it has on their opportunity to become employed, but also on the immense personal and emotional impact that it has on someone's dignity. I have seen people break down in tears when they realize that these mistakes from decades ago that have been holding them back in life are finally being put away for good and opening a door to let them move forward. However, I have seen the utter devastation on someone when they learn that something that they did more than a decade ago, sometimes more than 20 years ago, is going to be front and center when they go to apply for a job. I strongly support the efforts that this legislature has made to increase access to expungement, but in the years following the Justice Reinvestment Act, what we have learned from those affected by criminal records is that 10 to 15 years is far too long to make them wait. That means more than 10 years of unstable employment, more than 10 years of being denied housing. We cannot expect a person to re-enter society and get their life on the right track if we keep placing these barriers in front of them. I think this bill is a matter of human dignity. Are we going to continually punish our fellow citizens for their past actions, continually define human beings as criminals, or are we going to support them with a path forward? I really appreciate your time today, and I urge a favorable report on this bill.
Excellent, thank you very much. Actually, there's one question for Ms. Ahern. I thought I heard you say that Maryland has a 70% longer incarceration rate than our regional board.
Statistical, and I believe it was actually the Justice Reinvestment Initiative, which came after the JRA, that provided that statistic.
Yeah, that's. Could you furnish that to the committee? That could you give that to the committee?
Yes.
That would be great.
Yes.
Thank you.
Mm-hmm.
Senator West.
Thank you, Mr. Chair. The question for the sponsor. Have you read the testimony of Aisha Braveboy, the state's attorney for Prince George's County?
I have not, no.
She wants to make two changes. One change would be to remove the provision that would reduce the waiting time for felony theft violations. And the second, she says that efforts to expunge records should not be allowed unless any orders of restitution have been paid. So on the felony theft, she says, we don't believe it's in the public interest to allow these offenses to essentially be removed from public examination and review after only 5 years have elapsed. If that were to happen, potential employers and community members who might be tempted to trust someone who has previously betrayed that trust by stealing, and they would have no way to check to see whether or not the person that they plan to hire, in fact, has done stealing. So can you respond to both of those two suggestions, the one about removing felony theft and the suggestion that expungement not be allowed until orders of restitution have been paid?
Sure, happy to. So on the second part, my understanding is that that is already part of current expungement law, that when you are required to complete all aspects of your sentence, that restitution is part of that. And so I think that's already covered. On the second part, certainly I believe that it's appropriate for theft to remain on someone's record for a period of time. But I don't think a switch to 5 years is too dramatic. And so, just to be honest, I like the State's Attorney of Prince George's County, served with her here, but I'm not sure how her argument on that issue is consistent with her earlier testimony here for Senator Carter's bill, where she testified that judicial discretion in any cases, including theft, should be allowable. So perhaps we can sit down with her and understand her position.
Good. Thank you for your answers to those questions.
Seeing no further questions, thank you all very much. Thanks. All right, we'll now hear from Judge Karoum. First dues you already went. Miss Denise Davis. Mr. Wiggins. And Miss Emerson.
Chairman Smith, Senators, again speaking for Major, not officially for the Maryland courts. I'd like to initially say that I am not aware of any scientific or rational basis for the legislature to have picked the 10 or 15 year waiting period that currently exists. But thanks to a training program that many judges were sent to, the ASTAR program, Advanced Science and Technology, had the benefit of training at Hopkins, Stanford, and other places about criminology and neurology, which would provide a science-based reason to go to 3 and 5 years. And I'd like to tell you that what we've learned and is readily available in the public domain to legislators is that 85% of folks in our prisons have substance abuse problems, alcohol, illegal drugs, strong connections to their offense. There also is evidence to suggest that if a person, neurologically speaking, has been able to abstain from alcohol and drugs for a period of 2 years, they're more than 50% likely never to do it again, never to relapse into that substance abuse. And if someone can abstain from alcohol and drugs for 5 to 6 years, they are 80% likely not to do it again. Those nicely track the 3 and 5 year periods that this bill proposes, and we have built into Maryland law the parole and probation system that can see if someone has successfully abstained, drug testing, alcohol testing, and if they do successfully complete their probation, I would suggest there is a good evidence-based reason to believe that this policy for SB 37 is a very good and rational policy.
Good afternoon, Senators. Mary Denise Davis with the Office of the Public Defender. We are in support of this bill. I want to thank the Senator and just everyone that has over the years made reform with the expungement laws for the betterment of individuals. I've been coming to Annapolis since 2007 when there was a bill for the automatic expungement of release without charge. And yes, if we could say that we solved all the problems, none of us would be coming back. But there's still problems and there's still the need in the expungement statute to be fixed. And this is one of them. And I think that it's reasonable, it makes sense that we cut down the waiting periods. And all I got to say is, dang, because I always thought Maryland was progressive, but that chart does not make us look very progressive. I mean, we need to change these waiting periods. And the other thing I will say, shorten the period of expungement. I know this, other people have said it, but it's going to improve lives. It's going to make people get to better jobs, better housing, better education. And the reason I say better, it's not just to get housing. They have housing, but they need better housing. And when we can get their criminal records off, that's when they can move. They can move from a position where they're just a regular worker to maybe even a supervisor. So it's really important that the waiting periods are shortened. And this, I will say that I'll just end it and say I hope you support the bill. Thanks.
Good afternoon, Chair Smith, Vice Chair Waldstreicher. Thank you so much for sponsoring this bill. And members of the committee, my name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which focuses on reducing the collateral consequences of criminal legal involvement for human trafficking survivors, as well as those populations put at highest risk of exploitation. I am also here in support of SB 37, the REDEEM Act. In addition to the points that my colleagues have already made, I want to reflect briefly on the intent of these longer expungement waiting periods, which have historically reflected the belief that individuals should only be eligible to clear their records after successfully, quote unquote, rehabilitating themselves, which is reflected by a period of crime-free behavior. However, numerous states have since shortened their expungement waiting periods in recognition of data that actually indicates the exact opposite, which is that record clearing actually plays a significant role in rehabilitation, meaning that lengthy waiting periods may actually contribute to recidivism rather than rehabilitation as we once thought. SB 37 would support this research by reducing waiting periods for convictions under Criminal Procedure Article 10-110. And as my extern Blake shared with you earlier, criminal records are a predictor and the result of trafficking, with national data telling us that 91% of sex and labor trafficking survivors have intersected with the criminal legal system at some point in their lives. And like all individuals with criminal records, criminalized survivors of trafficking similarly encounter struggles with housing and employment and all of those things. For this population, however, these consequences carry with them the additional risk of continued exploitation by a trafficker. In recent years, Maryland has shown its strong support for remedying the impact the criminal legal system has on the ability of its citizens to escape poverty and live productive lives. And reducing excessive waiting periods supports proactive rehabilitation and will allow all Marylanders, including criminalized survivors, to escape the shadow of their criminal records. So for these reasons, we support SB 37 and respectfully urge a favorable report. Thank you.
Questions from the committee? Seeing none, thank you all very much. Thanks. Good to see you all. All right. Did I miss Miss Downs? Yeah, Miss Downs. And did we have Mr. Wiggins? Okay, got it. All right. Excellent.
Good evening, you all. My name is Kirsten Downs. I'm the Executive Director of the Homeless Persons Representation Project. HPRP represents and provides free legal services for those with issues that put them at risk of homelessness, and hopes to fight barriers to economic security and housing security. HPRP has provided thousands of expungements for Maryland citizens throughout the years. The Homeless Persons Representation Project supports SB 37. This is not just an economic bill, it's actually an imperative of justice. I think it is well researched and well known that the criminal system has disproportionately affected people of color, particularly Black communities. At every stage of the criminal system, people of color are overrepresented, whether it's from arrest, over policing of neighborhoods, whether it's in plea agreements, whether it's in convictions and high sentences, in community supervision, people of color are overrepresented. And all of this leads inevitably to a mass amount of criminal records. 1 in 5 individuals has a criminal record. This becomes a considerable justice issue, but also a racial justice issue when it comes to the collateral effects of the criminal system and criminal records. It's been well documented that African Americans with criminal records have a harder time securing housing, securing employment. This not only affects the individual, but it affects generations and whole communities. We are in unprecedented times, and as previous speakers have said, there's new research from the passing of the JRA to show that we need to think about these things differently. In an era where there's significant staff shortages, and an era where there's significant evictions, this is a time to change this and allow individuals to enjoy the benefits of their serving their sentences, the benefits of what's available, and it will have significant economic advantages for the state of Maryland. So we request that this committee issue a favorable report on SB 37.
Excellent, thank you very much. All right, seeing no questions for the witness. Oh, do you have one? No? Oh, wait. All right, sorry, no questions, thank you very much. You're off the hook. All right. All right, so do we have Miss Francis? Is Miss Hanson? Miss Warnken? Mr. Thompson, Aaron Thompson? Mr. Coleman? All right. Thank you.
Good afternoon. Thank you for the opportunity to provide testimony in support of Senate Bill 37. Thank you to the members for listening. I want to talk specifically about the data that supports why 3 and 5 years as opposed to 10 and 15 years makes more sense. As was alluded earlier, there is no current data that exists that would demonstrate that 10 to 15-year waiting period has a bearing on someone's rehabilitation. And additionally, in fact, that the waiting period goes into effect after a person has fully served out their sentence. The data actually shows that a person who was not rearrested or committed a crime within the first 1 to 3 years after release has a stronger chance of rehabilitation for nonviolent offenses, and from 3 to 5 years, no new arrests or technical violations on parole demonstrates that the person has successfully been rehabilitated. I am the vice chair for the Maryland Alliance for Justice Reform. I'm also the former associate director of a workforce development program that ran out of Georgetown University that was designed specifically for people returning home. And I will tell you that employers, you know, there was a comment earlier on one of the other expungement bills that employers need to know whether or not someone has committed offense. There are a lot of second chance employers out here, and they're concerned about whether or not the person has been rehabilitated. I worked for an employer where I was one of the individuals that had to do the background checks, submitted them to the background check company, and then one of the things that we did was search the judicial records and a public record search through open source data to determine whether or not there was anything that was found on the internet. And so, you know, the data shows that the 3 and 5 years has a strong correlation, and that is why the 35 states that have similar waiting periods have reduced their times to 3 and 5 respectively. So I urge Maryland to do the same thing, come in alignment with the national average, use the data that currently exists. You can look at the RAND Corporation. The Collateral Consequences Resource Center did a study in 2018 by talking about waiting periods for relief, and that was by Love and Schlushel 2018. Thank you for the opportunity. I urge support of this bill.
Good afternoon, members of the committee. Once again, I am Heather Warnken, the Executive Director of the University of Baltimore School of Law Center for Criminal Justice Reform. The center is dedicated to supporting community-driven efforts to both improve public safety and address the harm and inequity caused by the criminal legal system. In direct alignment with both pillars of this mission, we are grateful to testify in support of the REDEEM Act, a direct mechanism for reducing the impact of incarceration and enhancing employment opportunities for lower-income workers throughout the state. The impact of a criminal record on individuals and their communities is staggering, as has been stated powerfully by so many witnesses today, including an extensive list of collateral consequences that can follow a justice-involved individual for years well after a case or period of incarceration concludes. As has been discussed, these impacts span numerous areas central to a person's ability to survive and thrive, impeding access to stable housing, education, healthcare, voting, occupational licensing, rights related to the parent-child relationship, and more. A groundbreaking study published in the Journal of Science Advances in 2022 shed new light on the enormous impact of a record on employment prospects specifically, including for the economy as a whole. The study found that the stigma of a record runs deeper than had ever been previously quantified, finding that more than half of unemployed men in their 30s have criminal records. Among 35-year-old unemployed men, 64% had been arrested and 46% convicted of a crime. In other words, the unemployed population is uniquely saturated with individuals living with records. The REDEEM Act is a common-sense way to address this, strengthening our communities without negative impacts on public safety, and indeed, in ways the research tells us will strengthen public safety. We urge a favorable report. Thank you.
Good afternoon. My name is Harold Coleman. I'm in support of this bill. I just want to tell a short story. It's not long. My journey started back when Obama was in office. I was given the opportunity to work for the Maryland Transportation Authority right here at the Bay Bridge, and I excelled. And I'm at a point now where I can't go any further because of the waiting periods. I can't get to an appointed level because of, the long periods that I'm waiting, and I'm trying to move forward, set an example for the people that's coming behind me, and have a face for them, so I will ask for a favorable report, on this bill, and thank you.
Appreciate it. Thank you, Mr. Coleman. Questions from the committee for the panel? Senator Sidnor.
Mr. Coleman?
Yes.
How many years have you come down to testify?
I've been testifying for the reduction for the expungement bill for like 4 or 5 years. I think it's like 5 years.
On this bill?
Since, yes.
Thank you.
Mm-hmm.
Excellent. Seeing no further questions, thank you all very much. It's good to see you all. Thank you. All right, we'll now hear from Mr. Richardson and Mr. Cox. Ms. Lipscomb. And our virtual panelists are not here, so.
Good afternoon, Chairman, Councilman. I'm here to testify today for the first time ever because my friend, Mr. Coleman, told me it makes a difference. So I'm going to tell you my story. I got in trouble 20 years ago, and I didn't know I was signing a death sentence, but I signed a guilty plea. But now I live in a basement apartment that I built for a friend 10 years ago. I'm still happy. It doesn't matter to me. But this law kept me down so bad that I had to work 4 jobs. And when I was working 4 jobs, I was so tired that I was working for a trash truck company he drives for. I fell off and broke every bone in my neck. And I still didn't give up. I still work. But I was paralyzed for a year, couldn't do anything, and they even told me that I wasn't going to walk. But the thing is, like he was saying, you're at a point that you can't go any further because of this law, and this is why I'm for it, because this is life. You know, we need to push forward and get our life together. Because when they told me I wasn't going to walk, I knew I was going to walk, you know, because I was taught by my mother to never give up. I was raised by a single mother. And she told me, you know, there's no point in giving up because, and as far as this law, I believe that, you know, asking permission to move forward in your life after you done did your time and signed a deal with whoever, a judge or whatever, and you still can't do it because the laws change, it's not right. So we need to move on with our life. You know, even when I broke my neck, I died, and I'm still trying. I want to get my life together. I'm 54 years old, so there's no training. I'll never be a lawyer. I'll never be a congressman. I'll never be a manager. But I still want to work, even after a broken neck. I want to work. I want to live my life, and my 2 minutes is up. So thank you for your time.
Thank you, Mr. Richardson, and I know you're 54 years young, but I don't believe anything you just said toward the end. You'll never be, you'll never be, you'll never be. But I still think if you testify like that, you apply that same, you know, effort to anything you do, anything you've done already. I mean,
Right.
yeah. So thank you for being here.
Thank you.
Yeah.
I know that wasn't for me.
Well, it's you know, it's early yet, so.
I'll hold out hope. I'm John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association. Senator Waldstreicher, you gave me the names to thank for the careful deliberative process in 2016, apparently the chair and Senator West and Senator Reedy, in going through that thought process and determining that appropriate time range. I had my say earlier on the prior bill. I'd just like to use misdemeanor theft as an example and how that impacts the criminal justice system. I believe that there ought to be a clear distinction between that which is publicly available and that which is available to the criminal justice system. So if an individual commits a theft, let's say for some reason, I don't know what it would be, they're not granted probation before judgment for their first offense. Then they have, under this legislation, if they have a minimal sentence or very little period of probation, 3 years to get that expunged from their record. And then if they were to go out and commit another theft a month after that, then I can make no mention of that prior one. And then we can go through this process repeatedly. And then 3 years later, if they're not caught until 3 years later again, then they have that expunged. And again, it looks like this is a person who's never committed a crime before when they appear in front of a judge. The judicial system ought to be able to know for a longer period of time than 3 years whether or not somebody's committed a crime previously if they're back in front of that judicial system. One example that doesn't apply here, but I think it's a good example and by my own experience, is DUI. So expungement doesn't apply to DUI. I'm not trying to imply that it does. But it gives a good example of the circumstances in that I have a vivid recollection of prosecuting a number of cases where, say, for example, somebody's a 5-time drunk driver, and they had those drunk drivings once a decade. And yet we would be in a scenario other than DUI, not having any ability to give consideration to something that somebody has done before and deciding what ought to happen to them for their next crime. We'd ask that the time periods remain the same. Thank you.
Good evening again. I'm Jerome Spencer. I'm the General Counsel for the Charles County Sheriff's Office, here on behalf of Sheriff Troy Berry and the Maryland Chiefs and Sheriffs Association. Similar to what Mr. Cox has told you, we want you to be aware of the potential collateral and perhaps unforeseen, maybe intended consequences of reducing the time from 10 to 15. Now, when you made a decision to make 10 to 15, I don't know what the science was behind it, but probably made a fairly good assessment that somebody who stayed out of trouble for 10 to 15 years is a good candidate to not reoffend. That seems like an assumption you probably would have made. But if we reduce down to 3 years, that means that there are other offenses where you're not allowed to possess a firearm, for example, with prior convictions. Of the 36-plus offenses in the current statute, a lot of them are ones that prohibit you from possessing a firearm. law enforcement, the prosecutors won't be able to access that prior conviction to prosecute somebody under the public safety article for illegal possession of a firearm. Similarly, many offenses, occupations require background checks. I think earlier we heard 55. Among those occupations are school teachers, social workers, and police officers. After a 3-year period, somebody who's committed a first-degree burglary or 5-year period, whichever it is in the statute, can apply to be a police officer. We won't pick that up in a background check, can't hold that against them. That person becomes a police officer or a teacher or a social worker or a doctor, whatever it may have you. So be mindful of the very broad sweep of this bill. The nature of the offense matters. The bill is, I think, significant in that it has an exception for domestically related crimes. That's still 15 years. Why? Because that's the offense where you've decided we're going to wait 15 years for that. Similarly, make sure you're making a careful decision about what occupations you want to have people being convicted of these crimes, applying for and receiving those jobs. Some jobs should not have the person's convictions have that job. I mentioned a couple of them. Many others, great, fine. Just be very mindful of the consequences that will occur if this bill passes through, the impact it will have on the ability to enforce the existing laws, and the lack of ability to screen employees for very sensitive positions. Thank you.
Excellent, thank you. Seeing no questions from the committee, thank you all very much for your testimony. I think that's it. Is that it? All right. So with that, that'll conclude the testimony in the hearing for Senate Bill 37. We'll now move on to Senate Bill 27. Senator West, you're up.
Thank you, Mr. Chair. And once again, for I think the third day in a row, I'm all that stands between you and dinner. So unfortunately, unlike the last two bills I presented at the end of the day, this bill does have some opposition. So I doubt it will go quite as quickly as the bills at the end of Tuesday afternoon and Wednesday afternoon. Chairman Smith, members of the committee, it's a pleasure to be before you to present Senate Bill 27, all about restorative justice. So restorative justice is a government and court-appointed system which focuses on rehabilitating offenders by reconciliation between the victim and the offender. It emphasizes repairing the harm caused by criminal behavior. Restorative justice achieves this by bringing both the victim or a representative of the victim and the convicted offender together in order to ameliorate the harmful effects on a victim in a manner that treats the victim with dignity, respect, and sensitivity. The goal is to engage both victims and offenders in the justice process, leading to the repair of the harm caused to the victim and encouraging behavioral change in the offender. Senate Bill 27 establishes the Restorative Justice Program inside the Victim Services Unit of the Governor's Office of Crime Prevention. Participation in the Restorative Justice Program must be voluntary on both sides. I can't emphasize that word voluntary enough. Once informed about the program, a victim must take the initiative to request participation in the program through the Victim Services Unit. Similarly, once informed about the program, the offender must take the initiative to request participation in the program through the offender's case manager. I want to stress that neither the victim nor the offender will be put under any pressure whatsoever to participate in the program. In the case of a victim in particular, if the victim does not want to participate in the program, the victim can simply ignore the notification provided to the victim by the state's attorney of the existence of the program and the way in which the victim can request participation. So this is not an opt-out statute. This is an opt-in statute, and it's entirely within the control of the victim whether or not the victim decides to opt in order to participate in this program. I went into some detail on this because I think you're going to hear some suggestions from the opponents that somehow the victim might get railroaded into participating in this program. And I want to make very clear, and the text of the statute, proposed statute, makes very clear that the victim has total choice as to whether the victim gets involved in the program or not. The bill sets up the Maryland Restorative Justice Council within the Governor's Office of Crime Prevention, Youth and Victim Services. The council will be responsible for administering the program, including its standards, policies, training requirements, and certifications for facilitators. The bill also creates the position of restorative justice legal specialist within the Victim Services Unit, whose duties will include managing the program and ensuring the compliance of the program with all applicable laws, regulations, and established policies. In addition, the bill establishes the Restorative Justice Program Revolving Fund to pay for the costs and administrative expenses of the restorative justice legal specialist. So here's how the program will work. Once both parties agree to participate in the program, the restorative justice legal specialist will assign a facilitator or a facilitating organization to bring the victim and the offender together while ensuring the safety of the victim and in a manner consistent with trauma-informed methodologies in an attempt to facilitate program participation. The facilitator will be completely neutral. The restorative justice legal specialist will create a confidential file in the Maryland Electronic Court System. On request of the facilitator, the prosecuting attorney, the Victims Services Unit, counsel for the offender, counsel for the victim, and the court may provide the facilitator with helpful information. The court clerk must provide the facilitator with access to all materials in the court file at no cost. The facilitator must submit regular reports to the restorative justice legal specialist, and then either party may withdraw its participation in the program at any time without consequence. Finally, let's discuss what a restorative justice program can accomplish. In those cases in which both the victim and the offender agree to embark on a restorative justice dialogue assisted by a trained facilitator, the possibility exists that the program will meet the victim's need for healing, will result in the offender acknowledging wrong and taking responsibility for the criminal act, and will reduce recidivism once the offender is released from confinement. Finally, based on statistics I've seen, the cost of providing restorative justice programs is offset up to 8 times by the savings created by significantly reduced recidivism rates and the cost of future crimes. The probability of rearrest has been shown to have been reduced by 13% for those who participate in the restorative justice mediation program. The probability of returning to prison is reduced by 12% in restorative justice cases. In short, restorative justice mediation has been shown to improve recidivism rates. So with that, I am going to turn the program over to my fellow speakers, and I appreciate the committee's consideration and hope for a favorable report.
Good evening, everyone. Thank you, Chair Smith, Vice Chair Waldstreicher, and honorable members of the Senate Judicial Proceedings Committee. My name is Chris Morton, and I am representing the Maryland Prisoners' Rights Coalition, an organization working to improve the conditions of confinement in Maryland correctional facilities. As Senator West explained, Senate Bill 27 creates a restorative justice program. He did a good job of shortly explaining what restorative justice is, so I'm not going to go over that. It focuses on repairing the harm caused and not simply punishment, but it's important to point out that as this is a post-adjudication program specifically, many of the offenders will have been received punishment, rather significant punishment. And it's also important to know that it includes a wide range of practices. And we're fortunate enough to have witnesses here presenting testimony that will share their expertise and experiences. So I'm going to focus mainly on why we are introducing this bill and why the program is structured as it is in the bill. We at the MPRC, Maryland Prisoners Rights Coalition, are looking to advance decarceration from the other side of the walls. Our focus was breaking the cycles of violence and revenge that create more cycles of crime, victimization, and incarceration. After consulting with several community groups around the state and especially in Baltimore City, the area most affected by these cycles, we decided our efforts were best spent in creating a trauma-informed restorative justice program that dealt with serious crimes and that serves the entire state of Maryland. This legislation is not meant to create a fully formed restorative justice program with all aspects from beginning to end mandated statutorily. We want the Restorative Justice Council, created by the legislation, to create their own standard operating procedures in line with nationally recognized best practices of certified practitioners. You will hear from opponents today that certain crimes are not appropriate for restorative justice processes. We do not necessarily disagree with that. But this is best decided by practitioners, not advocates or legislators, and we do not want to foreclose anyone from participating at the beginning. So we urge you to return a favorable report on Senate Bill 27, and I'm happy to take any questions.
Good evening, Chair, members of the committee. I promise this is the last time you'll hear from me today. Elizabeth Hilliard, I'm back here for the Maryland Office of the Public Defenders. We are so thrilled to be presenting a restorative justice bill this session and ecstatic that Senator West has introduced it in the form it comes. It is focused on healing the offender, healing the victim, and repairing harm to community. Something that often goes unsaid, or at least not said enough, is that people who are incarcerated have frequently been victims themselves. And we know that cycles of violence continue when harms go unrepaired and when people are not made whole. I represented people in DPSCS facilities for 6 years. I have seen the absolute lack of programming, of therapy, of rehabilitative services that our 30,000 Marylanders who are incarcerated currently face. This program offers a small step in the right direction to remedy that. I will briefly address 3 of the concerns brought forward by the opposition. First, we have introduced a friendly amendment, and I just ran it by Senator West, that will permit a victim or a victim's representative to opt out of any and all notification at any point, so that there will not be persuasive or coercive opportunities, and a victim can opt out from the beginning. Second, we are happy, in fact, invite domestic violence survivor trained and trauma-informed and intimate partner violence trained individuals to join the council. And we are happy to expand that, expand our council to include those representatives. Again, we urge a favorable report on Senate Bill 27. We are happy to work on amendments and trying to assuage some of the concerns by the opposition, and I'm available for any questions. Thank you.
All right. Seeing no questions from, oh, we got a question. Senator Sidnor.
You seem to be, I take it that you were about to say that there's something else. What else did you agree to?
You waited till I closed my laptop, Senator. Yes, and I just wanted to emphasize that we have additional amendment language that we apologize did not make it into drafting that will ensure that, get to the page here, the restorative justice legal specialist is required to have experience, not just knowledge, in the restorative justice process, so that they have actually participated in it and are not just someone who has an idea of what restorative justice is from reading or mediation, and that the 4 persons who are representing the restorative justice advocacy organizations in the council will be 4 experts in restorative justice advocacy organizations. Again, ensuring that we are including people who are at are the most educated and the most well-trained in the restorative justice field, so that we can serve all people involved in the most helpful and least harmful manner.
Thank you.
Thank you.
Excellent. Thank you very much to the panelists. We'll now move on to our next panel. Ms. Warnken, Ms. Casey. Do we have Ms. Camera? Ms. Kirsch? Ms. Abrams? And Desmond Perry? Mr. Perry? Excellent. Yep.
Okay.
Good afternoon. Once again, Heather Warnken. I am the Executive Director of the Center for Criminal Justice Reform at UB Law. I testify today also drawing on my previous experience as a visiting fellow at the U.S. Department of Justice, where a big part of my work involved advising and collaborating with DOJ's Office for Victims of Crime on numerous initiatives, including post-conviction and corrections-based victim services nationwide. I have personally participated in restorative justice dialogues both in and outside of incarceration facilities, both through my policy work and as a surrogate victim of crime. Based on this background and experience, I want to highlight two overarching points. Number one, there is a deep and urgent need for greater availability of restorative justice programming in Maryland and across the U.S. There are many reasons for this, including how inaccessible and insufficient the more, quote, traditional victim services infrastructure has been for the majority of victims. Most victims never experience their harm being prosecuted, but for the relatively small percentage who do, many express deep dissatisfaction with a criminal justice system not designed to deliver on their needs. Restorative justice offers incredible potential, especially for those whose experiences and wishes have diverged from the hard and often inhumane edges of the criminal justice system. In addition to its potential to provide voice, healing, and closure for those seeking it, and who faced barriers to such engagement through their earlier adjudicatory phases of their case, it also holds transformational potential for incarcerated persons. In the right context and circumstances, it can offer more meaningful accountability and reductions in recidivism than incarceration alone, or even some other forms of rehabilitative programming. And the second overarching point I want to emphasize is that collectively, we should not let these complex questions surrounding implementation of this programming prevent us from pursuing it. And I would be happy to answer any questions. Thank you.
Good afternoon. My name is Gretchen Casey, and I am here in support of this bill, and I'm speaking from actually three separate but connected backgrounds. I am a victim advocate. I've been a victim advocate in a rape crisis program through the Attorney General's office and through the State Attorney's office in Florida since 1986. I am also a survivor of sexual battery when I was 23 years old, and I am now a facilitator of restorative justice, victim offender dialogues, reparative dialogues, impact dialogues. There's lots of different names that we refer to these as, but I have done over 90 of these in the last 5 years. And I'm speaking in support of this bill because I can tell you, if you're interested in lots of the reasons why people seek this, people who have experienced harm and those who have committed acts of harm, or their defense attorneys reaching out to me. And that's going to take more than 2 minutes. But what I do want to emphasize is how important it is to recognize what this can offer to people and to be able to put this in statute. This bill provides victim survivors the right of access to restorative justice. Victim and survivor centeredness starts with agency, the ways people figure out how they will regain a sense of empowerment and control in their life. Not all victim survivors will choose or consider this newly bestowed right if it passes. Not all victim survivors invoke other rights that are set into law. Those who want RJ will be involved in extensive preparation, safety assessment, and addressing readiness keeps it centered on safety and informed about the needs that each party has, and managing expectations. A harmed person can also, at any point, withdraw from the process or this option. The essential point is this: a victim's right to restorative justice, if it's embedded in law through this bill, victim survivors will be able to decide whether they want to participate in a restorative justice dialogue with the person who harmed them. That determination will no longer be made for them or excluded from them by others, not by criminal justice officials, and not even by those who advocate for victims' rights. The decision will be made by victims and survivors, as it should be. Thank you.
Hi, I am Ann Bocchini Kirsch, and I was asked to give Bob Rudy's regrets and give major support in his place. I'm a volunteer, and no member of the board was able to be here. I am also a survivor of rape and a survivor of domestic violence. I am an imperfect victim if you have read Lee Goodmark's new book, and I'm a returning citizen. I'm also director of advocacy for Prepare. We are a parole and reentry advocacy group that works with people from intake when they come into the prison system and continues to follow them after their release. The importance of a program like this couldn't be more clear to me because I've walked all the way around this island and seen it from every perspective. It's not the right answer for everybody, but for those who it is the right answer for, it can be transformative. I understand the concerns with some of the power crimes, and I've read what the opposition has written. These are very important issues that can be brought up as this is taken from this legislation that's in front of you and put into executive instructions in COMAR. This isn't something that needs to be handled at this level. These are issues that I would invite them to come to the table and work through with us. But the root of this bill is too important to walk away from because of executive procedures. This is something that I see every day in my work, people crying out for on both sides, and you have the opportunity now to change a culture and create a culture of healing instead of an adversarial process. And I'd invite any questions.
Hello, everyone. I'm Catherine Abrams. I am a licensed social worker and substance abuse counselor and peer supervisor. I was a clinical social worker inside DPSCS prison system for the past 6 years. I spent every day inside Maryland's prison system, maximum security institutions with some of the individuals that we are most afraid of. I provide clinical services inside the institution, and in my evenings, I have a clinical practice where I provide therapy for individuals who are victims of crime. I provide clinical services to victims of rape, child abuse, and other horrific, traumatic incidences. I'm also now the executive clinical director of a nonprofit organization, Rectify. I'm here to address some of our fears about restorative justice and some of the things that we might be concerned about, especially encountering, our offenders that most of us have chosen to lock away and avoid. As the clinician who worked with them on a day-to-day basis, we are trained to identify when you might be encountering manipulation, when the individuals might not be clinically appropriate for these programs, and when they might not be suited at this time for this program. I can tell you that majority of the individuals that I encountered had been frozen in a traumatic state. Most of my individuals have been victims of crimes themselves and have been severely struggling. And we release them back into our communities with zero services, treatment, or support. That is not public safety. This program will be providing services on both ends and is a public safety measure. I invite any questions if you have any.
All right, hello, how are you doing today? My name is Desmond Perry, and I am here also representing Rectify as a co-founder and executive director of peer programming. I am a peer recovery specialist. I am currently a student in BCCC in Health and Human Services, and I also am a peer coordinator for helping others to empowerment in their diversion program. And I'm also a returning citizen and once was a long-term offender who was serving a life sentence for first-degree murder. I'm here today in representing this bill and hoping that you all will take this bill into consideration because I was on that other end of the spectrum. I've counseled men as a peer in prison on writing letters to mothers of violent crime. And I also had to do it myself. And I saw and I witnessed how we were unable to be able to do this because we didn't have a program like this. There was nothing set up for us to be able to restore any type of justice on both ends. And so the trauma just continued and it perpetuated on both ends. In my particular case, the mother who was told to come to court and she was notified and had to face me again, she had gotten no resolution whatsoever, and she expressed it. And there was no way that I could show her all of the good that I had done and all of the things that I had been a part of and how remorseful I was because we didn't have any type of connection whatsoever. I spent 20 years behind bars working on myself every day trying to show this family that I was sincerely sorry for the harm that I had caused them. And I couldn't do anything about it. And so I'm here today, again, in hopes that you all would take this in consideration, just my testimony briefly and my story of saying that a bill like this is needed. It is much needed in the state of Maryland. I saw it, and I witnessed it, and I experienced it. The trauma is a cycle, and we have to break it.
Thank you. And I'm looking through the opposition, and I'm looking at the panel, and I'm thinking, wow, most of you up here who are talking about this would most likely be looked at as folk who would be who these organizations are trying to protect. And you all are saying, let's have this program, and they're saying, no, it's not victim-centered. And so, I'm curious because on line 5, it says, page 5, lines 11 through 13, it says, create a victim-centered approach of restorative justice that seeks and obtains positive outcomes for victims, offenders, and communities. And I've looked at, I think, each of the letters in opposition, and they all seem to be saying the bill doesn't take a victim-centered approach. So I'm curious, with you all being victims, what you believe a victim-centered approach program would be, and if you can, why you believe that, and I'm going to ask them the same thing, why do you believe that they believe that this isn't a victim-centered approach?
So I believe the first thing that makes it a victim-centered approach is the choice. It's that ability to opt in or opt out. In both cases, and I was raped when I was 15 years old, and I spent 13 and a half years in an abusive, controlling marriage. So I have a lot of experience with victimization. My power was taken away from me. I did not have control of my life. I didn't have control of my body. And when this bill offers me a choice, I can say yes or no. I can say this is how I choose to heal today, or this is not how I choose to heal today, or maybe in 10 years, I want to see what this individual has done. Now, I will speak, if I had the opportunity to participate in restorative justice today with the man who raped me when I was 15, I would take that opportunity because I would want to know what a juvenile was doing decades later. And if I was offered that same restorative justice with my ex-husband, I would refuse because I never want to see him again. And that is what makes it victim-centered, that bill gives me that power to say in these situations, yes to this one and no to that one. I'm not entirely certain why they don't believe that it is a victim-centered approach.
Okay.
As I mentioned, I think that a lot of the specific issues that I saw them bullet out are COMAR issues.
Okay.
There are things that, like privacy, how is the data going to be protected? These are issues that are done at the executive level. So they are certainly issues that I would invite close scrutiny of as this bill is moved forward. And if you choose to approve this bill, I hope there are good watchdogs to make sure that those things get executed properly. But that is not a legislative function. That's an executive function. And so I think we're talking about two different things. I think that some of the opposition expressed their desire to give me my choice. And if that's truly what they want to do, then I feel like they would support this bill and closely watch and fight for the right outcome at the executive level as well. Do the work all the way through.
Because my read of this legislation is that a victim or an offender, they can request it, but neither is, or at least with the offender, they're not directly going to the victim, they're going to this specialist, and the specialist forwards it.
That's correct. And
Is
that
that-
is the purpose of somebody like Kat.
And is that, and again, if I'm reading what they're saying, that in and of itself is enough of a trigger that they don't even want that trigger.
Well, as somebody who works in parole advocacy, victim services is going to contact that victim anyway.
Okay.
That is part of the normal process. There's a 120-day victim services hold on my cases all the time, because as a part of the process, the offender comes up for parole, the victim is notified. So in terms of a letter being a trigger, this is going to happen anyway. In this particular program, the victim has the power to permanently opt out forever. They can say, I never want to hear from you again, and they will never contact them again. That was the amendment, the friendly amendment that Elizabeth spoke to.
Okay.
And that's really important, because that's not really an option with these other, the court system has to make the victim notification. The parole commission has to make the victim notification. So that's something that's already a part of our system. This bill is actually gentler with that, because the victim can say no forever and never hear again.
And I don't know if this is a question for you or for the sponsor, but whomever can answer. Within this, you talked about the issues that were being raised as being COMAR issues. Is there anywhere in here that sets language that says that the Governor's Office of Crime Prevention shall set or establish rules or regulations? It is in there? Okay. So that's a yes?
Yeah, she's looking for the actual citation for me right now.
It's on, okay, so it's on page 10, line 25 through 27, page 11, lines 1 through 11, maybe? So, okay, it's in there.
It's in there, yeah. It would be impossible to run this sort of a program without COMAR
Without regs.
regulations, because you have to have some type of executive structure to,
Okay, look, thank you very much.
thank you.
Could I also weigh in on that? Okay. I just wanted to add 2 points in response to the question about it being victim-centered. And I talk about this in my written testimony as well. But one, I want to underscore what is so often a false binary between who are victims and who are people in the system. As has been discussed at various points today, the vast majority of people who are incarcerated have themselves been victims whose trauma was never addressed and who never received the services that they needed when they were victims of crime. And the other thing I want to emphasize about that is all the victims out there who want this, who are so hungry for this and who are desperate for this. And that was my second point that I made in the earlier oral testimony. I don't think we should we should let these barriers, these complex implementation questions for which there's ongoing dialogue about how to address and for which there's a council structure built into the bill, prevent us from meeting the needs of so many victims who are asking for this, and foreclose on that transformative possibility based on the exceptions. Thank you.
Good to go, Charles? All right, excellent. Okay, thanks. Yes, ma'am, were you coming up to testify?
I had signed up to
Yes.
testify, and my name wasn't called.
Oh, we're not done yet. Yes, I'm sorry. We're still calling folks.
For it,
I'm sorry?
to support it.
Yes, come on up. You can, since this panel has just concluded, you're up. Welcome.
And I look for, it's the Unitarian Universalist Legislative Ministry. I don't know if you have something on it. I'm Karen Clark.
Yes, we're still working through the list, so.
Oh, I'm
no,
sorry.
No,
I
no,
thought
no, no
that
worries,
you
no
were
problem.
together, guys. All right, well, I'll start. Well, good evening. And a lot of what not a lot, but some of the things I was going to talk about in my written testimony, I'm going to just talk. I would definitely supported what Senator West was saying about the improvement on the recidivism rate. And I researched and found that this is just kind of starting being used in our community, in our church community. By the way, they were thrilled when we had heard about this. I ran across it and I said, well, you know this? We're thrilled that you're getting this law goes in the mix. I do want to tell that there are 20 states that say they are involved in this kind of process of dealing with conflicts and people in their criminal justice systems, schools, also hospitals, workplaces, communities, churches, and children's services. Often they address low-level issues, but there is one national group called Impact Justice that is doing this in prisons and across the U.S. Besides the U.S., these countries identify as using this process: Canada, England, Wales, Australia, New England, Japan, Indonesia, and Germany. Closer to home, we have it up here in Baltimore's Community Conferencing Center. It's being used in New York's Common Justice Center. Cities like us and Minneapolis have victim offender mediation programs. So I would like to also say in our church, we have one of the Black Lives Matter signs hanging up in Annapolis, and it gets torn down periodically. And rather than take it to the police, and the police were surveilling, they knew it happened, but we wanted to do something different, and it was a young teenager. We did what we saw as restorative justice, no one being trained, but we had the parents come in, conference. The church was the victim, and some people came in and talked with him. We also, our 8th principle is to dismantle racism in ourselves, others, and our institutions. And so we have lessons and books and videos. He came with his parents to our church and spent some time with the people. This way, we're not just taking somebody and punishing them. They're showing that what they do has impacts on people, makes a difference. There's growth and there's transformation. And I think this, obviously, it's not just, it's being done other places too. So we highly support this, and hopefully we'll have a positive result. And thank you.
Excellent. Thank you, Ms. Clark, and thank you for hanging in there with us. All right. Is Mr. Muhammad here? There was a problem with the registration. What is your email address again? I'm sorry, you're just.
Mr. afair77@gmail.com.
Got it. There you go. Excellent. Thank you very much. You're up.
Good evening. Certainly feels like evening. Mr. Chairman, Vice Chairman, distinguished members of the committee, I'm honored to be in your presence. Senator Carter, it is always an honor and a privilege to be in the room with the people's champ. My name is Anthony Muhammad, formerly Anthony Fair. 30 years ago, on January the 26th, 1993, at the age of 15, I was arrested for 2 homicide charges in the city of Baltimore. I was ultimately convicted and sentenced to life plus 20 years in prison for the crimes that I committed. Just 4 months ago, on September the 20th, 2022, I was released under the Maryland Juvenile Restoration Act after serving a total of 29 years, 7 months, and 29 days for the crimes that I committed. There are no words adequate enough to express the depth of my remorse for the crimes that I committed. It was a horrible decision, the worst decision I ever made in my life, the decision to take the lives of 2 human beings. I'm truly sorry for the crimes that I committed, and I deeply regret my actions. Currently, the Maryland Division of Correction, the Department of Public Safety and Correctional Services, does not have a program, does not have a process in place where an offender can request any type of victim-offender mediation and dialogue to express their remorse for the crimes that they committed. 2 months after my release, I had the opportunity to sit down with the families of the victims in a victim-offender mediation dialogue that was initiated by the Sentencing Review Unit out of Baltimore City State's Attorney's Office and ultimately facilitated by the Baltimore Community Mediation Center, a very successful victim-offender mediation process that I wish was available decades earlier within the Department of Public Safety and Correctional Services. Since its inception, I have been a member and supporter of the Maryland Restorative Justice Initiative founded by my great friend and mentor, Walter Lomax. So I believe in restorative justice. I believe in the lost ideal of rehabilitation. And most importantly, I believe that that process of restorative justice and rehabilitation is rooted in some form, some kind of victim-offender mediation. I believe that the rehabilitation of an offender is not complete until he comes into some kind of awareness of what we call the ripple effect, the consequences of his actions, specifically on the victim and the representatives and families of the victims. And I believe that that is best initiated through some kind of victim-offender mediation process. So I would urge the committee to vote favorably on this bill, and I thank you for your time. And one last thing, I would be remiss in my duty if I did not thank this committee for the excellent work you did on the Juvenile Restoration Act, specifically Senator West. I'm honored, and thank you for the work that you did.
Well, thank you very much, Mr. Mohabben. Thank you for hanging in there with us. All right. Did we have the Maryland prisoners' rights? You already testified? There you go. That was you. Okay, excellent. Zaneb Kamra. Here. Craig Susek.
I think it's Jean Trower.
Or, sorry, Jean Trower.
No, she's not here, and Mr. Susek accidentally signed up for in-person.
Understood. Okay. All right, that then will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Is Ms. Jordan here? Ms. Shapiro? And Mr. Kroll? And the rest are virtual, so. Ms. Shapiro, you're up.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence. First, I want to make one thing clear. We do support restorative justice. We do support restorative practices. However, we do oppose Senate Bill 27 as it has been drafted. Crucial steps have been missed in the development of the program contemplated in the bill, and it's insufficient to say that we will address them through some executive process, some counsel, which includes just one victim, or COMAR. I have spoken to numerous individuals, and Ms. Jordan did want to be here. She did submit written testimony, and I'm also here on behalf of the Human Trafficking Task Force. Service providers and survivors of domestic violence, survivors of trafficking, have all expressed their opposition to this bill and the program it creates because it does lack so many victim protections. And making this an opt-out is insufficient. It must be opt-in. It must be in the power, in the hands of the victim, of the person that was harmed. I'm going to use my remaining time to amplify the voices of some victims who I consulted on this bill, and this is what they told me. It promises to be voluntary participation, but if the victim declines because she knows her abuser will continue the behavior, he can still enter the program. This puts the victim's fears, experiences, and trauma marginalized. She really doesn't matter. The bill details confidentiality and voluntariness, but if the victim declines, a facilitator can have access to legal records. This violates the victim again, as she has no control over what was a very vulnerable and personal experience. Another victim said if he had decided it would be useful to him, he would have presented a wholly charming, touching, reasonable, or even pitiful face in the restorative justice conference, winning the goodwill of everyone there while continuing to abuse and control me in private or through third parties. This bill does not at all contemplate the unique aspects of power-based violence. There is no specific training requirements for the facilitators. And if I could just have one more moment to finish, I want to make sure that these victims' voices are heard. The perpetrator, the individual asked whether the perpetrator must have recently attended a sanctioned abuse intervention program, holding them accountable and coaching them on practicing nonviolent relationship skills prior to participating in the restorative justice practice. And another individual wrote, I think for something like this to be considered acceptable in the DV arena, the process would have to be very unique, and specialized training would play a huge part on the side of the facilitator. I have a concern that a person sentenced to prison for first-degree assault who was there for a crime against his wife goes through this process the same exact way as a person who was there for a crime against someone from a street fight. Those are the same charges, but very different scenarios. This can't be a one-size-fits-all. I urge an unfavorable report.
Mr. Chairman, members of the committee, good afternoon, or rather good evening. I'm Stephen Kroll, the State's Attorney Coordinator, Executive Director of the Maryland State's Attorneys Association, and I've been practicing criminal prosecution since 1984, including representing victims of domestic violence. To Senator West, we are in favor of restorative justice. The way this bill is written, we cannot agree to it, and are recommending an unfavorable report. This bill at a minimum needs a lot of work, Senator. I think you would admit that. More importantly, every day we as prosecutors do restorative justice. Come to court and see us in action. We are implementing many of the things you want to see with victims and witnesses, and in turn doing restorative justice without it being legislative. Second, when the public defender's office and academia says they're for victims and witnesses, red flags should go up. There are only one victims of crime, and they're the true victims of crime, not the ones that are in jail, but the ones that are in freedom who have suffered at the hands of defendants. Third, have you seen GOCAP, or whatever they're calling themselves now? They are a shell of what they were, and you're going to give this important program to GOCAP the way it is now. They have no executive director, no vice director. They're in no position to handle this at this time. So go down to Crownsville and see. They're a shell, and the poor people that are working there are doing the best they can, and they're doing great work. Not good work, great work. But until they are restored and they get the right people in the right places, they cannot handle this important piece of legislation and doing it correctly. Finally, as I mentioned to you, we do this work every day, and what we see is a balance of power, as Ms. Shapiro said, that's abused and could be abused in this situation. It shouldn't be a victim opting out or opting in or opting anyway. They should have the real choice, and they're not getting that choice with this bill. This bill needs a lot of work. We are for restorative justice, but we are not for justice the way it's written in this bill. And we'd ask for an unfavorable report as the Senate Bill 27, and please bring back the power to the true victims of crime, the true victims of crime. Thank you.
Thank you, Mr. Chair. First, I want to acknowledge and say thank you to Mr. Muhammad for your testimony. Your story is very compelling, and I was moved by it. To Ms. Shapiro, I apologize. I missed the beginning of the bill, and I'm not sure I fully understand it, but I have some thoughts and some suggestions and some questions, and they will be very quick. Senator West, based on what I've heard and based on the idea that this is a good idea, I'm wondering if you're amenable to maybe a pilot program to roll it out slowly, since we like to move slowly on justice in Maryland sometimes. Just something to think about. You don't have to answer now. Ms. Shapiro, is there a way to just carve out, I mean, I know that when cases are filed and they're always labeled immediately in court, they always label something domestic or not domestic at the initiation. So why don't we just carve out all domestic cases or domestic-related cases for the beginning, and then those would be the one group of people that wouldn't have any opportunity at all to get any of the benefits of the restorative justice initiative?
So, Senator Carter, thank you very much for that question. And certainly it's something that, we've contemplated asking first to the pilot. we have talked to Senator West. I have met with the advocates on 4 separate occasions over the course of the last year regarding this bill. And none of the changes that we have suggested have made it into the version that is before us today. And so we are happy to continue those conversations. But as it's drafted, our concerns sort of go beyond just carving out one group. And quite frankly, there are victims and survivors of domestic violence who may want to utilize this program. So I don't want to foreclose that. But the power needs to be put back in the victim's hands to opt in, to say this is something I want to do, as opposed to right now how it's presented where anybody can do it. And because we don't have enough protections in the sense of like the bill contemplates and in fact mentions, I believe on page 8, victims counsel. And there's no right to a victims counsel in law. There's no funding for victims counsel. There are some victim witness advocates in some states' attorneys' offices, but there's also funding issues. And so how they're being notified, they may want to participate in it, so simply carving out, and it's not just victims of domestic violence, it's victims of trafficking, it's all victims of power-based violence. I haven't seen all the opposition testimony, I don't want to speak for anybody else, but I'd rather work on a process that can be available to all victims and be implemented the right way than push a bill and do a pilot and carve out certain victim groups.
The question I'd asked the other panel, your testimony notes that this bill does not take a victim-centered approach. Would you mind explaining that?
Thank you, Senator Sidnor. So what I would start with is just how the process can even be initiated. And so in this case, as it's drafted, it can be initiated by the offender. And while there is contemplation that the offender does not have direct communication with a victim, it is still possible and likely that that can be very triggering for an individual who is the victim of a crime. And so to truly make this a victim-centered bill, I would also note there are some of the privacy concerns that were raised by individuals, ensuring that there has been some acknowledgement of responsibility in their role from the domestic violence lens, at least the individuals that I spoke to, treatment and acknowledgement of the harms that they have caused, and handling and the special training needs of all of the individuals. So to make this truly victim-centered, the power of whether or not to even be notified in the process needs to be solely in the victim's hands. And that's why we have said, and I've repeatedly said to the proponents of this legislation, that we have to start with it being solely an opt-in, something that a victim can be made aware of. And if they choose to opt in to the process, then that's something that's in their power. And that's the very first step of making it victim-centered.
Okay, thank you.
All right, seeing no further questions from the committee, thank you very much. We'll now switch to our virtual panel. We have 2 signed up in support, and we'll start off with Jonathan. Sure, welcome.
Good evening. My name is Jonathan Sharp. I'm speaking in support of Senate Bill 27 to create this post-adjudication victim offender dialogue process. I've been the director of the Disorder Justice Project since 2013, providing the same type of services for the entire state of Wisconsin for violent and sensitive crimes. This bill creates a process that offers incredible opportunities for healing, transformation, and growth for both survivors of crime and those responsible for it. The bill addresses 2 of the chief issues that I hear from survivors, awareness and notice. I encounter so many survivor clients who never knew this was an option that exists for them. They were never informed that it was possible. They were never provided a clear pathway to access it. And some search for years to find this opportunity and are incredibly frustrated by not being informed about it by anyone. Not people in the legal system, not advocates, not other individuals. So I know there are many people missing out on this option who could dramatically benefit from it. This bill also offers an avenue for individuals responsible for harm to indicate their interest in this process and to be allowed to seek it out, which is the other common issue that comes up for us. This can be critical for many survivors to also access this process, to know that the person who hurt them wants to do something to make things right, and they're affirmatively reaching out to do so. There is so much confusion that exists around contact and sentencing provisions that this cuts through. Much of the concern and potential issues raised from the victims' rights organizations with the legislation again, are some of the very things that will need to be carefully examined by the created RJ Council to determine the appropriate program parameters, policies, procedures. And again, I believe those concerns are better suited for crafting and rulemaking process than by legislating them entirely out of consideration. I also think that the concern regarding responsible parties initiating the process could be further addressed through the inclusion of an initial screening process, through the, again, whether that's the specialist or additional contact with the facilitator, for appropriateness before reaching out to any party, again, before reaching out specifically to the victim, which is what we do here in our process. Operating in this post-adjudication space as this bill offers needs to be recognized as quite different from the diversion space when it comes to many of the concerns raised with specific types of cases being eligible or not, including power-based crimes. I do have information and data prepared about my program that I'm happy to share. I've been doing this for quite some time, served hundreds and hundreds of people, stacks of letters from individuals. I can talk about the cases and crimes that we serve, some of the outcome data that we've got, the statistics, things reported to our Department of Corrections, as well as what we've seen from the recidivism space. So I really welcome any questions that the committee may have. Thank you.
Excellent. Thank you very much. We'll now hear from Ms. Chaudhry. Welcome. Welcome back.
Thank you. And I realize I'm probably the last witness before you're able to break for the day and actually get to dinner, so I'll try to make it brief. Thank you, Chair Smith, members of the Senate Judicial Proceedings Committee, for this opportunity to testify in favor. On behalf of CARE, the Council on American Islamic Relations, we are the nation's largest Muslim civil rights and advocacy organization. You have my testimony before you. You've heard a lot of back and forth about why this bill should be passed or should not be passed. My organization's work is to promote tolerance and advance justice, particularly for marginalized and underrepresented communities. And this work is rooted in faith. And that faith teaches that prioritizing non-carceral solutions and restorative practices whenever possible is a must. In the conversation about justice, the ultimate goal of our legal and penal systems should not be to punish offenders for their crimes, but rather to proactively help deter crime itself. Recidivism rates under retributive justice systems such as those that we have in our state, across our country, prove that institutionalization and criminalization do not necessarily serve a rehabilitative purpose. In fact, multiple studies show that rehabilitation reduces recidivism, whereas retribution further exacerbates antisocial tendencies in offenders, and it fosters contempt for authority, which we see in our justice system. Restorative practices focus on healing victims and survivors, offenders, and communities. And while I do agree that absolutely this should be a victim-centered initiative, I do appreciate this bill sponsor's initiative and his willingness to be receptive to feedback on how to make it more victim-centered. I think that those voices do deserve to be centered in that conversation, but we have to start somewhere. And I really appreciate Senator Carter's suggestion of probably creating a pilot program of some sort that could be implemented to help see what works and what doesn't work, and how to make sure that this is an initiative that actually truly helps those community members who need it the most. We believe that restorative practices focused on healing victims, survivors, and offenders, as mentioned. In this form of justice, and especially in the way that this bill is structured, we believe aren't centered around punishment, but rather healing for the victim through the actions of the person convicted of wrongdoing. So this measure aims to bring closure, which helps to promote healing for both parties and for all parties who are involved. So for that reason and the others listed in my testimony, I urge a favorable report. Thank you.
Excellent. Thank you very much for your testimony. And seeing no questions from the committee, thank you very much. That'll conclude the testimony and the hearing for Senate Bill 27. All right, just a quick note. Tomorrow is a pro forma session, so we will not be in committee tomorrow, and you are not required to be on floor tomorrow.